The writ petitions stand dismissed.
I'm so deeply obliged, my lord.
Wait, please, Lord. Lord, one matter. The stay vacation application was filed way back in 2019.
What?
Stay vacation application.
Stay vacation.
It hasn't come yet. So there's the prayer you'll have to make.
So whose fault is it?
My Lord, in between there was a COVID, but that period is all over.
So whose fault is it?
My Lord, very deep.
Everyone's fault.
My Lord, I will not volunteer to say anything.
Right.
It is whose fault. Maybe some misunderstanding somewhere.
Maybe. So what do you want?
My Lord, your Lordship may approve us so that it can
Huh?
come up. So that the matter can come up and we can do the case.
When do you want?
Any day convenient to your Lordship.
You. Huh? When? I don't know. You were it.
God bless you. That is your Lordship.
Lordship, the concern on the other side, I beg to mention item number 29, your Lordship.
Yes.
In this matter, we need to file affidavit. 2 weeks time may be granted, Lord.
Who's for the petitioner?
But they can
You
consult.
just wait because tender has been finalized, no?
Yes, your Lordship.
Then is it infructuous or not?
They're saying this is not infatuous, your Lordship.
They're saying it's not
Not
infructuous.
infatuous.
Did he take part?
Yeah, no, he didn't take part.
He did not take part. Okay. Let him come because.
Yes, your Lordship.
Problem.
My lord, I beg to mention item number 41.
Yes.
I have some difficulty today, my lord, and next week, if it is possible, my
Has it been complied with?
partially
been
complied with,
complied with.
according to
It's
petitioner,
been
partially
complied with.
complied with, my lord.
Complied with
It's
Partially
complied.
complied with, so my lord, I have
There's
some.
no question of punish.
No, my lord, in the next week, my lord, only
What?
only for the payment,
The last time also the same thing.
only for,
Same.
only for the payment.
Huh?
Only for the payment. Lordship may post it by,
Okay, right. On the prayer for adjournment made by Mr. J. Sharma, the matter be listed on Monday, this Monday. Monday.
my lord,
No further adjournment shall be granted.
my lord. Obliged.
My pleasure. My lord, I beg to mention item number 8, my lord. The
And no further adjournment shall be granted as it appears that the order has been complied with.
Item number 8,
Yes,
it may be taken up on next week, my lord. Council is out of station on behalf of the petitioner. Eight.
who is the council?
And Nomita Gogoi, and
Who is for the,
Well, I'm appealing for 1 and 2, madam.
yes, what is the case? Is there any admission?
No, yes, madam.
Then
No,
what remains?
no, actually,
There's
She-
admission because, madam, there's one certificate from the PW department which says, madam, 92 lakhs 70,000 is still due to them. This is there.
He's claiming 87.
Yes, he's claiming additional.
He's claiming 87, so 92, so 5 lakhs you can claim extra, you're not claiming. Where is he?
she went to Nagaon, my lord. Due to some personal.
We'll dispose it of in her absence. What is that? Let it be again scrutinized and decided.
Yes.
That's all.
Actually, I don't have any brief. She instructed me.
No, it's
but-
okay. The thing is that she has claimed 87 lakhs.
Yes,
Now, if
Now
they
they are
say that
admitting
the
more.
92 lakhs is
No, I'm not
admitted.
saying, madam.
I know the
department
PWD
says-
is saying.
yes.
You are representing who? You are not standing on your own, no? You're standing on
Yes,
behalf
madam,
of
I'm
your
appealing
client.
for 1 and 2, madam. Donor, madam.
Huh?
Department of Development and Northeastern Region. I'm appealing for Union of India in this case, madam.
Okay, okay.
Hmm.
It is for and who has to pay the amount?
Donor, madam.
Donor.
Yeah.
You have to pay.
Yes.
And if the PWD has said that they have to, then you verify.
Yes.
And you pay, verify, you wait. Okay. Let us wait.
May I please, Your Lordship? Lordship, I beg to mention item number 20 of daily list.
Yes.
This matter may kindly be taken at 2 p.m. The English Council is having difficulties in the first.
Item 20.
Item 20,
Okay, 2.
deeply obliged.
Yes, madam, what to do?
Then, Lordship, this is a contempt petition, Lordship. Non-compliance of order dated 27/9/2022.
Yes. It's the same order.
Same order, Lordship. Relevant portion in page number 17, Lordship.
What?
Relevant portion
Page number?
17.
Right, heard.
See, Dekha.
See, देखा लगा council for the petition. Who submits that the contractual bills of the petitioner has not been paid. Issue notice returnable in. Despite the orders passed by this court, despite the order passed by this court, issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by a registered post with AD within 3 days. This is the matter after 4 weeks. 1 to 5, same order, huh?
Lordship, repetitions numbers are different, Lordship.
I have not mentioned any writ petition number. No one appears for the petitioner on call. This is the matter after a week.
I'm sorry to mention at this stage, could it be listed on Monday for withdrawal?
Which one? Yes. Right, heard, mister?
SS Islam.
Your name is not here.
Yes, Lordship. Yeah, I'm on behalf of MJ Kadir.
Heard, Mr. SS Islam.
SS.
Appearing on behalf of Mr. MJ Kadir, not counsel for the petitioner. Islam. This petition has been filed due to non-compliance with the order dated 23/8/23, passed in WPC number 4511/2021. Issue notice returnable in 4 weeks. Petitioner takes steps for service of notice upon the respondent by a registered post with TD within 3 days. List the matter after 4 weeks.
One second.
Yes, let us see where is that.
Yes, my lord, PS 19, my lord. The lecture 4.
Completion certificate. You're right.
But only thing, my lord, let me kindly see that the project was completed on 18/10/2020, my lord. So, my lord, he has come after a period of 3 years.
So?
Limitation, my lord, says, Article 18 says, my lord, it has to be within a period of 3 years.
No, this is a contractual thing.
Yes. Only that point.
He will have come earlier to you. We won't go on that.
No, but he had not approached us for that.
That way, huh?
He had not approached us before this.
He has not approached you.
This acknowledgement has been made on 29/1/2022.
These documents are 2022, I'm not on that one, I'm just
So,
on the
3
point,
years,
my lord,
is
that the
there
work
already.
was completed on 18/10/2020.
How does it
I'm on that point.
It is
18,
within
10, maybe.
years.
How does it matter? That
No.
is why that's why they have come in,
But
in a writ-
my lord, Limitation Act says Article 18. says, my lord,
limitation act, this is the it's a writ petition, Mr. Council. Limitation act does not apply here. You take advantage, you use their money, give them who they're due.
my lord.
That's all. Yes, Mr.
SK Group,
Appearing on behalf of,
N Gogoi,
appears on behalf of Mr. N. Gogoi.
Miss N.
Huh?
Miss N Gogoi.
Miss N. Gogoi, learned counsel for the petitioner. Mr.
M. Adhikari,
M. Adhikari appears on behalf of
1 and 2.
Forest 1 and 2. Who appears for the others? This is under the NLCPR scheme or
Yes, sir.
who appears for PWD? Yes. Who appears? PWD. Mr. Dash appears for the respondents number 3, 4, and 5. Next para. Then you take the synopsis, huh? Take the synopsis. Pusta. Why haven't you paid 87 lakhs?
I don't have any instructions on that yet. I have to get instructions.
That will take ages, I think.
My lord,
That will take ages. Correct.
it will not, my lord. Perhaps within
Huh?
2 months, my lord, within 2 months, my lord, I can get the instruction.
Within 2 months, let us, you verify and you pay the amount within 2 months.
Well, then, my lord, it will be on 3 months, my lord. If it is at all payable, my lord, we'll pay.
Pusta, yes. The petitioner. Next para. The petitioner's counsel submits that as the executive engineer, PWD, as the- Roads, Jorhat Division has given us completion certificate stating that rupees 92.70 lakhs is payable to the petitioner from the funds to be given by the respondents number 1 and 2. comma. This court is of the view that the claim of the respondent, the claim of the petitioner should be verified by the respondents once again. And thereafter, the respondents number 1 and 2 should pay the admitted amount to the petition. Full stop. Next para. The completion certificate dated 29/1/22 issued by the respondent number 5 states as follows. Page 19. As the petitioner in this writ petition is claiming rupees 87 lakhs as unpaid contractual bills, comma. The respondent shall verify the claim of the petitioner once again with regard to his unpaid contractual bills within a period of 2 months from the date of receipt of a copy of this order. Full stop. Thereafter, thereafter, the admitted amount to be paid to the petitioner after verification should be paid by the respondents within a further period of 1 month. Full stop. The writ petitions accordingly disposed of. But who will appear for the PWD?
P9.
Is Mr. P Naik the only council or any other? You call one of them, just call one of them. Can you call one of them?
Yes.
Just call one of them. Okay, we'll put their name later on. Yes, where is the admission?
Non-payment of the contractual bills, Lord.
Where is the admission?
Lordship annexure 2, page 20. Is a bill on the top page of the bill only. They have additional deputy commissioner has sanctioned the amount, Lordship. Page 20, annexure 2. This is one of the bills.
No,
Similarly, on all the respective bills, Lordship will find the amount passed for is so and so by the additional deputy commissioner. And then a Lordship may turn to page 36, annexure 3. Is the letter deputy commissioner has issued to the commissioner PNRD. Copy has also been marked to the petitioner herein, where they have been called for release of the additional amount for payment of the outstanding bills, Lordship.
yes,
My lord, specifically not admitted yet, my lord. But for the entire work, they are sought for sum of rupees 2 crore 21 lakhs.
no, how many lakhs? 2.99.
My lord, yes, my lord, yes.
Huh? How much?
2,99,000, Lord.
2 lakhs 99.
Huh.
But for the entire supply, my lord, they sought for, my lord, 2 crore to 21 lakhs from
How
the
much? How much?
2 crore 21 lakhs.
2, 4, 21?
Lord,
My lord,
Lordship, actually,
there are
that
so
is
many
very-
suppliers.
Ah,
for different suppliers, the total amount outstanding is 2 crore something, Lordship.
2 crore something.
Yes. It's not admitted, my lord, specifically against this firm money. So my notice may go, my lord.
Similar matter to lot because there are various departments involved in
Yeah, okay. Okay, right. Correct. Heard, Mr.
8 OT.
8 OD learned counsel for the petitioner who submits that the petitioner has not been paid rupees 2,999,462, huh? Rupees 299,462. In spite of successful completion and supply of pooling materials to the material cell for the Panchayat elections 2018. Issue notice. Returnable in 4 weeks. Mr. Who is for one?
One for PNRT. See. Hello, I am appearing from one.
What is your
One.
name?
G
Mr.
Bokolial.
Huh?
G Bokolial.
Bokolia.
My lord.
Mr. G. Bokolia appears for respondent number
1, 4, 4 and 5.
1, 4 and 5. Who's for 2 and 3?
Lordship, I am appearing for 2 and 6.
What's your name?
N Bora.
Miss N. Bora for 2 and 6. What's your name? R. R. Dubey for respondent number 3. List the matter after 4 weeks to enable the respondents' counsels to obtain instructions.
10 similar trade, Lordship.
Similar, out here the amount is
Amount
575, 339. 575, 339. The parties are same?
Parties are same, Lord.
Same. In the same order. The same, huh? The same.
11.
The petitioners herein, they were a workman in Noapada Spinning Mill. It is under the Assam State Textile Corporation Limited. In the year 2002, both of them went on earned leave.
Went on earned leave.
Went on earned leave
For how long?
But for that period exactly. is
You
not-
don't know,
but,
okay. You went on earned leave. When did you go in earned leave on 2002? Which month?
In the month of February and March.
February and March. Okay, February and
February
March.
and March.
And you don't know for how long you went?
But the instruction, I am appearing as legal aid counsel, all instruction is not here, my lord.
Not here. But this is in appeal.
No, not appeal, it is petition against the award of
So
the.
basically in appeal in a way.
Basically, it's appeal, but. form
But
is
this the
located-
form is by way of a writ petition,
Lord,
that's all.
Lord.
So
Now,
all
what
the
it is-
facts should have been before the labor court.
Mal.
So
Now, when they returned for joining, then the mill was.
when did they return to join?
In the month of September 2002,
September 2002
they went
to join.
to join, but that mill was temporarily closed.
Mill was closed.
And subsequently in the year 2007, my lord, this mill was permanently closed.
2007,
2007,
mill was permanently closed.
permanently closed.
And what did you do between 2002 and 7? Did you try to go and join?
No.
Did you go to High Court or did you go to
No.
any court? No.
Yes, my lord, industrial dispute was raised. Subsequently, what happened, my lord, in the year 2007, with effect from 28/6/2007, mill was permanently closed.
Yes.
28/6/2007, and except these two workers and one other, except these three workers, others were provided with the VRS benefit as well as the closure compensation till the date of permanent closure. It is 28/6/2007.
Then
But these two workers, along with another, they were not provided. They were provided till the date when they went on early.
they were
and-
provided what?
My lord,
What were they provided till the day of the availing early leave? What were they provided?
they were provided with the closure benefit.
Closure.
Closure benefit. And they accepted also. That is also one hurdle, my lord.
So the closure means till closure
year
till which
date of-
date? Which date?
February and March 2002.
February, March 2002.
Petition number 2 till February 2002 and petition number 1 till March 2002.
Closure compensation.
Closure compensation.
Then
But they were not provided with the closure compensation till the date
till
on which
2007.
2007, on which date actually the mill was permanently closed. They raised industrial dispute that was referred to the London Labour Court.
When did they raise the industrial dispute?
They raised the industrial dispute in the year 2007, my lord,
2007.
2007. But
Let us see what is
conciliation was ended with failure and it was not referred for adjudication. They came before this honorable court with a
reference
petition.
cases of 2022. Mr. Council,
My lord,
what are you talking about?
they preferred a petition in the year 2014. Lordship will get it at page 11, the order. As the dispute was not referred for adjudication.
Page 14,
Page 11, my lord.
page 11,
Page 11.
page 11.
Page 11 is the order.
Who is this Bipin Mahanta?
He is one of the workmen, my lord. Bipin Mahanta and Biren Boysa. These are two workmen before your lordship.
That's Bipin Chandra. Out here, Bipin Mahanta, out here, Bipin Chandra.
And the same person, my lord, they Bipin Chandra Mahanta and Biren Boysa, these two workmen,
Hmm.
they preferred this writ petition as their dispute was not referred after failure of the conciliation.
Huh.
And lordship passed this order, lordship will get at page 13, the relevant portion. Lordship directed to refer the dispute to the Labour Court for adjudication. Page 13, the last paragraph, it is about it.
Okay, so you went to,
Bloody-
so this writ petition
Yes, my lord, in 2014,
disposed of on
it was disposed of on
21/4/16.
21/4/16.
Then
Then my lord, matter was referred to the London Labour Court. Page 15, lordship will get that notice from the London Labour Court.
Yeah.
Reference 4 of 2016 was registered.
yes,
Page 15.
yes.
After that, my lord, the reference was with the terms of reference, lordship will get at page 25. Page 25, the terms of reference, whether the management of measures Assam State Textile Corporation is justified in non-payment of pending monthly salary.
Why is this reference case different?
My lord.
This is 4 of 22.
No, 4 of,
The one that you were talking about is 4 of 16.
my lord, 4 of 16. I inquired it, but
Page 15 shows
yes,
that reference case is 4
yes,
16.
4 of 16, the
And
WS,
page 25 deals
WS
with
is
4
also
of
4 of
22.
16, my lord.
Huh?
WS is also 4 of 16.
I don't
That
know.
page 16.
You please, how come this is a different number?
That I uh, but when I inquired the same case, the reference was decided against the workman. But reference,
How come two reference numbers?
the Lordship may fix it on next Wednesday. I'll ask the reference number is different. Lord.
Reference number is different.
I'll take instruction from the High Court Legal Services Committee regarding this, Lord. Maybe on Wednesday.
Okay, right. Right, Mr.
PM, hello.
K.M. Halloy, learned counsel for the
I'm appearing as legal aid.
petitioner who prays for setting aside the impugned award dated 25/5/23 passed by the learned Labour Court, Guwahati, in reference case number 4 of 2016. Full stop. However, Annexure 5 of the writ petition shows that the impugned judgment and award dated 25/5/2023 pertains to reference case number 4 of 2022 and not reference case number 4 of 2016. The petitioner's counsel shall clarify the ambiguity, the above ambiguity. Full stop. The above being said, comma, in the case of the petitioner, next para, the above being said, the case of the petitioner is that the petitioner number 1 and 2, 1 and 2 had taken earned leave in February and March 2002. And on rejoin and on trying to rejoin their post in September 2002, they learned that the Noapara spinning mill was temporarily closed. Full stop. Thereafter, the mill was permanently closed with effect from 28/6/2007. Full stop. The grievance of the petitioners is that the petitioners were given closure compensation for the mill only till February and March 2002, while the other workers of the mill had been given closure compensation till 28/6/2007, besides VRS. Correct?
Right.
Full stop. The next para, the petitioners thereafter approached this court by way of WPC 6813 of 2014, which was disposed of by an order dated 21/4/2016. But wherein a direction was issued to the effect that the dispute raised by the petitioners should be decided, should be referred to the labor court under section 10 of the Industrial Disputes Act 1947. So, the judgment and award dated 25/5/2023 passed in reference case number 4 of 2022 shows that the case of the petitioners have been dismissed. Correct? Have been rejected.
Rejected. It is
Have been
the
rejected.
award reference has been decided against the workmen.
Have been rejected. Against the petitioners hearing. Full stop. However, as stated earlier, the prayer in the writ petition is for setting aside the award passed in a reference case number 4 of 2016 and not against 4 of 22. List the matter when?
Wednesday,
Wednesday.
To make seven, kindly for a moment, Lordship, it should be 22, Lordship, but kindly, petitioner has shown incorrect. Lordship, page 24, Lordship. Page 24, reference was made on Lordship, September 2020, Lordship. Page 24, Lordship, may kindly pay, Lordship.
No, actually, what I can understand, no, you see, what has happened is, I think, earlier he made a reference, in 16.
Lordship.
Since nothing was being done, they came to the court. And this court said, no, it should be decided by the labor court. And accordingly directed that the reference should be sent to the labor court.
He has,
So I think they gave a different number there.
he has approached the court of 14, Lordship. 2014, Lordship.
Yeah.
they approached it in
Acha,
14.
14, they have
14,
approached.
order is of 2016.
Yes, because Lordship, the page 19 also says that Lordship, the written statement filed by the Lordship, concerned Lordship, company Lordship, it was also Lordship, reference 422, Lordship, page 19, Lordship.
So basically, they just have to change this. Sir.
Lordship.
Maybe there may be some,
Even Lordship, order also reflect the reference.
So
notification.
basically, I think
It should be 22, Lordship.
22 instead of 16.
Maybe.
So,
Lordship.
basically.
no, it has to be 20, it has to be
It has to
22.
be 22.
It has to be 20, it cannot be any other.
Otherwise,
Problem is
even
you
Lordship,
do not get
orders
all
also
the
reflect.
documents and instructions filled as legal aid counsel, that is the problem.
Orders also reflected reference was made on 2020, Lordship. If 20, the Lordship, it cannot be 16,
What
Lordship.
document is provided
And
to us.
otherwise also page 19, Lordship, it says that reference 4 of 22, Lordship.
Workman's name are same,
Lordship.
management is also same.
Management
But,
filed the written
maybe-
statement, Lordship, in reference case number 4 of 22, Lordship.
In workman's written statement, that is the written as
But
60.
written statement, everything is there.
Lordship,
This order, page 15 also, you just look at page 15.
Lordship. Page
Page-
15, probably Lordship, another case was there, as because Lordship, it is
Maybe there are two cases
two
filed.
cases,
Maybe, my lord.
two cases. So
Maybe,
Lordship
but
may-
they have provided,
Page, if Lordship peruse the page 24, then Lordship, it will be clear, Lordship, page 24.
Yes.
there may
Page
be two
24
cases and they
lordship,
have provided
The
the documents.
reference case arose out of the notification norm so and so September 2020, Lordship.
Have you filed two cases?
Lordship,
I
probably,
don't know, my lord, I have no such instruction because
You find out. Gustavo.
I have the instruction from High Court Legal Services Committee because I am appearing as legal aid counsel in this. case.
The petitioner shall also obtain instructions as to whether the petitioners,
Lordship.
the petitioner's counsel shall also obtain instructions as to whether the petitioners have filed two reference cases and the final decision with regard to reference case number 4 of 2016
Lordship.
should also be produced before this court.
Then, my lord, maybe after,
Why don't you also find out?
Lordship, I
It
also,
may be that 4 of 16 has been dismissed again, they went, we do not know.
Lordship.
On 7th, I will try, my lord. I will take instruction from High Court Legal Services Committee. Much.
This comes 7.
Very pleasure, Lordship. It is regarding settlement matter. Why not? Tender was circulated on 10/4/2023.
10/4/23.
Yes, madam. For the financial year 2023, 2024, that is 1/7/2023 to 36/2024. The law says, my lord, after completing the entire settlement process, that market required to be settled by the Panchayat authority in every Panchayat financial year for regular settlement process to the valid highest bid value. Here, what the my lord. The competitive statement was prepared on 6/6/2023. Wherein, my lord, seven, in this case, my lord, 13.
You're the highest. Are you the highest, the lowest? Where are
No,
you?
no, no, of the highest. They are running the market temporarily by engaging their own FS employee without making regular settlement. And then I've challenged them of page, my lord, 56, 112. It initially,
Page 56.
sorry,
55, you mean?
yes, 55, my lord. 112 day back, passed on again orders allowing the two FS employee to run the market and collect the taxes until further order, my lord.
Where is the law which says that has to be settled?
My lord, my
I-
lord, my lord, section 105 policy of the Panchayat Act, rule 47, 10 of the Assam Panchayat Financial.
105 of the Panchayat Act.
105 Panchayat Act and rule 47, 10 of the Assam Panchayat and Financial Rule 2002.
40, yes, give me. Panchayat Act and
You can see page 106, section 105 of the Panchayat Act.
105 of the Panchayat Act.
Yes, ma'am. Followed that all hearts within the territorial jurisdiction of the Anchalik Panchayat shall be settled in a manner prescribed for a period coinciding with and not exceeding one Panchayat financial year by inviting tender at the office of the Anchalik Panchayat by its president, ma'am.
And then 47, 10 of the,
Yeah, for Assam Panchayat and Financial Rules 2002. You will also find page 264. 265. Assam Panchayat and Financial Rule 2002.
this book is 47.
4710, my lord.
Assam Panchayat Financial Rules,
Yes,
2002.
2002. 4710. Tender of the highest bidder shall be accepted.
Give me the sticker. Yes.
Yes, my lord. Ordered by prayer before you also, my lord, let this matter be disposed of. With a direction, with a part of Jilla Parishad, Jorong Jilla Parishad, to settle them, to make arrangement, to settle permanently, to make regular settlement. And till then, she is presently they are running, department running the market. Till then, my lord, let this MP order be continued, my lord. It is my humble word. Let it dispose of it, it's a law. Law says,
Yes, why, let them, yes,
Lordship, kindly see, section 105 of the Assam Panchayat Act 1994,
yes.
subsection 5. Failure to settle any hard for want of adequate value, the Anchalik Panchayat, as may be decided by the Jilla Parishad, may be entrusted with the direct management of such hut by the Anchalik Panchayat.
My lord, what?
105 of the Act.
105 subsection 5.
Yeah. Yes. So where is the decision taken by you? That there is no one has given, you must have given a rate,
Yeah, the rate given, my lord.
then
Rate given, it is rate given or starting by the government.
where
rate.
is the rate? given?
Can you see? Can you see on page 20, page 21, my lord. Page 21. Page 21.
Yes.
Page 21, my lord, Tangni open market, government, my lord, government rate, 5,90,422.
And what is this 59043? Security money, okay.
Yes, for security money, yes.
And what was your bid?
No, I'm not paying that, settle the market in my favor. My bid
I
is,
just
my
want,
lord,
I want to know,
my bid is, my lord, can you see?
He's
Uh,
ninth bidder.
9 bidder, my lord.
9 figures.
Ninth
Nine.
bidder.
8,07,000,
Ninth.
8,07,000, my lord. I'm not
So-
saying, my lord, whoever come out.
So what is this? Adequate value is given. Is 8 lakhs beyond your 5.9 lakh.
But Lordship, according to comparative statement, he petitioner is the ninth highest bidder. But
Where is the comparative statement?
Yours is filed for page 35.
35.
Yes,
Ah.
my lord, there I'm one by one, I'm saying, my lord. So far as the tender number 1 is concerned, he has withdrawn. There I saw, my lord, letter issued by the Anchalik Panchayat,
Withdrawn.
withdrawn.
Ah.
So far as the 2 is concerned, my lord, for a short period of time, my lord,
Number 2, what about number 2?
he surrendered, my lord,
Surrender.
surrendered.
What do you mean surrender?
Surrendered, my lord, what happened, my lord, initially for a time being, permanent settlement was given in his favor. So after running the market, what happened, my lord? He made an application saying
He
that
withdrew.
I withdraw on medical ground. The resolution in Diaz, my lord, is
So he was allowed to withdraw.
withdraw, my lord.
Then
So far as the 3 is concerned, my lord. 3, I don't have any instruction, my lord. 4, so far as the 4 is concerned, withdrawn. 5 withdrawn,
or withdrawn.
4 withdrawn, 5 withdrawn, my lord. 6 withdrawn. 8 withdrawn,
8 not withdrawn.
8 withdrawn. Hanif Ali.
Your number?
9. Nasir Ali.
9.
Lordship,
I'm not saying, my lord, settle the market in my favor. Whoever comes out as a higher valid bid, this better be settled. But temporary settlement is not permissible under the law.
Lordship, 4 were surrendered and 1 is unable to run the market due to sickness. But after that, petitioner is the third highest bidder.
So why aren't you giving him? He has quoted above that rate. 5 point. Your rate is 59.
Five-
Reserve rate is 59. 5.9.
Yeah.
So his rate is 8.7.
Lordship, in this test notice, Mego.
Notice, my lord, time will going to be completed on 36.
No,
my lord.
notice. You, what is there? If this is the facts of the case, you're not denying this aspect. We'll fix it next week. You bring the record. We'll dispose it of on that day.
Lordship.
We'll one chance for her to obtain instruction. Because this is the first time it has come. Heard, Mr.
After all.
FKR Ahmed, learned counsel for the petitioner, who submits that in terms of the tender dated
Tender notice dated 10/4/2023.
10/4/23
2023.
for settlement of the Tangni open market for the period from 1/7/23 to 30/06/2024. The petitioner amongst the petitioner and 13 other tenderers took part in the selection process. The reserve price for the market was fixed by the respondents at 5 90,422. The petitioner's counsel submits that the petitioner who was
Nine,
ninth
nine position.
was, who
The place, nine position.
was in serial number 9
In the competitive statement.
in the comparative statement, as he had given his bid amount of rupees
8,07,000.
8,07,000 was not considered, was not given settlement of the market despite a number of the other bidders who had given higher bids withdrawing from the same. He submits that the respondents have been running the market by the impugned office order dated 1/12/2020 in violation of section 105 of the Assam Panchayat Act 1994 and Rule 47(10) of the Assam Panchayat
And financial rule.
Financial Rules 2002. Gustav. Miss
Amber.
N. Bora, learned counsel appearing for the
Respondent number 1, 2, 3, 4.
1, 2, 3, and
3 and
4
4.
shall obtain instructions and bring the official records if necessary on the next date. Comma, that is which date?
Next week, my lord. Next week, my lord.
On 8, on 8.
Right.
8 to Augusta. On the set date, an attempt will be made to dispose of the case.
Right.
The counsel for the respondent shall obtain definite instructions as to why the market has not been settled with any of the bidders, including the petitioner here. We'll have to, I think you'll have to settle it.
Not
You cannot run it like that.
Right, ma'am.
Please, my lord, the petitioner has been marked as the voter in the voter list of 1997 onwards. And before that, in the year of 1985 and 89, he was regular voter. And he has casted his vote. But without informing anything and without any notice, my thought doubt he has been put against his name in the voter list of 97 and onwards.
I am praying for Election Commission of India, Your Lordship.
Huh?
I am praying for Election Commission of India, Your Lordship. The petitioner here, he has been grievances, he is marked as D, Your Lordship. He is relying on the judgment and his annex is Annexure 12, Your Lordship, page 47 of this honorable court. He wants the similar plea that this petition should be also disposed the similar line. We have no objection to that, Your Lordship.
Yes,
Yes, I'm appearing for the from department, my lord.
yes.
For respondent number.
So any objection to his prayer?
Who and no objection, but it may be dismissed.
Okay, right. Heard, Mr.
Yanis Talukdar.
Amy Jury.
Talukdar.
Jimmy Talukdar, counsel for the petitioner who submits that the pet that there is a marking D, inverted comma D, against the petitioner's name in the voter list of 1997
7 onwards.
onwards. Comma, even though the said mark D was not present in the earlier voter list
Yes.
prior to 1997. So stop. He submits that no opportunity of hearing was provided to the petitioner prior to the marking D, prior to giving the marking D against his name in the voter list. Full stop. The petitioner's counsel submits that in similar matters, comma, that is WPC 7087/2023, which was disposed of by order dated 11/12/2023, comma, this court had directed
SP border, my lord.
had directed the superintendent of police, border, to examine and verify the case of the petitioner.
My lord, in fact, in this case, my lord, already we verified and found that there is no such case pending against the petitioner in the office of the superintendent of police as well as my lord in the foreigners.
Then what is to be done?
My lord, they may be directed to refer his case to the concerned foreigners tribunal for adjudication.
And if on verification it was found that the case of the petitioner was to be referred to the concerned foreigners tribunal, the same should be referred. Full stop. The next paragraph, the petitions council further submits that in the present case, the SP border has already made a verification. Where is that?
42.
Huh?
Case number 42, my lord.
Already made a verification report after conducting an inquiry and stated that as per records available in the office of the SP border, the voter case, the voter case is not found against the petitioner. He accordingly submits that the SP border should be directed to refer the case to the concerned foreigners tribunal.
Yes, my lord.
Foreigners tribunal to decide the issue as to whether the inclusion of D against the name of the petitioner should be removed. Full stop. Next paragraph. The counsels for Mr.
AI Ali,
A.I. Ali appearing for respondent
3, 4, 6 and 8.
3, 4, 6 and 8 and Mr.
J. Payak, my lord.
J. Payam for respondent number
Respondent number 2 and 7, my
2 and 7 and Mr.
G. Kulian for 5.
For respondent number submit that they do not have any objection to the prayer made by the petitions counsel. Full stop. Next paragraph. In a similar case pertaining to the inclusion of the name of a person in the electoral roll in the category of D voters since the year 1997. This court, while order dated 23/8/22 passed in WPC 8262 of 2018. Wait. No, not 82, sorry. In.
708.
708.
Page,
Case number
Case
47.
47.
order dated 11/12/23. 11/12/23 passed in WPC 7087 of 23 and directed the superintendent of police border to examine and verify the case of the petitioner therein. And if on such verification, it was found that the case of the petitioner was yet to be referred to the concerned foreigners tribunal, the same was to be referred to the concerned tribunal to examine the claim of the petitioner. So, next paragraph. In the present case, the superintendent of police has apparently written memo number GLP/B/F_T/2019/1939 dated 19/8/2019 to the election officer Golpark. Stating as follows, page 42. Whether this is correct?
Yes, my lord.
No. First stop. In view of the above, comma, the SP Boda is directed to refer the case of the petitioner to the which tribunal?
My lord, concerned for
To the concerned foreigners tribunal to examine the claim of the petitioner and verify the veracity. After verifying the veracity of the letter dated 19/8/2008 issued by the Superintendent of Police Border. So stop. Upon such reference being made before the concerned foreigners tribunal, comma, the petitioner may participate in such proceeding and establish his claim before the concerned foreigners tribunal. The writ petition is accordingly disposed of.
time period may be 6 minutes to Jakarta can spend.
Time period it will be.
My lord, 1 month or 2 months has.
No time period.
My lord, in last quarter also there is.
No, is there?
Yes, my lord. This matter.
They've got so much matters, we cannot put.
No, my lord, if not met till now,
Okay,
we met with.
okay.
uh,
That's right, the reference he made. The reference, if not made till now, comma, be made by the superintendent of police border within a period of 2 months from the date of receipt of a copy of this order.
Similar to your non-payment of contractual fee. Nalwari district panchayat election. Item 9-10. Similar to 9-10 also.
Okay. The parties are same also,
Same party.
same. Okay, you see, you take that order passed by, I think, Kalpana in 8, 9 and 10, parties are same, names of the lawyers are same, only the figures will be different. Figure in 14 will be 15,68,017. Can you give me that? Give me 15, 16. Exactly similar, huh? Kalpana. Then in 15, the figure will be 36,54,838 and 16. 16, it will be 4,61,995.
Earlier was item 9 and 10 also.
9 and 10, not 8, 9, 10, 9 and 10.
Much of it. Please go. My lord, after issuance of tender process, my lord, I participated in the tender bid. Technically, I found clear. Then thereafter in price bid, I became the L1. And when kindly see at page 73, annex 3.
Yes,
It is informed you that the bid number so and so has been opened and updated summary by duly constituted committee. Your bid has been admitted by the committee, and further information you are asked to get touch with the tender inviting authority. Next page, kindly 74, I became L1.
yeah,
Now thereafter, kindly see page 82. Page
Yes.
82.
yes,
Please refer to your letter number so and so with letter number so and so regarding the justification and workability of the quoted rate for the subject work, which is below 30.51, below the estimate has been submitted. On going through the reply submitted by you, it is observed that instead of submitting a detailed analysis and justification, only narrative has been submitted besides readiness and for submission of additional TBG.
As such, in order to ensure execution of the work and show your earnestness, you are hereby requested to submit your consent to submit an additional performance security deposit of 20% quoted amount. So thereafter, my lord, I submitted one reply on 19. On 19, my lord, I read for, I have not refused to give the additional PBG, but I offered 10%, my lord.
8%.
8% plus 2%, 10%. I offered 10%.
Performance guarantee is 2%. Then,
Then additional 8% I offered,
okay, so it
Additional
become,
of-
so it will become 10%.
10%.
Ah,
So, but when I have offered 10%, they remain mum. They have not given any reply to me. Immediately thereafter, I given page, my lord, kindly see. At additional PVG letter I have given on 30/12/2023, page 94.
but where is your letter offering 8%?
This is next offer letter 8% at page 80, page 84.
Lord, he is right. We admit that.
Page
he's right.
84.
Page
84.
No, you see, I want to know. Have you written any letter? You see, you have written a letter,
Kindly see
15, where is your letter 15/12/2023?
15/12. 16/12, my lord.
15/12, come to page
Oh,
82.
Before that, yes,
Yes.
yes,
That will
15/12.
clear up, that will clear up the issue.
yes. Page 70. Page 78. From page 79. In reference to your letter reference regarding justification and workability of my quoted rate for above cited work, we would like to inform you that we are NCR-based infrastructure company. Our presence in so-and-so executing several works, even Northeast 2. Recently, we have successfully executed construction of drain in Agartala, Tripura, which was
So
completed.
you come to the second, page 80,
Page 18. Yes.
last paragraph.
Yes, we are fully confident and ready to execute the work on our quoted rates. Further, we are also ready to submit additional performance security if any asked to raise by the department. Then, my lord,
So any amount that they ask, you're ready to give.
yes, then thereafter, my lord, when they have not communicated about the 10%, 8+2, then we have wrote a letter on 19.
Where have
Page
this,
94.
where have you said 8%?
Page 84.
So you see,
After we demanded 20, then you offered 8.
yes, that's what,
Negotiation.
Then,
that's what I'm saying.
then again.
You see,
then again-
actually earlier, he was ready to give any amount,
Yes,
but when you ask for 20%, now he has come down.
yes.
That's
Now,
negotiation.
page 94, miles, kindly see. Page 94. When they have not accepted that 10%, we are ready to give the amount which they have demanded, my lord.
If that be so, my lord, I'll accept
Page
it right now.
94.
We are interested in work. If he accepts to give 20% right now,
Yes,
I'll admit.
yes. This
But that is the whole difficulty is
This
they
is
were,
the
they
letter.
were negotiating. Let me explain. They started negotiation. The post-tender negotiation, my lord, as per the CBC guideline is prohibited. So the moment he started negotiating, 8% we will give, not 20%, we said nothing doing, full stop. So that's it, we took a decision of going for re-tendering. Now, my lord, this is a mega project monitored by the Prime Minister's office. Chinese are breathing down our neck. They are constructing a huge dam in Sangpo River. We want to start the work as soon as possible. And my lord, it's a very, very important work involving public interest because it's construction of embankment in the Subansiri River.
Over, construction over?
My lord, it's Swansea Dam
because it's the construction of embankment,
Embankment.
flood control measure. This is the period.
On the side.
Yes, my lord, very, very important. If he agrees for 20%,
For the lower Subansiri or? for
no
upper?
Subansiri, that huge dam, my lord, that will be the biggest dam in Asia, in fact, once it is constructed.
Page 94.
No, the
can-
lower Subansiri already is commissioned.
My lord, it is not commissioned. as
No,
yet.
not,
not-
it is
not yet.
embankment.
We are expecting that by 24, we will have 2 units operational,
But that is for 2000 megawatt, no?
2000 megawatt.
2000.
But I think there is another 4000 megawatt
That
somewhere
is
on the country.
Dibang, my lord.
Wow.
That is Dibang, that's huge. That will be the biggest, my lord, once that comes up. It will overshadow even Subansiri.
That is.
So, my lord, we want work to begin as soon as possible. If he agrees for
So
20%,
he said 20% he's agreeable.
if he's agreeable now, yes, my lord, he
Page
said
94,
that.
Page
He-
94.
With 94.
Yes. Even bank also I have wrote letter for performance guarantee. Page 94. Accepted additional PBG 20 plus 2 of my quoted amount as request so and so by letter dated so and so through email.
This is of 30 December
Yes,
2023.
30 December.
So he's
Then-
accept,
Yes,
but then I think we need a formal document letter from your side.
My lord, if it comes from your lordship, I'll persuade, I'll tell them. Let it come from your lordship. That since he agrees, he accepts our initial proposal of 20%.
No, this is his letter.
My lord, that was subsequent. By the time decision was already taken.
That, okay.
By the time decision was already taken. That is why.
no, this
So, my lord, in fact, my lord, I called them up. This morning, I told them, we are interested in work. If he agrees our proposal, that yes, on 20% performance security deposit he will make, we will allow him, we should allow him to do the work. Because ultimately it is the work which is very important. And that will safeguard and protect our interest. If 20% performance security deposit he makes. Because, you know, 30% is abnormally low,
Very low.
very low. So we can't take the risk.
Whether he can implement.
That is why we have serious
my lord,
doubts. And but
there are-
to protect
there
our interest, that is necessary.
similar nature of project has been done, but page 26 instances.
So for
are-
others-
My lord, in those
In-
projects
in
also,
upper-
we had demanded additional performance security deposit, and they had done it. They did not negotiate like him. We said 20%, he said 8%. We said nothing to it. So let it come from your lordship that we should allow him to do on 20%, on deposit of 20% additional security.
Okay,
Fine, my lord.
that's all. Solved.
Yes,
Sort out.
better. Finally, it is work, not because we don't want cost overruns.
How much is the cost, the project cost? I mean, this site.
Estimated cost is 5
5
crore,
5
3 lakh something.
And
this
the,
was-
and the Subansiri 20 crores, 20,000 crores.
That is huge. Vinod. That's a mega dam. That's huge. Vinod, actually 1 kilometer stretch is there. In fact, around 10, 20, whatever. So 1 kilometer is 30, 33 kilometer total stretch. So 1 kilometer each we have divided. For that, we are issuing NITs. This is 1 kilometer stretch.
I think this is the second opportunity for me to pass order with regard to this dam. I had passed it in Arunachal,
In.
Oh, yes.
in
by
DB
DB matter.
DB
By
matter,
DB
Yes,
matter.
yes.
regarding compensation.
Yes.
I think that has been settled already.
Along with justice.
No, that has not been settled,
Medi,
Vinod.
that is Medi.
No,
Vinod,
that is.
But I appeared in that case, so I'm aware.
What Thakur.
No, we
Stop.
this is
I
Medi.
appeared in that case. I know, my lord is right. My lord, that part is settled,
Ah.
but they are not satisfied even with that.
Okay,
Now they are demanding that original 3,000 crores.
okay,
So those cases are pending.
okay,
That part of your lordship, we complied with that.
okay, that's
After
it.
we complied with the order, now they came with another petition demanding more than 3,000 crores under 2013 Act, which your lordship did not accept. That judgment of your lordship was affirmed by the Supreme Court.
Okay,
So thereafter now additional writ for further compensation. So it's never ending. It goes on and on. Possibly those cases may come before your lordship now,
what to
very
do?
soon.
What to do? The lure of money.
But not that's it. The lure is always there.
Anyway, whatever.
So-
Heard, Mr.
SK.
SK Ghosh, Learned Counsel for the petitioner, and Mr. PK Tiwari, Learned Senior Counsel for the
For NHPC, respondent
For
got
the
all
NCT
345,
For all the respondents.
except Union of India, which is
Acha, wait,
6,
for the respondents number 1 to 5,
1 to 5.
1 to 5. You're the caveator also? No,
Yes, there was a caveat.
there's a caveat.
There was a caveat.
Is there a caveat? You just say for 1 to 5 and the slash caveator. Good stuff. I think the synopsis is good enough. Huh? The petitioner's case.
My lord, the best thing would be if my lord looks into the last lecture, recommendation of TEC, entire narrative is given there. Page
No, I
page
don't,
84,
no, page 84.
entire narrative is there, all dates. No, I'm just,
No,
no, it's,
No.
my lord, I'm sorry.
No,
It's the
that's right. The petitioner's
page
case.
86, 87,
No,
88.
we'll just take the synopsis. I think
Very well.
So everything is here. The petitioner's case. Is in the petitioner's case in brief is that, then you take it down, huh? Take this down. Two, then three, four. That's synopsis. Next para. Mr. P.K. Tiwari, the learned senior counsel appearing for the respondents number 1 to 5, submits that as the petitioner is willing to deposit the additional performance guarantee of 20%. Of the quoted amount besides the existing 2% performance guarantee provided in the tender notice, the respondents accept the 22% performance guarantee, the security deposit to be submitted by the petitioner.
Lord, I'm sorry, only one thing, my lord. If my lord gives a reference of NHPC letter at page 82, that would be better.
No, I said,
Where will be asked for
Okay.
it? The letter of NHPC at page 82. When we ask them that, yes, if you are requested to. submit a reference.
I will reflect all that in my stuff. Okay. What have I said? To be submitted by the petitioner and they will withdraw the recommendation for cancelling the NIT dated 13/9/2023. Stop. Correct. Next. I have heard the learned counsels for the parties. On perusing the letter number NH/S, no, not NH, sorry. Perusing the letter number,
Page 82.
no. Number TKJ/NHPC/2023/QL-RL/01 dated 15/12/2023. Issued by the petitioner. It is seen that the petitioner are ready to submit additional performance security if asked or raised by the NHPC Limited. Good stuff. The letter dated, the letter number NH/SLP/CONT/2023-C-35/2023/769 dated 16/12/23 issued by the Group Senior Manager bracket PNC NHPC Limited is to the effect that in order to ensure execution of the work and to show their earnestness in doing the contract work, the petitioners were requested to submit their consent their consent for submission of an additional performance security deposit of 20% of the quoted amount, in addition to the existing 2% performance bank guarantee as per tender condition. As the petitioner's counsel. No, next, where is that other letter? Page 94, 92.
Regarding
That 20%, we are
page,
accepting.
yes, the page 94.
Next para. The letter dated, the letter number TKJ/NHPC/2023/QL-RL/04 dated 30/12/2023 issued by the petitioner to the Group Senior Manager bracket PNC Division, NHPC Limited. Is to the following effect. Page 94 from here to here. Okay, next para. As the petitioners have agreed to submit additional performance security deposit of 20% of the quoted amount in addition to the existing 2% performance bank guarantee as per the tender condition, as per the existing tender condition, which amounts to 22% performance bank guarantee, which is accepted by the respondents number 1 to 5, the respondents shall, in consequence, the respondent shall accordingly withdraw the recommendation made by the tender evaluation committee, bracket respondent number 5, to cancel the NIT dated 13/9/2023 and award the work to the petitioner, who is the lowest bidder. The writ petition is accordingly disposed of.
Yes, ma'am. Better be not, nobody knows that the next again, if we go for NIT, more writ petitions. Over there also, there will be dispute. So better the work begins. Let us hope he does it.
Let us hope there is, he can do the work.
He can do it within that amount
The
without
30
any arbitration.
minus 30 is quite high.
Why? That's why we are worried.
Only men and machinery is to be given,
Let us see.
nothing else.
We'll find out.
But then you
They
see,
are supplying.
all this thing is not like that. Then you will not work, finish it in time. You will have a cost escalation,
Yes.
cost index, everything will go up. What do you think? Subansari Dam, it was supposed to be commissioned how many years ago?
That's
More than 20 years have passed.
that's it.
More than 20 years have passed. It was supposed to have been commissioned by, I think, maybe 5,000 crores. Now must be above 20,000 crores.
20,000, one beyond 20,000.
Uh,
That is why we can't compete with China. Their system is different. Over there are no litigations.
Who are these persons behind this company?
This company.
Who
No,
are the persons behind the? Find out. I don't know. I don't know. We don't know whether they are really interested in doing the work. We don't know.
interested.
We hope it does because it's for the benefit of the entire nation.
That's it.
Yeah.
And our Arunachal is going to make huge money out of it.
No, sir.
12% of the thing will be free, I think, of the output.
No, sir.
Lordship may kindly peruse.
Yes. That's
Lordship may kindly peruse order dated 8th of January.
8th of January.
Yes, my lord.
8th of January. 8th of January? Yes. What is this matter?
No,
about?
no, this matter, I filed it for a very limited purpose, my lord. The GMC authorities are refusing to renew my trade license on the pretext that an appeal is pending before the mayor in council, my lord.
What
Yes,
appeal?
my lord. The facts go as such, my lord. My father
Yes.
was carrying on a business of engine repairing works, and since 1996,
Engine repairing work.
yes, car engine repairing work, different.
He's got a workshop.
Yes, he's got a workshop. So he was issued a trade license in 1996. So since 1996, it was being renewed. Business was being carried out till 2016 without any hurdle from any corner, my lord. In 2016, what happened? Since my father was also getting aged, he executed a partnership deed with me and requested the GMC authorities to renew the trade license, also including the name. Otherwise, earlier his name was shown as the proprietor of the firm.
Now it should be in the name
Yes,
of the
yes,
partnership.
that was a simple request. The GMC authorities then gave an information that somebody has lodged the complaint against renewal of the trade license.
GMC.
Yes. I then requested the GMC authorities to give me a copy of the complaint. They provided me. And thereafter, I gave my written objection against the complaint. So there was a hearing.
What is the complaint about?
Complaint was that one person, who was also a relative, he is a nephew of my father, he was claiming that his father was a partner in the firm. So it had always been running as a proprietorship firm in the name of my father.
But though it was a partnership.
No, it was not a partnership.
Anyway, then he's claiming that it was a partnership.
Yes, he's claiming that.
So what does he want? If it's
So he wanted that his name should come
as a partner.
as a partner.
Okay, with your father.
With
Your father and you also,
Yes, ma'am.
including you.
No, at that he did not like
Know that you
want
were a
that-
partnership.
want that I should be included.
Okay.
Yes.
But did he know that you had a partnership? No.
No, he did not know it at that point of time. He just made a complaint. So I made my written objection against the complaint. There was a hearing, and after that, after considering all aspects, the GMC commissioner, he renewed the trade license in my favor for the year 2017-18.
2017-18 in the name of the partnership or in the name of
In the
proprietorship?
name of as it was earlier, in the name of my father. So thereafter, my lord, after that order, he appealed against the order before the mayor in council.
He appealed that
Yes,
other fellow.
that-
Is he a party here?
No, I'm not inviting your lordship to express
That issue.
anything on merits as regards the matter. Thereafter, what happened? I received a notice. My father received a notice. He attended, and without hearing anything from him, without hearing his version, the mayor in council disposed of the appeal against my father, and directing the authorities to include the name of that person as a partner. So thereupon, I came with a writ petition before this honorable court. This honorable court, after hearing the parties, was pleased to dispose of the writ petition, setting aside that order on the ground that there was violation of the principles of natural justice. Thereafter, again, directed that the appeals, I should be given notice, I should be heard. So again, another date was fixed.
copies of the appeal, whatever was given to me. I submitted my objection. That was sometime in 2018, my lord. That was on July 2018. I submitted my written objection against the appeal. Thereafter, no dates have been fixed in the appeal, no hearing whatsoever. Appeal is lying stagnant all these years. And my lord, my trade license, my father's trade license was not renewed on that pretext. This was going, my father filed representations after representations that renew my trade license. There was no action taken. In the meantime, he passed away. COVID period also went. Again, I filed a representation. renew
But
the
you're
trade-
still doing the business.
Yes, yes, business is being carried out. And my lord, what happened?
So why have you suddenly come?
No, my lord. They come up with a notice to me that why so asking me to show cause as to why I am running the business without renewal of my trade license.
Where is that?
Yes, my lord. Page 72.
Wait, 70?
Page 72. Lordship has got it, Annexure 26, page 72. 73 is the vernacular version. This is a typed copy, madam, translated copy. Then page 74 is my reply to the show cause notice. Then page 80 again, another representation for requesting for renewal of my trade license.
Page 70?
Page 80.
80. Eighty is reply to show cause notice.
Yeah, 80 is reply. 81, your lordship will see early disposal of appeal. They're sitting over it, madam. My trade license has not been renewed.
Where have you asked for your trade license to be renewed?
Lordship will see page 70, 26/3/2021. Even after the demise of my father, I had requested for renewal of my trade license. Then this
This
notice,
is of 21. Where
21.
where have you prayed for it in 19 or 20?
well, 19, my father had prayed.
Your father, it's
My father died in December 2019. And your lordship knows in December, the car movement started, so there was a shutdown.
Yes.
And thereafter this COVID period was there. So in 2021, after the COVID period, I again made a representation that my father's requests are pending. Father has passed away. in the
So
meantime.
the impugned order right now is which one page? Is there any impugned order?
No appeal. I'm only praying that let the appeal be pending, let the appeal be decided or not. In the meantime, they should.
What is the appeal number?
Appeal number is what?
Is there any appeal number?
Yes. Appeal number is your lordship will find it page 53. GCL /02 just /2017. It is pending before the mayor and council, madam.
Yes.
In the pair, my lord, he is praying for renewal of the trade license, my lord. My lord may come to page number 73, my lord. My lord, this notice was issued against his father, not to the petitioner, my lord.
Other died,
My lord,
he cannot answer from his grave.
my license cannot be transferred from one person to another, my lord. He has to apply for that, my lord.
You cannot have renewal of a
Right.
license from against the dense man's license.
But they did not come up with that in any of the reply to my.
Well, now they're telling you,
No, that
He
can
has
be,
to apply online, my lord.
no, I can do that, my lord.
you cannot have in the dead man's name.
No, that I know, my lord, that I know.
Then what have you been doing?
No, I have,
He died when?
he died in December 2019.
19. 4 years have gone by.
And they did not renew the trade, whether
How
they will
can
show
the-
the continuity in
How
my
They can
business. That,
renew the
Huh?
How can the authority renew the license, my lord, who is not?
Correct, he's a
No,
dead
no.
person, how can you renew?
even they did not renew it during
why
the
did you-
lifetime of
why
my father
did-
also, my
huh?
lord. Even they did not renew it during the lifetime of my father also.
That is a different issue.
Yes.
That,
Is in page number 73, my lord, not renewal from 2018-19, my lord.
18, 19 years. my lord.
That's why, my lord.
not renewed from 18,
18,
19.
18, my father was there. 18, my father has requested the authority to renew the trade license. They were not doing it on the pretext that this appeal is pending, my lord.
Where is that? Where is your father's request to renew?
Your lordship will see at page 66. They even refused to receive my request by hand, so I had to post them by registered post, my lord.
Ashish Sen Gupta. Who
Yes,
is
my
this? This you or this
No,
your
my
father?
father, my father.
Anyway, so now what is to be done? Now, so there are two aspects. One is renewal. So let him file it in his name, an application. And why is the appeal not being decided?
With their instruction, I will not have money.
Even, my lord, in this writ petition, your lordship will kindly see the mayor and council have been made parties, notices have been issued, they refused to receive the notice of this honorable court.
Final opportunity is granted to madam to
My lord.
obtain instructions.
My lord, for trade license, they have to, my lord, apply, my lord.
I will do that,
They
my
will
lord.
apply.
License, my
For that, they will apply.
My lord, I have contacted them, but they say that this
My
appeal
lord,
is pending,
now
your
I-
license won't be
my lord, registration, my lord, by online, my lord, not through the, my lord. They have to apply online, my lord.
Must apply online.
My lord.
I'll do the
So you
lordship
apply
make a-
online.
make an observation, my lord.
And you apply online and depending upon the decision that they take, then you can come again. How does it? Because now,
They're subject to the decision in the appeal, my lord. They.
what do you mean subject to the decision there? That,
No.
how do you
Well,
know it is connected? Why are you connecting the two?
My lord, because this appeal was filed against renewal of the trade license in the name of my father, my lord.
Okay.
My lord, the person who
The
has filed the appeal, he
the
is not
subject
my
matter of
lord.
appeal is this, my lord. Now, if your lordship gives a.
You see, one thing is, you see,
Yes,
there are two aspects. That appeal cannot be decided because the appeal is against the dead person.
Yeah.
Or appeal has been filed by you or
No,
whom?
no,
By him.
No.
So
appeal-
you have got to go and plead yourself there in that appeal.
They're
because-
not giving any dates, my lord.
My lord,
What
it is
is the,
more, my
what
lord,
what is the question of giving dates?
My lord, if
The-
they do not even receive any application, my lord.
Then you file an application first. Where is your application to them? For substitution of your father's name by
No,
yourself.
no, that is not there, my lord.
Then you do that. Then we can take up the issue. Otherwise, we are going to take up our half-baked case. You have got to do your part of the, the homework first.
Yes, yes.
You have got to apply for changing the proprietorship from your father's name to your name. Number one. And at the same time, you have got to apply for renewal of the license.
Yes.
Number two, you have got to go to that mayor and council, ask for implement of yourself in place of your father. Substitution of your father's name by you. Two aspects.
Yes.
So once you do that, depending upon how they answer you or they don't take action, then you come here.
Yes.
Right now, we cannot decide this matter.
Yes,
You withdraw this. Okay, with liberty.
yes.
Okay, heard, Mr.
D. Goswami.
D. Goswami, learned counsel for the petitioner, who submits that he may be allowed to withdraw the writ petition with liberty to file afresh. Full stop. He submits that the petitioner will be filing an application before the GMC authorities to change the trade license from his father's name to his name, and also be asking for renewal of the trade license. Full stop. He further submits that he would also like to make an application in appeal number GCL/02/2017, which is pending before the mayor in
Mayor in
council,
council.
Guwahati.
Guwahati.
Guwahati. As his father, who was the respondent, expired on
Expired on, 9. Lord, he passed away in, okay. On 7th of December 2019.
7/12/2019. When did you file your applications? How much time?
Well, immediately, 1 month, 1 month.
Okay, Miss S. Tutesh, learned counsel appearing for the GMC, submits that she does not have any objection to the prayer of the petitioner's counsel. Accordingly, the writ petition dismissed as withdrawn, with liberty as paid for.
Deeply.
Then you come, then we'll see.
Yes.
Non-payment of contractual dues, my lord.
Huh?
Non-payment of contractual dues, my lord. It is admitted by the respondent, my lord.
Where is the admission?
My lord,
Page 95, para 7, my lord.
all dues are not admitted, my lord.
No, you pay the admitted amount.
Admitted. my lord.
Page 95, para 6.
3 lakhs,
Yeah.
3,000.
Yeah.
Okay, right. Heard Mr. P.J. Saikya, learned counsel for the petitioner. Also heard
G. Bokolial.
Mr.
G. Bokolial.
G.
Bokolial.
How do you spell?
Bokolial.
B.
Okalial.
Bokoliar.
Man.
Learned counsel for the
All are respondents.
all the respondents. the case of the petitioner is that after being awarded a number of work orders by the respondent authorities during the period from 2015 to 2019, the petitioner supplied all the materials in conformity with those work orders and submitted the final bills amounting to rupees 10,23,729 full stop 75 paise. Full stop. However, the respondent authorities have not released the pending bills of the petitioner till date. Full stop. Next, Mr. So-and-so, Bokolia, learned counsel for the respondents submits that the affidavit of the respondent number 3 in paragraph 7 has admitted that the pending bills of the petitioner are only 9,03,731 and not 10,23,729.75. Next paragraph. On hearing the counsel for the parties and on perusing the affidavit in opposition filed by the respondent number 3, it is seen that the respondents have admitted that they have got an outstanding liability of rupees 9,03,731 against the petitioner. As the respondents have admitted that they owe rupees 9,03,731 to the petitioner, the respondents are directed to pay the said amount of 9, to the petitioner within a period of 3 months. Your financial year is ending. You'll have ending, you'll have money before 31st March.
Yes.
Within a period of 2 months. From today. Within a period of 2 months from the date of receipt of a copy of the file.
That'll do.
The petitions accordingly disposed of.
Apply.
But in this item 21, my lord.
May I please your lordship? May I please your lordship?
My lord,
Yes.
in the item 21,
Let me place it before the court. Lordship, WPC 3205 of 2021, Lordship.
Yes.
That I had filed against the cancellation of contract. Lordship, now I've got instruction from my client that they will go for ADR arbitration, since
Okay.
arbitration provision is there.
Okay.
So I would like to withdraw this WPC.
Lordship, I have an objection to that, Lord. Let it be remain all the 3 writ petition may be had together. Because Lordship, in this petition, Lordship, on the day this writ petition was filed, cancel, already her contract was cancelled and
What was cancelled?
award contract was cancelled and award has been awarded to someone else. That prayer has not been made in the writ petition. Subsequently, she filed a writ petition.
He wants to withdraw, that's
No,
all.
Lordship, that will be brought under order to rule 2, relinquishment of prayer, Lordship.
Lordship, when arbitration is
Let
there.
it be remain, Lordship.
go there.
Why?
Or otherwise, the next writ petition will be brought under principle of order to rule 2, Lordship.
Why, what is this case about? This is her claim, look, this is a technical bid has been,
Yes.
you have been rejected on
No,
the
no,
technical
no,
bid.
I've just
What
observed
contract
it.
has been cancelled?
Huh?
What contract has been cancelled because of
Just-
non-performance, Lordship?
Okay, what contract?
No, not
Yes,
non-performance. That was during COVID period. We were not able to supply. Nobody was able to supply. But then they had cancelled my contract. So then they tried to, the most important part is that they tried to recover that money from WPC 4234, which I had filed. That is another contract, which final order completion or certificate was issued. But my final bill they did not release, and they tried to deduct that risks and cost, whatever was the loss in this contract from that one. So after this, when I had come before this honorable court, what they did is that they blacklisted. So that is the third petition.
Lordship, can you see the prayer made? in
So
the
Lordship,
petition?
now my client is saying that since this is pending and his money is also there, so he says that we'll go for ADR. So I am withdrawing this.
Yes.
The provision
You
is
cannot
there.
stop. This is not your writ petition, Mr. Mount.
Lordship, can you see the prayer, Lordship? The cancellation has not been
But
challenged.
I am
No
withdrawing.
prayer has been made.
Mr. Council, this writ petition, it's withdrawn.
Ought to have been withdrawn at the first instance, Lordship, not after 3 years. Lordship,
There's nothing.
Lordship, there is a stay
No,
order
no
that,
prejudice is caused to you.
that there is a stay order that may be
Huh?
vacated. There is a stay order that may be vacated.
Actually, all stay orders are going to be vacated.
That will vacate it. That
And
will get-
actually, all stay orders. So you're going to withdraw all the cases.
No, Lordship, only WPC 3205 of 2021.
Item number 22.
Item number 22.
In 21, my lord, I have to supposed to file affidavit, my lord, but I have.
Okay, so they're all interconnected.
Yes, Lordship, by one petitioner.
That's why
No,
I'm-
No, not
no,
interconnected, Lordship.
No, wait.
same
Wait.
contract arising up.
Same
the Same
contract.
contract.
No,
Lordship.
Okay,
Lordship,
same
again
contract.
is misleading.
No,
Not
Lordship.
same contract. This is a different contract,
Okay,
3205.
986,
Yes, this is a
WPC,
different contract.
just a minute. WPC 986 of 2023 pertains to what?
This is against blacklisting,
This is against blacklist.
blacklisting, Lordship. I had been
And
barred.
then 3205 of
This is
20,
against
this is a
cancellation of-
disposed of matter.
Cancellation of
A
contract.
disposed of.
He want
No.
to see on the.
Withdraw.
I want to withdraw.
Why does it say D/O? Huh? That's what it means. It says a D/O. But out here it says nothing. Actually, there is 3205.
Yes, 320.
One is 21
Lordship, that is 21 initially filed against one.
and there is one 3205/22 that has been disposed of.
That was disposed.
So you want to withdraw 3205 of 2021.
2020,
This pertains to what?
cancellation of contract.
Cancellation contract. And 4234 of 2022.
I want to file affidavit, my lord, next week, my lord.
What is the matter
Lordship,
about?
this is a separate contract,
Okay.
totally separate work.
No, that is.
Which we
once
had,
there's
which
been
we had- just a-
given to third
Just a
person,
minute,
that has been challenged.
just a minute. No, he's wrong again. Lordship, this work I have completed. My final bill payment is not being made.
In that 4234, we have
Yes,
completed.
So
So
I want a direction from this court.
32025, you have been terminated.
Yes,
So you want to challenge. That's a different contract.
that's a different contract.
Then
and this is-
986 of 2023 is.
That is a notice where we are being blacklisted.
Acha. No, there's
We are
different
barred,
issues.
Lordship, actually.
Okay, right. Miss
Embora, Lordship.
M. Bora, appearing for the petitioner, prays that she may be allowed to withdraw the writ petition. As the petitioner is planning to, is going to approach the respondents to avail of the arbitration clause in the agreement. Pustav. Who appears, Mr. B. Chakrabarti, CGC, appears for the
All the respondents.
respondents and objects to the prayer.
That's
What? What do I write? What do you want?
maybe withdrawn and the stay order may be vacated.
Just say appears for the union, appears for the respondent. Pustav, the prayer of Ms. M. Bora is allowed. Writ petition is dismissed as withdrawn. Interim orders pass, any interim order passed earlier stands vacated. So 22 disposed of.
Lordship.
Now, item 21.
No,
21,
21. 21 was, means 3205 has been.
Yes.
Correct,
Item
22,
number 22.
22, correct.
Lordship, yes.
Now,
Okay.
item 21,
21, I need at least 10 this time, I will file affidavit, my lord, defective affidavit come, my lord.
is there, wait a minute, this is a different contract?
Different.
Now, out here, what is the issue?
Completion certificate was issued to me.
But-
But final bill was pending.
I mean,
Yeah, final bill not released till date. And
is there any in-house mechanism for resolving disputes here? Any in-house mechanism other than arbitration?
no, Lordship.
So is there an
Direction
arbitration
can be
clause?
given by this court.
Is there an arbitration clause?
Arbitration clause is
Ah,
there,
yeah.
because interest, Lordship, again, interest is.
Then why don't you go for arbitration here also? Even arbitration clause is
But-
here.
Lordship, actually, my client is having overdraft facility with the bank now. He had taken some money from the bank in this case. Now the interest is accumulating in the bank and we are repeatedly trying to get the final.
Doesn't
order
matter
released.
with that, that is not our concern.
Lordship,
Our concern is if there is a dispute
Arbitration.
resolution mechanism in place in the agreement itself. You have to avail of that.
yes, Lordship.
Then-
That has to be a bit
then-
because the interest is there.
Then why should we venture?
Lordship, give one date, I'll just consult with my client. Because he is also wanting time and I
You
will
want,
also,
you want time for what?
for his affidavit.
That regarding that arbitration clause, I have already mentioned in my affidavit, but defective affidavit come without any initial signature only.
That's a different, this is a question of law. There is nothing here.
I have mentioned about that arbitration.
If there is an arbitration clause, you avail of the
Yes,
arbitration
I'll
clause.
avail, Lordship, I don't have no, just I
You-
need
you-
a consent from my client.
You don't need any consent. We just have to direct you. Your client's consent is of no use. We are not,
I know.
we
I
are not
already
bound
talked
by
to
your
them.
client's consent, madam.
Because ADR is there, so
ADR is
we
there.
have to use.
You cannot, you see, yeah. Can you understand now in item 22, you want to go through ADR because it's in your agreement. In item 21, there is again the ADR, but you want
No, Lordship.
to consult
Here
the
only
client.
that I prayed for a direction from this court so that at least the principal amount is released. Because Lordship, financial hardship is there. We contractors are also having financial hardship. So that is why I'm before.
At least the
Because once
principal
I go-
amount.
Yes, once
The
I go
interest
to
part
ADR, it
of-
will take time.
Yes,
again.
yes.
My stand is that she has not completed the work because of that.
Completion
Or not completed the work.
The whole work, my lord. So at least the affidavit,
But at least give the admitted part.
no.
But of course, the agreement is, you've got to complete the work, otherwise a third party
Malad-
can come in and do the work.
At least next week, maximum, 10 days time maximum.
Okay, right, item 22, item 21, Mr. K. Parasar, learned PGC, you granted 10 days time to file affidavit. Miss M. Bora shall obtain instructions as to why the arbitration clause provided in the contract agreement should not be resorted to.
No, Lordship. I'm ready to. It's
Then-
just that I want the principal amount from this honorable court's direction.
But when he's taken the stand,
Lordship, we will go through the final, it is their certificate issued to me. So he's taking time, let him take. I will show this honorable court that the final
Okay,
certificate has been
just
issued
say,
to me.
Ms. M. Bora, learned counsel for the petition submits that though the petitioner is agreeable to invoking the arbitration clause in the contract agreement, the petitioner should be given the principal amount in as much as the contract work has been completed.
Lordship,
Full stop. The dispute is related only to the interest portion
yes.
to be paid to the petitioner. On the prayer, the parties list the matter on, give a date. On the
Chair.
date. 12.
12, no. 12. That's not a problem. 21 of.
21 will be 20 days.
No, I will be out of session next week, some 22nd will be. I have some vision.
22nd month.
And then item 23, what about this?
23 architecture today he is out of session he has taken instruction
Okay, same date.
Affidavit.
On the prayer, just say, as Mr. R.K.D. Chaudhary, Deputy SGI is not present, list the matter on 22nd.
22nd.
Same date,
Same date.
26th. Much obliged.
My lord, the case of the petitioner is that, my lord, he is jari kar rakha the SDJM office.
Is this matter to be heard by this bench?
Heard at length, my lord. My,
No, is this the appropriate bench?
lord, this is. Best tree.
Yeah, bench free matter, no? That's what I was thinking. Okay, that's why. And anyway, out here, I think you've got to file a rejoinder. Are you filing?
We have filed it.
You filed it? Okay, so pleadings are complete.
Yes, my lord.
Okay, Mr.
A.W. Aman.
A.W. Aman, learned counsel for the petition. And Mr.
I'm U Pathak, I'm appearing for Mr. H.K. Das, standing.
Mr. U. Pathak appearing on behalf of Mr. H.K. Das, learned
Council.
standing counsel,
Guwahati High Court.
Guwahati High Court. Submit. Submit that pleadings are complete. Post up as the matter pertains to bench 3, comma, registry to list. Registry to verify the same and list before the appropriate bench. You have Guwahati High Court. Just tell Mr. You have for the Guwahati High Court, no?
My senior is for the.
Tell,
Guwahati High
tell me your senior if he can come and meet me at 1.
My lord, I'll
Okay.
inform. I'm deeply obliged.
Deeply.
May I brief the Lordship? Lordship is an application under section 11 of the Arbitration Act. Lordship may kindly peruse the last few orders.
Last few order.
Yeah, Lordship order dated 10/1, sorry, Lordship. Third, Lordship order is 6/11/23.
Which order?
6/11/23, 6th of November.
Yes.
So Lordship, and thereafter, make a kindly peruse order dated 19/12/23. So Lordship, every time they appear, they seek time, and every time last opportunity is being granted to them, and still they have not filed their affidavit. The simple application under section 11(6), Lordship, for.
Appointment of an arbitrator.
Yes, Lordship.
What is the issue here?
Lordship, so we are a home buyer, and we were they were supposed to hand over the flat to us in a contractual period. So that contractual period has been over, so we are entitled to compensation.
How much have you paid?
95% of the consideration amount.
Where is the arbitration clause?
Shit. Lordship,
Yes,
final
madam,
page
what?
59.
May your lordship, we have not received any specific instruction.
No need,
for the
no need,
defect.
no need. We can't wait for you all the time.
Lordship, page 59 of my petition.
Mr. Parwari, can you meet me at 1 o'clock? I've also called the High Court Council. Okay.
Lordship, page 59 of my arbitration petition. It's clause 16. It starts from page 58.
Clause 15,
Clause 16, Lordship.
16, which?
Page 58.
Which?
It starts at 58 and then it follows on 59.
Yes, but which subclause?
Clause 16, subclause A, B, C, D, E, F.
Okay.
All arbitration.
Any dispute claim, for both 3 arbitrators.
Yes, Lordship. So we have proposed from our end.
Ah,
They haven't responded to the notice here.
then what happens if they don't want to appoint? So we'll appoint.
Lordship will have to appoint
Then the
They
third
have raised
arbitrator,
their- they have raised their
arbitrator will be appointed
by
by
the
two.
arbitrators.
Where's your senior?
Sir, the senior is on legs,
Where?
so he's on the way. Both.
He's coming here.
Yes, sir.
Okay, let us wait since
Very well.
junior,
Very well.
they're at a loss. He seems very lost.
Very well, Lordship. Obliged, Lordship.
Right, please, your lordship. That's it. In to our arbitration petition, I have received some instruction. Some clarification is required, lordship, from the department.
What time, please?
After 2 weeks, lordship.
No. Why? What clarification?
As per my instruction, lordship, contract, this contract, has not been completed, Lordship. And
So that is a dispute. According to you, contract has been completed.
Yes, Lordship.
According to you, it has not been completed.
Lordship,
Then that's a dispute.
They should have submitted affidavit. That's
Lordship,
what time.
kindly,
No, we accept her submission. We'll record a submission that, so that is a dispute. So let the section 11 arbiter be appointed.
actually, Lordship, petitioner has to go through some procedure, but they have not go through a certain procedure for.
No, Lordship, we had sent the notice.
Huh?
2 times we had sent notice to appoint arbitrator.
No, they cannot appoint arbitrator.
No, Lordship, as per clause 23
In,
of the
in
MIT.
terms of Perkins Eastman judgment, this DAO cannot be an arbitrator. Because he's an interested person. He has got an interest in the results. The High Court only can appoint.
Lordship, can you 1 week time maybe given?
for
Lordship,
what?
Lordship, actually, yesterday I have received the instruction. I have to go.
What is the instruction? Let us see the instruction. Where is the arbitration clause?
Lordship, page number. Page number 25, Lordship. Clause 23.
There is nothing to decide, madam. What is there? Do you think we can dispose of this matter? We can't. What instruction are you going to take? To what effect do you want? What type of instruction do you want, madam?
Lordship, regarding the procedure, they have in Parawai's comment, they have
That judgment regarding that arbitration, can you just print out? Uh, that recent one, that Eastman, Perkins Eastman. Perkins Eastman, just print out. Acha, it is an arbitration petition number 24 of 23. 24 of 23. A&E Industries. So you want a section 11 petition.
This Lordship, appointment of arbitrator.
So we'll have to appoint.
Yes.
From the
Since
list
they
of
have-
arbitrators.
Since they have not responded to our notices.
Yes,
For appointment of arbitrator.
they will not respond. Just a waste of time. Sir, give me the list of arbitrators. Give me the list of arbitrators. Acha. Okay. ठीक है।
Lordship, kindly, in parawise comment for, second page, 14 to 20. In parawise comment, Lordship.
You have given me parawise comment, yes,
Lordship, I have given.
yes,
Second para. Bottom, Lordship.
14 to
14
20,
to
yes.
20. As per their instruction, Lordship Department, petitioner has to follow certain procedure for payment of
So all these things will be decided by the arbitrator.
Yes, Lordship. Our prayer is limited, Lordship, appointment of arbitrator.
That's all. This, section 11(6), I think. Section 11(6) Arbitration Act. Where is your letter asking them to appoint an arbitrator?
Page number 55, Lordship, Annexure 9.
Yes. Okay, right. Right, mister?
MZ Short.
Huh?
MZ Short.
Appearing on behalf of whom? Is it Chaudhary, that's your
My name is.
name is there? Yeah. And the Chaudhary, direct counsel for the petitioner. And Miss
Z Bora, Lordship.
C. Bora, learned counsel for
Agriculture Department.
the Agriculture Department. Then they take this order dated 13/10/2023. Para 2, para 3, para 4, huh? Para 5. Can you continue? However, no response has been forthcoming from the respondents till date. Miss Bora,
Lordship.
A. Bora, G. Bora,
Z Bora.
Miss G. Bora, Learned Standing Council Agriculture Department submits that there is no need, there is no requirement to appoint an arbitrator. The contractor must follow the following simple procedure before payments are made in any government beneficiary oriented scheme. When you take from here, huh? There are 14 to 20, this part, this A, B, C.
Lordship,
Huh?
there's a letter, 31/8/2022 and report, field inspection.
Huh?
28/2022, Lordship.
There is no letter in my copy, madam.
Lordship, I have given. On the side.
No. 31/8/22.
Lordship. And 28/2022, Lordship. This is the field where we come with it.
Full stop. Next para, the learned counsel for the agriculture department further submits that in terms of the letter number EE/AG/KD/GUW/RURBAN/23/575, no, 1575, dated 31/08/22, issued by the Executive Engineer, Agri, Kamrup Division, Guwahati. The contract work of the petitioner was inspected by Shri Paban Das, PABN Das, junior engineer. Who made the following observations. One to five. And where is your letter that there's a completion certificate? Where is it? Is there any completion certificate?
Yes, Lordship.
Where?
In this letter,
Yes, Mr. Bhuyan, is there any completion certificate?
Completion certificate was there, my lord.
Where? Was there means what? It was, now it's no more there or what? Is it still there or not?
My lord, they have not issued any completion certificate.
Though you have
yet,
completed it.
my lord. We have, my lord, what has happened, my lord, the bamboo sets wooden structure which we have constructed, my lord. We have requested them to take delivery of the same. Now, my lord, they did not take the delivery, neither the completion certificate has been issued. And in the meantime, my lord, as these are very temporary structure, my lord, something has been damaged due to flood or erosion, something like that. Now they are disputing that you have to again rebuild, which is not possible, my lord. That is the instruction I have received, my lord. That's why all the disputes, and therefore, my lord, this arbitration clause is there.
Can you go through, letter dated inspection?
Lord, my respected
Just a
friend,
minute.
my lord.
Next page, Lordship, I have, just hand over 28/2022.
Yes.
The present status and remarks has been there, Lordship.
Anyway, right. In that order I said, no? In that order dated 13/10/23. Okay, not that, then, right, then, carry on, not carry on, full stop. On perusing the, no, on considering the submissions made by the councils for the parties, it is clear that there is a dispute between the parties in as much as the petitioner's case is that he has completed,
My lord.
he has successfully executed the contract work.
Yes, my lord.
While on the other hand, the case of the state respondents is that the petitioner has not completed the contract work.
As per proper manner.
Huh?
As per proper manner, Lordship, kindly go.
Naturally, as per proper, it cannot be as per improper manner.
Lordship.
Full stop. Next. as there is a, as it is not disputed between the parties that there is a
Clause.
arbitration clause. In the event of, for the purpose of settling disputes between the parties, this court is of the view that the arbitration clause provided in the NIT would have to be resorted to settle the disputes between the parties. Full stop. The only problem arises with the condition in the arbitration clause wherein it is stated that the arbitration shall be finally settled at EAO, Kamrup of Government of Assam under the provisions of the Indian Arbitration and Conciliation Act 1996. Full stop. Next. The issue with regard to whether then an arbitrator can be an interested person. And if not an interested, and whether an interested person can further appoint an arbitrator has already been settled by the Supreme Court in the case of Perkins Eastman's Architects, DPC, and another versus HSCC, bracket India Limited, reported in 2020, 20 SCC 760. So, sir. In the case of Perkins Eastman Supra, the Supreme Court has referred to under this decision of the Supreme Court, that is TRF, okay, you take this down. Okay.
One of the party.
From para 8, 9, 10, 11. Para 16. Now, out here the arbitrators are Supreme Court judges, Supreme Court judges, High Court judges, retired district and section court judges. Now, High Court judges are Justice H.N. Sharma and C.R. Sharma. Then retired district judges are Mrinmoy Kumar Bhattacharjee, Pradeep Kumar Das, Mahmood Ahmed, Chaya Rani Goswami. Who do you want?
Justice B.K. Sharma would be better.
There's no B.K. Sharma.
Not just.
H.N. Sharma
H.N. Sharma, of course.
and C.R. Sharma.
Here, Sharma.
Madam, who do you want?
Here, Sharma. Criminal.
Give him this, give them this. Let them choose from it.
Yes.
Yes.
Oh,
Yeah, Sharma, okay.
Yes.
This, yeah, then 17, huh? It takes 17. Eighteen of. So now with regard to
Well.
the ability of the arbitrator, with regard to the whether whether they are uh, having any difficulty in being an arbitrator, Section 12 provides
my lord.
that they should give they should provide, they should state as to whether they have any, handicap or problem in being an arbitrator. For that event, we'll appoint him as him, but the parties will communicate with him
Well.
with regard to whether he can take up the matter as an arbitrator. That I leave it up to you under Section 12.
My lord is keeping the matter pending, my lord.
No, I'm appointing him straight away.
My lord.
If he doesn't
My
come, then you come
Then
again
we'll
afresh.
come again.
We'll
My
appoint somebody else. No
My
point keeping that. Only because of that, 18, 19. 19. So we are, Sia Sharma, okay? Just say, the parawise reply that has been submitted. The parawise reply made by the government made by the agriculture department to their council, and the letter dated 31/8/22 issued by the executive engineer Agri Kamrup division.
And Lordship, 28/2022 also.
And the
Letter.
letter dated 20/08/22 issued by the JE to the office of the executive engineer Agri is made a part of the record and marked as annexure X, Y, Z, and Z respectively.
Okay.
Annexure X. Annexure Y. Z, X, Z. Please give it to separately. What is the next one?
My lord, similar, my lord. Similar nature of.
Similar.
Similar.
But
Parawise
otherwise,
comments are also there.
same.
Similar. Lordship.
Lord, only the parties are different.
Parties are
The-
different, Lordship.
But the parawise comments,
Almost same.
nature of
okay,
both
same.
of them.
We'll see. Dispose of both.
My. It's obliged, Lord, highly obliged.
Your lordship. Your lordship, the matter relates to tender of a bazaar for a period of 1 year, your lordship. Your lordship, if your lordship may move on the comparison statement, your lordship, it's. Your lordship will find that,
Page.
lordship. The lordship will find a comparative statement from page 72 to 73, your lordship. Additional affidavit for your lordship.
Yes.
Your lordship will see the highest bidder of the market was shown at Jayanto Dungri, your lordship. 12,74,401.
Yeah.
But he was, but the remarks from him suggest that it has been cancelled.
What is the reserve price?
Your lordship, reserve price was, 2,15,390.
2,15,000,
379.
1,500, no?
Yes, your lordship. And your lordship, the first bidder was bid was shown to be cancelled. The second bidder was withdrawn. The third bidder is the petitioner, your lordship. And your lordship, yeah, after the order was passed for resettlement, it has been seen that the lowest bidder, your lordship, who happens to be the private respondent, your lordship, his case he has been approved.
But please see, DD not as per tender clause.
Yes, your lordship. Yes, your lordship. I'm coming to that. But their bid is also not free from defect, your lordship. Their bid is also not free from defect, your lordship.
So how does it matter?
Your lordship, if his bid is not free from defect, he is also not entitled to get the market, your lordship. The private respondent is not entitled to get the market, your lordship. And I have clearly,
But how do you know?
I have clearly pointed out, your lordship. I have annexed his certificate, your lordship, annexed his form, your lordship. And your lordship, I have mentioned on page 54. Page 54, your lordship. Your lordship, I read from the third line, the private respondent number 9 has also failed to annex the requisite documents required to be filed along with the tender papers. That is non-encumbrance certificate, income tax clearance certificates, affidavit for agreeing to government rules, financially sound certificate from circle officer, and affidavit for genuine.
Show me, where?
Your lordship, page 54. Page 54.
Yes.
I have got this information after I filed an RTI. I have received his form, your lordship, and here I have not found this documents, your lordship. The private respondent number 9, third line, page 54, third line. The private respondent number 9 has also failed to annex the requisite documents required to be filed along with the tender papers with non-encumbrance certificate, income tax clearance certificate, affidavit for agreeing to government rules, financially sound certificates from circle officer, and affidavit for genuinity of the documents, submitted documents, which are listed on point number 8, 12, 13, 14, 16, respectively, of the list of required documents to be annexed along with tender papers, your lordship. So these documents are not found. And your lordship will see if your lordship move on to his form, the vernacular form, page 61.
No, these are disputed questions of fact.
Yes.
If they agree to it, then it's okay, no problem. But do they agree that this is not been submitted?
Your lordship, I have.
You have got no clue of what they're going to say.
Lordship. Your lordship, I have stated based on the documents that I have received through RTI, your lordship. In the form of the private respondent number, it is clearly stated that he will pay the amount as actually at one go. What the money receipt that I have received suggests he have paid in installment. That is another violation of the clause. And your lordship will find that this private respondent number 9 find ways to get the tender in his name by some ways, your lordship. Because in the preceding years also, this man is your lordship,
Settlement holder.
Your lordship, he is the owner. So he will find ways somehow, way or not. Your lordship will again take into notice that comparative statement, though the highest bidder was shown as cancelled, but I have annexed a document which is on page 74, 75. Your lordship will see that initially the market was awarded in the name of the highest bidder, Jayanto Dungri. So just to send a feeler, see, there was everything is fair and the market has been awarded to the highest bidder. So I also stepped back. But when everything pulled off, your lordship, suddenly a comparative statement is released where his bid is shown as cancelled. The second is shown as withdrawn because they are the proxies of the respondent number 9. And subsequently, your lordship, the respondent number 9 has been awarded with the market.
So there is a cartel.
Yes, your lordship. So I have annexed those documents. This is also an order of the Biswanath Jilla Parishad dated 28/6/2023, page number 74, 75, wherein the.
Anyway, let us see. What do you mean by DD not in order? What does it mean?
According to clause
Your Lordship, DD was supposed to be addressed to the Biswanath Jilla Parishad. I have addressed it to the Anshalik
Anshalik Panchayat.
because since the market is above the
above
price
than
of
1
1 lakh, it ought to have been sent to the Jilla Parishad. There is also another story. I don't want to bring it before this honorable lordship, before this court, your lordship. But the thing is that if my bid has been is defective, your lordship, how can a person with the private respondent number 9, whose bid is also defective, who has not submitted requisite documents, can be allotted with the market?
So, Mr. Council, let us ask them.
Your lordship,
You're repeating your story,
lordship.
over and over again. Let them reply, give them a chance to reply,
Lordship.
okay? Because then we will know what to do. Okay. Yes,
That's why we have received the record. Here
please see, both of you see the records. Let him see also. If for everyone to see.
is
Yes, see if the documents are there or not.
executive
Because it will be all in Assamese. I will not. So both of you see
Your lordship, this is the record pertaining to the petition, your lordship.
petitioner.
Yes.
Oh,
And the records of the private respondent.
private
number 9,
respondent,
This one is. CEO Biswanath Jilla Parishad. This one,
yes, see, he says that all these documents are missing.
Whether these documents,
all documents.
non-income certificate.
This one, Lordship, we have received the compulsory statement also, original. Here also, he's the third bidder, and he is not, DD not on for tender clause.
They did not ask for tender clause.
Yes, sir. That is for the petitioner, your lordship. But the private respondent.
So if DD has not been done as per the tender clause, then where is the case?
Yes, lordship. Your lordship, if I don't have the case, your lordship, the private respondent number 9 also don't. have the case.
No, that is, no, they are Supreme Court judgments. Just be, you just be, you see, you have got to, just because you cannot be in the same footing like that.
Your lordship,
You've got to stand on your own feet.
your lordship, since your lordship,
Anyway, let us see this respondent number 9 or whatever. 9 or 7 or what is it?
9,
Seven.
respondent number 7.
Oh,
7. Has he
9.
submitted the documents or not? You have given him the documents. Has he submitted? He says that non-encumbrance certificate was not submitted
Yes, sir. Income tax, your lordship.
and income tax clearance.
Affidavit.
all
All are there.
are there. Comment.
Wait, please.
They submitted all.
Huh?
Submitted all and all the.
Anyway, so let him clarify. He is making the allegation.
Yes, Lord.
Now let us see what he has got to say.
Your lordship, it's not there. Non-encumbrance certificate, land, affidavit for mortgage of land from Pattara income tax certificate, those are not present here, your lordship.
And-
They have the tax clearance certificate from Jilla Parishad, Anshalik Panchayat and the GP.
What do they don't have? They
Your
don't
lordship,
have-
they don't have the, your lordship may move on to page 64. Your lordship.
No, I'm looking at it.
64 is the.
Just a minute, Mr. Council. Yes, madam. Is the non-encumbrance certificate there? Private is point number 9.
Compared to the LEC, non-encumbrance certificate. This one is non-encumbrance certificate, yes.
It is there
Yes.
or not there? It is there. Oh,
Non-encumbrance. This one is Biswanath Charyali, Sub-Registrar Office.
okay. Then number 2, madam, is the income tax clearance certificate there?
Income tax clearance certificate, yes.
It is there.
No, Your Lordship, these are from the Panchayat and the Jilla Parishad,
Panchayat.
not from the income tax authority. These are of clause A, 4, 5 and 6, Your Lordship.
Lordship, This
Income
one
tax
is from-
certificate also is mentioned in on clause 12, Your Lordship. That is not there.
tax clearance certificate, non-liability certificate, tax clearance certificate also here. This is from the
Gaon
Jar-
Panchayat.
Jarabari Gaon Panchayat, Jarabari. And clearance certificates,
Income tax certificate from the income tax authority is not there.
Lordship, it's
And the affidavit for agreeing to government rules is also not there.
tax clearance, it's tax clearance certificate from Gaon Panchayat,
Your Lordship,
not income tax.
Your Lordship, may I take Your Lordship?
Tax, income tax, you give it to the Gaon Panchayat. The
And the
income tax.
tax clearance certificate.
Tax, but then let us see your, madam, let us see your NIT. Let us see the NIT. Let us see the conditions.
Page
the NIT.
64, Your Lordship.
Page 64.
Page 64. In the form itself, it is written.
Ah, okay.
Your Lordship, she is
Just a minute,
she is
just a minute.
referring to number 4, tax clearance certificate from Jilla Parishad, tax
Correct.
clearance certificate from AP,
AP means
Anchalik Panchayat,
Anchalik Panchayat.
yes.
tax clearance certificate from GP.
Ah.
I am on 12, Your Lordship. Income tax clearance certificate. I am on 13, affidavit for agreeing to government rules.
Income tax clearance certificate. Ah,
Financial
At
sound
13.
certificate from circle officer.
madam, page 64.
Plus,
Clause 12 officer. Page 64.
plus 12, income tax clearance certificate.
Is it there?
Clearance certificate. Tax clearance certificate. It's not enough. No. For Mukta Praman Patra. 14.
12,
Which one is?
12.
Four. This one is tender paper. This one is tender application.
I'm referring to the form of your office.
This is tender paper. So. Allow it. For Mukta Praman Patra. No. Income tax. For Mukta. This is tax clearance certificate. Tax clearance certificate.
12, 12,
Oh,
12, income tax clearance certificate.
Okay.
Form of fiscal is not a form of fiscal is.
this is tax clearance. Tax clearance. This is.
Okay, where does it talk about DD to be given in a certain manner?
Your Lordship,
Main defect is that.
Huh?
Main defect is that he deposited the earnest money to the executive officer Bagmara Anchalik Panchayat instead of chief executive officer.
Where does it say in the NIT that it has to be submitted to the Zila Parishad? To the CEO, where does it say DD has to be submitted to the CEO?
Plus. Lordship, kindly see the page number 29, vernacular.
Vernacular.
Uh,
প্ৰত্যেক নিবিদাকাৰীয়ে নিবিদত 1 লাখ টকাৰ ওপৰ বজাৰ ঘাট মীনমহলৰ তালিকাত উল্লেখ কৰা মতে 10% আমানতৰ ধন জিলা পৰিষদৰ মুখ্য কাৰ্যবাহী বিষয়াক অধিক কৰি অসম কোঅপাৰেটিভ এপেক্স বেংক অথবা যিকোনো ৰাষ্ট্ৰীয়কৃত বেংকৰ ড্ৰাফ্ট নিবিদাৰ লগত গাঁঠি দিব লাগিব। অনুসূচিত জাতি অনুসূচিত জনজাতিৰ লোকে 5% আমানতৰ ধন নিবিদাৰ লগত বেংক ড্ৰাফ্টৰ সৈতে দাখিল কৰিব লাগিব। So the bid value is more than 1 lakh. So it's deposited CEO Jila Parishad.
Okay. Your Lordship, but she has not been able to address your Lordship 13 points, Your Lordship.
No, but then there are judgments.
Regarding the
If you yourself do not have the condition, where can you, how can you make a challenge to others' cases when you yourself
Your
do not
Lordship, if he
qualify?
is also in the same, if he or she is also in the same footing, Your Lordship. Your Lordship, she has also violated her promise, Your Lordship. He has also violated his promise. He has promised to deposit the entire amount at one go. Now, Your Lordship, the money receipt suggests that he had paid in installment, still around 2 lakhs rupees is pending.
Where is the judgment of the Supreme Court which says that if he does not have the qualification, he cannot make a challenge to the qualification of the others? Where is that? The judgment is there. You don't have. There is a judgment of the Supreme Court against you, directly on the point that you're trying to raise.
Your Lordship may propose another date, Your Lordship will, I will come with certain judgment.
No, there is one particular judgment. Where is that?
And Your Lordship, there are orders of this honorable court, Your Lordship, where the tendering of state lodges, Your Lordship, leads to the, Your Lordship, it means fetching revenue to the state exchequer, Your Lordship.
Mr. Counsel, that is a different issue.
Your Lordship, it is evident from the documents of record that they have been manipulating, Your Lordship. Firstly, they will, Your Lordship, award the tender.
Yes, what about that, those issues that you have raised?
Your Lordship, they will award the tender.
5 documents, they have not put. That's point number 9. Is the 5 documents there? I can understand 1 or 2, but 5 documents missing. That's a bit too much, it appears.
To respondent. Income tax certificate. No tax certificate.
Page 64, correct?
Lordship.
Page 54.
64.
54 is the point number 8, 12, 13, 14, 16.
Lordship.
Are these documents there?
Before. Okay. Now, the income tax claim certificate. Lordship, it's in LIT application. Here said. Here tax claim.
You please look at it during lunchtime. We'll take it up after lunch. Huh?
Lordship.
That page 54, whatever documents he's saying are missing. Those 5 documents, please check.
Lordship.
Otherwise, we're taking forever otherwise. Yeah, next. Item 29. Where?
Okay, here the LOI has been issued.
Huh?
The LOI, I mentioned the morning. The concerned side, the LOI has been already issued on 12th John 23.
23.
23. And he is challenging that he was not able to participate in technical glitch in the bidding process, Your Lordship.
Because there was a technical glitch.
Yes, Your Lordship.
Now, the thing is that you were supposed to, I think, obtain instructions.
We have obtained instructions, Your Lordship. LOI has been issued. And that is not put on challenge on this petition, Lordship.
No, but then that is not the issue. LOI has been issued.
Yes, Your
That
Lordship.
is, he's not doubting that. His problem is that he could not participate because of a technical glitch.
Yes, your lordship.
Now, what are you going to do about it? So the question is, was there a technical glitch?
This tendering process, everything is held online, this handled by the MTron, your lordship. Once it goes online, the department have no control over it, your lordship. It's completely handled by MTron.
So make them party.
Yes, your lordship.
I may produce a copy of the instruction, your lordship.
How could you deposit only part of it?
Yes, your lordship, because of the technical glitch, your
Why?
lordship.
Then you pay in parts over.
Yes, your lordship, because your lordship may peruse from Annexure C, your lordship, and we have been paying in parts, your lordship. We have firstly
Annexure C is page.
page 23, your lordship. We have firstly paid the participation fee of rupees 5,000, your lordship. And then, your lordship, page number 24, Annexure D, we had paid an amount of rupees 3 lakhs, your lordship.
For what?
For the earnest money deposit, your lordship.
And then?
And then we have again paid rupees 4 lakhs, Annexure E, page number 25.
As?
As earnest money deposit, your lordship.
Why in parts? Why not in full? How much were you supposed to pay earnest money?
Yes, your lordship, because I am an ST person, your lordship.
So?
And for that, your lordship, only 15 lakhs, your lordship, had to be paid because for the SC, ST category, 15 lakhs 40,000, your lordship.
Yes, then?
And I have been paying, your lordship, I paid like in partly manner, your lordship. Otherwise, I could have, your lordship.
There's nothing to show that they have been paying. So you were supposed to pay one lump sum amount, basically, and you're paying in parts.
No, your lordship, because there was no specification.
Let us, you have downloaded an auction notice,
Yes, your lordship.
Yes,
Page 22.
and let us see how much was the earnest money to be paid.
Earnest money is paid 30 lakhs 80,000.
Where?
Your lordship.
30,80,000 is the amount to be paid.
Yes,
Yes,
your lordship.
And he's trying to pay it in parts.
These are in paying parts.
No, your lordship, for the SC, ST category, 15 lakhs 40,000 had to be paid.
And how much did you pay out of that 15 lakhs 40,000?
11 lakhs, your
11 lakhs. Why? You're paying it in parts.
Because, your lordship, I need to seek instruction, but in that regard,
What instruction?
he thought perhaps, your lordship, one
Perhaps.
lump sum amount could not be paid at one go, your lordship. That is why he has been.
Oh, he thought.
Your lordship.
From where did he think? How did he get that implication?
Perhaps,
Where does it say in the auction notice?
because, yes, your lordship, there is no
Technical
specific.
evaluation was completed by 16/10/2023, your lordship.
We'll take it up after lunch.
Over. Obliged.
Much obliged, your lordship.
Please, your lordship, my lord, I apologize, my lord, for submitting out of that. The item 24, which was taken up by your lordship, that has been assigned to your lordship, so my lord may take it up at 2 or any. At 2, my lord. I'm deeply obliged.
Lordship, again, sorry to interfere, lordship, 25, the other side is here, so lordship may kindly take it up at 2, the arbitration matter.
25.
Yes, your lordship.
Okay. All right. 25 we have got. That's been. Don't take it.
Please allow. The respondent number 128, that is the accused. Mainul Haq, Samsul Haq, and 6 others were convicted under section 302 149 IPC and are sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 5,000 each. In default, arrive for 6 months each. they are directed to surrender before the trial court. Who shall then send them to judicial custody to serve out the sentence, and else they should be arrested or sent to judicial custody.
Yeah, 29, let's continue 29, sir.
29. May please, Your Lordship. Your Lordship had made a query as to why we didn't pay the money.
Just a minute. Yes,
As to why we didn't pay the money on 13/10/2023, that
Yeah.
amount. My instructions, Your Lordship, are that he didn't have the money in the bank. Since they allowed him to deposit it on 14, that is why he was planning to deposit on 14. Unfortunately, he could not deposit the money on 14 due to the technical glitch.
but they are saying that there was no technical glitch.
According to them, yes.
Then what, now this is a question of fact. So now what can be done? If that is the case, because otherwise then everything, every time if we allow your prayer, then everyone can, there'll be a never ending dispute.
Yes.
Right. Heard Mr.
T. Devi, Your Lordship.
Sri Victor Deori, learned counsel for the petitioner, and Mr. R.R. Gogoi, learned standing counsel for his department,
All the respondents, Your Lordship.
for all the respondents. The case of the petitioner hearing is that in pursuant to a notice inviting tender dated 18/9/23, the petitioner would only submit a part of the earnest money that was required to be deposited and not the entire money. He submits that while the petitioner had submitted a part of the earnest money on
13/10/2023.
13/10/23, the petitioner was attempting to deposit the remaining part of the earnest money the next day, that is 14/10/23. Full stop. However, due to a technical glitch in the official website of www.assamforestonline.in, the petitioner could not submit the entire earnest money. Full stop. He accordingly prays that the respondent should be directed to reissue the tender in respect of NKD-M-16 Kopati Mining Contract Daily.
Yes, sir.
This is in the order dated 2011-23. Okay, para 4 you find it. Next. Mr. R.R. Gogoi, the learned standing counsel for his department, submits that the process has been finalized. And in terms of the NIT dated 18/9/2023, the letter of intent
Yes, Your Lordship.
has been issued to the
To one, Mercer Select Department,
to
MS Select Department,
Mm.
property of Ratul Das. It's not given here, Lordship. I was-
okay, to the selected tenderer.
Yes, Your Lordship.
That is what is name? Yes, right.
Mercer's Select Department,
Messrs. Select,
SELECT
City
Department,
Department.
proprietor of
Department?
Ratul Das.
Proprietor
Ratul Das.
Rahul Das.
Ratul.
R.A.
RATUL.
Ratul, R.A.T.U.L, Ratul Das. Yes, sir. Next para. Mr. R.R. Gogoi has also submitted letter number B/4467 dated 23/11/23 issued by the Divisional Forest Officer, North Kamrup Division, Rangya, which is to the effect that the petitioner, having downloaded the bid document by paying the same online by paying for the same online, and having also paid the participation fee, the same implied that the system was working fine, which the petitioner has also mentioned in his writ petition. Pusta. Pusta. As can be seen from the above letter and the submission made by Mr. Argal Roy, there is nothing to show that there was any glitch in the official website of www. On 14/10/2023.
May I interrupt you Lord, for a minute? Page 27 of my petition. Your Lord.
27.
There is an error.
Okay, there was an error.
There was an error, contact administration.
Administrator has to be the Mtron department. The administration has to be the Mtron department, Lordship. The Mtron handles every single thing on the online, Lordship, not the forest department.
Amtron.
Mtron. Completely handled by Mtron, Lordship.
Is Amtron a party?
No, Your Lordship, we are not made a party, Your Lordship. Because we are not aware whether Mtron does it or forest department does it, Your Lordship. The submission that I came to know that it's Mtron does everything. I'll make him a party if Your Lordship allows me. We clarified, Your Lordship, at least.
What is this? What is this? What is this tender for?
It's settlement. Settlement for mining contractor, Your
What
Lord.
was the last date of submission?
14/10, Your Lordship.
14/10. And when did you file your writ petition?
We filed a writ petition on
With Your Lordship.
10th of November.
10th of November.
17th of November.
Here's 10th.
10th of November.
As per this is 17.
Maybe. I'm a bit late, Your Lord.
Huh? 17 after a month.
And even the technical evaluation was completed on 16/10/2023, Your Lordship. Everything was completed by 16/10/2023.
Why did you come after so long? You,
I admit, Your Lordship.
then
But till then, as per my instruction, no LOI was issued, Your Lordship.
Huh?
The letter of intent was not issued till then, Your Lordship. That is why I preferred the petition.
but now letter of intent has been
After filing of the writ petition.
Huh?
After filing.
Filing of the
Yes.
petition.
So letter of intent has been
Issued
produced.
after filing of the-
Now what remains? There is no stay order also.
No,
No.
Then
Your Lordship may dispose it of with the.
right, another thing. Mr. R.R. Gogoi also submits that what did you say? The Amitron, what?
Mtron.
How do you-
AMTRON.
Yes, what was he doing?
He's the one who handles all the online auction process, Your Lordship.
Okay. Mr. R.R. Gogoi submits that the forest department has has nothing to do with the online process for collecting the bids of the various firms in respect of the NIT. Firms and individuals in respect of the NIT dated 18/9/2023. So he further submits that the selection process, what was completed by 1610? What was completed by
The
1610?
1610 opening and evaluation of technical bid.
So further, the opening and evaluation of the technical bids had been completed by 16/10/2020. While the present writ petition has been filed only on 17/10/2023. Next column. On considering the fact that the grievance of the petitioner pertains to his inability to submit a part of the earnest money on 14/10/2023. There seems to be considerable delay in approaching this court with regard to the same, as the writ petition has been filed only on 17/11/2020. Further, as the letter of intent has already been issued to the eligible to so and so, to so and so. This court is of the view that unless the successful bidder is made a party in the writ petition along with Amtron. Amtron, what is the full address? You give the full address here.
I'll give the first.
This writ petition cannot be effectively decided. Accordingly, in view of the reasons stated above, the writ petition stands dismissed.
The liberty, your lordship, if the liberty,
You put them, you make them parties, you file straight away.
the liberty has to be there, otherwise it may effectively.
They are not parties, no.
Yes, your lordship. They are not parties, but the relief will be same, so.
I have said that since they are not parties, it cannot be effectively decided. That's enough.
Give your. Obliged, lordship.
Huh? What is this? Yes.
My lord.
His case is, his tender was not accepted because of the DD being addressed to the wrong authority.
Yes.
Now his
Major defect, my lord.
major defect. Then, of course, his other stand is that the respondent number 9 did not submit 5 documents.
My lord.
But despite that, he was still given.
My lord.
So what have you got to say?
I've gone through it, my lord. It is only submit that some of documents the private respondent also not submitted along with the bid, my lord. But whether it is mandatory or not, that is a question, my lord.
You
But
see,
the-
there is a judgment of the Supreme Court
My lord.
which said that if a petitioner does not have the qualification, he
Yes.
cannot make a challenge
Yes, my lord.
to the others. Where is that judgment? That's fairly covered this case.
And also one Glodine Technofab is there, my lord.
Huh?
Glodine Technofab is also there, my lord, one judgment where Apex Court says, my lord, that it is up to the authority, my lord, whether the non-submission of document, etc.
Is ancillary or
Yes, that the locus judgment I don't have right now, but Glodine I can give the citation.
you give both.
My lord, lordship may kindly.
Release this matter again.
My lord.
Tuesday, when?
Yes, excuse him. On Thursday, your lordship.
On the prayer of the party, release the matter on
Thursday,
Thursday.
next day. Oblige.
Yes, okay, this item 24, you took it, no, Anupam? You took this item 24. Anupam, that lady had to do it. 24. No one has taken it. Aparna, we have to change it then.
It was assigned to you, lordship. Sundar.
Assigned to me. okay.
Yes, yes. There was a.
So basically, a penalty imposed,
My lord,
correct?
my lord.
Now, what is wrong with the penalty?
My lord, this is disproportionate, my lord, to the,
Disproportionate.
my lord.
That's your only ground.
There are other grounds also.
What are the other grounds?
The other ground is that, my lord, there is only this, if I can take you through this inquiry report, your lordship, page number 40A, my lord.
40, yeah, yes,
Can I read, my lord,
yes,
from point 14?
yes.
It says the PW3 in a statement is stated that.
Can we go into the merits?
My lord?
Can we go into the merits?
That is in-
You see, I mean, the later judgment also, if you read,
My lord,
whether we can go into the merits,
my lord.
whether we are exercising appellate jurisdiction. Can we exercise appellate?
This will need a elaborate hearing, maybe fix it for
No,
hearing.
no, just tell me.
My lord.
Can we go into the merits of a case? Can we go into the evidence? What does the Supreme Court say with regard to this departmental proceedings?
Like to produce some judgment, my lord.
Then you won't produce. There are judgments galore against him.
My lord.
You've got to show us unless it's perverse, totally perverse.
My lord.
You've got to show that the procedure has not been followed.
The only finding is that the petitioner, he referred as, he spoke in a language called toy. In Assamese it is two. So that is the finding against me. Not other accusation has not been proved. That's what the inquiry report says. So that could have been an admonition, but the punishment that has been imposed, on page number 59, the impugned order, where my 3 annual increment has been withheld, which is disproportionate to the even the
What was the charge against you?
charge is misbehavior and evasion of duty.
What duty?
Duty that I was asked before 1 day before Independence Day to arrange the for the Independence Day, which includes to inflate the balloon and to decorate and all. So those has not been proved in the hearing.
Who are you? You're a policeman or what are you? No.
Zari Karok, Milam.
Huh?
Zari Karok of the SDGM Court, Bokajan.
What is that?
Process server.
Process server.
Process server.
My lord.
And he's been asked to because of not blowing balloons.
No. Milord, what happened, Milord?
That is for the decoration. my lord,
Before
one
the
of the-
Independence Day, Milord, some preparations were going on. On Milord, previous day, 14. So all the employees of the court, Milord, they were engaged in some work, Milord. So work, he was also
So
asked
is that part of his official work?
No, that part the enquiry officer has said, because the entire thing ignited from that, the subsequent. So he was directed to do some work. He did not do, he wanted to leave early. So the complainant who complained, Milord, he was the senior officer. He said, you wait for some time, all are there. I'll give you some other work. So he said, I cannot blow balloon because I have breathing problem. So he was to given some other work. That part the enquiry officer has held that yes, no specific, there is no material that specific work was given to him. So it cannot be concluded that he has denied to do some work or not. But from that thing, the situation became worse.
Escalated.
Yes, he will not misbehave the senior officer and what's are there? And that aspect has been proved by other witnesses. There were 2 witnesses, Milord. So if we go by the preponderance of probability, we cannot go into the sufficiency of evidence, Milord. If we go by, because evidence is there.
But it has nothing to do with his official work. Is it?
No, insubordination and misbehavior is there, my lord. Whether it's official or unofficial, but the allegation that he misbehaved, that was true. Whether he did his entrusted work or not, that has been held to be not true by the inquiry officer. Two parts of allegations are there. So that he misbehaved the senior officer, that was proof, my lord. That
Okay, it
cannot
takes
be-
some time. We'll just, okay, that, just right. On the prayer of the parties who submit that pleadings are complete, this is the,
Fixed for hearing.
this is the matter for hearing in usual course.
Rule issue for fixing hearing. The rule has to be.
There is a rule is issued, this is the matter for hearing in usual course.
Earlier.
Item? Item?
May I please want me to the matter, an old matter which arises just after COVID, there was a municipal corporation in a place called Bongaigaon. So the municipal corporation was not functioning and the DC was in charge. Thereafter, when the lockdown was lifted, they called for elections. And in that period, respondent number 3, who's the executive officer, was appointed to take charge of the municipal board and run it. He also called for tenders. So the first tender was cancelled by him. And a second tender came where I was the highest bidder for 2 out of 7 parking lots in the city of Bongaigaon. So instead of declaring me as the highest bidder and whatever at that time and publishing the list, they decided to wait where the election winners would be sworn in the municipal board or municipal council, and then they would publish the list of successful bidders. Now, the moment they were sworn in, being from a particular political party, they decided my blue-eyed boys should be given the tender. We'll cancel this tender. I came to this court, obtained the stay. We were supposed to hear the matter early, but on numerous occasions, time was taken. So that period of 11 months, 21 days, which was supposed to be for the period of tender, is long over. But one question that is left is when the model code of conduct was there and the executive officer was performing the duties in charge of the municipal council, he calls for a tender legitimately. He takes a decision that he opens the tender, he publishes the list that these are the highest people. There's only a declaration that this one is to be the highest bidder. Suddenly, when the political people come in, they said, no, you go, we're going to cancel all this. So that was my grievance, that was the model code of conduct violated or not? If it was violated, when the executive officer had absolute powers over the executive board, council, and he was taking the decisions in propriety.
But that is not the case here.
That was now, that has become the case, my lord.
No, how can that become?
Let us see, I'll tell your lordship, in my prayer, at that time, we prayed for a rule to show cause why a writ in the nature manner should not be issued to allow the highest bidder to be allotted the tender from the date. Forbade from recalling, cancelling, or giving to highest bidder number hearing matter, make the rule absolute, declare and so, to bring the case under the umbrella of respondent 1. Respondent 1, my lord, who runs all the municipal board, because we have to bring the highest revenue to respondent 2.
So the last
And
tender.
restrain from further interference in the process of market tender for the financial year 22-23, white tender number so and so. And 25th March 22 as declared on 7th April. And to pass, that was the period when we had prayed for. Subsequently, my lordships had asked in between, because this question of, in the new election process, when the executive was put as the thing, as the in charge of the municipal board, was he acting improperly or he was acting properly, and whatever decisions he took, can that be cast aside by the duly elected board? My friend, of course, came much later in the picture, but there was a government council present when my lordships had raised this question.
So that the earlier NIT was for a certain period.
Certain period, 11 months, 21 days,
Now that period has gone.
that period is gone.
Now
Gone,
what
gone,
remains?
gone. But they've not,
and my
they-
lord,
may I finish?
Yes.
Allow me to finish. Yes. If my friend would give me the leeway. So what they did was 5 other parking mahals they gave in tender. My two mahals which were unstayed by my lords, they continued collecting far below what the parking fees were. And they've got my earnest money also for the last so many years. So the only question left is now whether that tender should be allotted further in terms of the municipal act.
But once the period has gone,
Yes. Period is gone, but it is
fresh
well,
tender.
the matter was to have been heard and disposed of, but
my lord,
as the
only-
record shows, my friends have taken time for one ground or the other for almost 2 years.
My lord, your lordship may just produce the order the 27 5 2022. As spread by Mr. P.N. Chowdhury, learned counsel for the petitioner, the case leaves the case on 24/6/2022.
This 27?
My lord, this is my lord 27, my lord 5. My lord.
Okay.
This was my lord as per prayer of my lord.
Perhaps my friends, my friends junior would explain,
And dear,
explain, calling me and asking me for
26, my lord, 26 June, my lord. Another prayer, my lord. PN Lord Council put applicant list the matter on part of the last part of August.
now, my lordship.
Now, again, my lord, I'm reading. I'm this, my lord.
Now,
And as-
lordship would pause for a minute.
This, my lord, this.
My friend has called me up.
Already over, my lord.
My friend has called me
Where-
up and asked me
where
to
it is,
take
ma'am?
time because they've had an accident in the court while coming to the court. Somebody's wife is going for medical treatment.
It is
Are we not supposed to help each other as brother councils?
My lord, this, that
The
period-
court has
the
recorded
period is
my
already
name
over.
because the absence of the other side.
Period is already over.
We should never cooperate with giving a request from the other side.
It is reflected in the record,
Maybe reflected in record, but my friend would clarify to the court, place it in proper perspective.
And my lord, already is 2023 March, it is over.
Was the other side present
No, no,
on that day? Was the other side present?
Just a minute, just a minute, just a minute.
Why call and ask me to?
It reminds me,
cooperate?
it reminds me of last Saturday when I went to the ghat to buy fish.
My lordship.
Everyone
is-
shouting.
Well, lordship.
And
Lordship
then,
is having
and
the
then
fish.
they were shouting so much, I had to buy, I just bought the small fish and went home. I wanted to buy a big one. That's it.
My lordship saw the fish in its proper perspective. It was
No.
not smelling to high heavens as my friend's arguments are.
No, now you see, the thing is that all said and done, the fact remains that the NIT now,
Yes,
that
yes,
purpose is gone.
Purpose is gone.
Unfortunately,
I must place my duty to my client
so,
before
so
my
now the
lordship.
only thing remains is fresh.
Yes, my.
And what about the NIT that you have, the earnest money?
With interest.
Well, it is there, my lord, then my lord, he'll get my lord, as per law, my lord, whatever it is there.
You give interest also, he'll be losing.
My lord, if it is there, they will get my lord, because my lord, they.
He has to give interest because there are
my lord,
time
what
taken
happened,
by them.
initial first one, my
reply.
lord, it was my lord, when the executive officer was there, my lord. To cancel the first one, my lord, they have no problem. Subsequently, the another was my lord, then the problem arose, my lord. And here they are.
But if we allow the interest, then it will be, other cases also will have problems.
Yes,
Yes, my lord.
Will
that's
have problems.
precisely what my friend doesn't place before my lord.
My lord, regarding the allegation.
We can't
political
open the
party, my lord,
floodgates.
there is no which political party, my lord, there is there, my lord. Only-
Well,
only-
if the
only
first order of stay would show,
It is, my lord,
first order of stay, my lordship would read. It is on 29th of April 2022.
Now,
What you would see at the bottom of the first line, petitioner claims that this time also the petitioner is declared highest in the respect of the two mals, namely so and so. According to petitioner, he reliably learned that to settle the said mals to some blue-eyed boys or the members of the board. This time also the board is trying to cancel the NIT and float a fresh.
blue-eyed boys and political parties, my lord.
But what
Yes,
to do? This is
yes,
gone. It's
yes.
from 1st April 22 to
yes,
31st
yes,
March
yes.
23.
So new press.
That is what they've been wanting. They've
What
been
to
wanting
do?
to
Mr.
help their
Chaudhary,
own
what to
people.
do?
We have no choice in the matter. And my lordship would appreciate as a long-standing member of the bar, and at bar, my friend has shown my lordship's orders where I have submitted for time. It is at the request of them, my lord. To accommodate fellow counsel, I had to stand up because they can't get a lawyer to take time for themselves. I'll never accommodate again, ever.
What?
It makes a mistake, my lord.
So they've taken you for a ride.
They've made a pagan out of me, my lord. In this,
How come the young ones have taken you for a ride?
always, my lord. Always we accommodate, my lord.
You're supposed to be a wizened old man by now.
We're still young at heart, my lord. Still young at heart.
Okay, right. What to do? Unfortunately, what to do? It's all gone.
Lord.
Right. Heard Mr. P. A. Chowdhury, Leonard's counsel for the petitioner, and Mr.
Estimate.
Estimate, Leonard,
Leonard,
TDC,
Not,
No.
not chasing, my lord, for the municipal report, my lord.
for the respondent,
Yes, my lord.
all respondents,
My lord, 2, 3, 4, my lord.
for the respondents number 2, 3, and 4. So the petitioner's grievance is that despite having been declared the highest bidder in respect of 2 mahalls, regarding parking place in terms of the tender notice dated 29/1/2022 for the period 1/4/2022 to 31/3/2023. Come on. The petitioner was not oh, the petitioner was not settled, was not selected as the settlement holder for the 2 mahalls. Subsequently, another NIT was issued on 25/3/22. That is
Declared
this
on
page.
7th April.
25/3/22.
And declared on 7th April.
25/3/22 for settlement of the same mahals for the period from 10/4/22 to 31/3/23. Wherein the petitioner was again declared the highest bidder in respect of 2 mahals, namely Chilare Daily Market and Chilare Parking Mahal. As the petitioner came to learn that the 2 mahals were going to be settled with some blue-eyed members of the Bongaigaon Municipal Board by cancelling the second NIT dated 25/3/22, the petitioner approached this court by way of the present petition. This court, by order dated 29/4/22, passed an interim order directing the Bongaigaon Municipal Board to not proceed with a fresh NIT. Next. Subsequent to the order dated 29/4/2022, various no, the case has been listed on various dates and adjourned time and again due to various reasons. As on date, full stop. Next para. Today, when the matter is called, it is seen that the period for which the NIT dated 25/3/22 was called has long been over. That is on 31/3/2023. Full stop. In that view of the matter, this court is of the view that nothing survives in this repetition. The as such, comma, this court is of the view that a fresh NIT should be issued by the Bongaigaon Municipal Board. For settlement of the different mahalls / parking space. And the same should be, especially with regard to, and that's all. That's the tender notices for the mahalls and the conclusion of the selection process should be done within a period of within 31st March. 31st March 2024.
And my earnest money with interest.
No,
The-
no requirement that they'll first.
The earner,
If they apply for phase tender, no, not required to deposit earnest money.
no, the earnest money deposited by the petition should be returned to the petition.
His submission is that in case we apply for this present tender, fresh tender, then there's no need for us to take out our earnest money. That may be there, gives us a chance.
Full stop. However, earnest money need not be returned to the petitioner if the petitioner applies for submits his tender for the new mahalls which are to be settled in terms of the NIT to be issued by the municipal board, as Mr. S.K. Medi has stated that it would not be required for the petitioner to, as it would not be required for the petitioner to submit any additional earnest money for the new tenders.
Yeah.
That's all.
Deeply obliged.
I'm extremely sorry, Lordship, I was not there.
Yes,
Lordship, here, though there is this agreement, the point I want to hesitate, Lordship, is that Lordship may take the judgment of Vidya Drolia 2021 to SCC 1, paragraph 78.
What else?
Lordship, I have given the list of both.
He wants arbitration, correct?
Yes, but here, Lordship, it's regarding the non-delivery of the flats within a stipulated time. Now, there is a lot of other litigation that has been going on regarding this project. And there are some other flat owners who have approached RERA already. So, Lordship, here, if it is about the interest, now RERA is a statutory body which has been made under the rules.
Why are you not giving the flats?
Actually, Lordship, what had happened is that we were, the occupancy certificate and everything was supposed to be procured, but there was a wall constructed by, there are two, the facts is that there are two phases in this project, phase 1 and phase 2. Phase 1 was the Games Village people, where they were already in possession of the flats. They constructed a wall in between.
Who constructed the wall?
Phase 1 owners of that Games Village. So due to the construction of the wall, the fire licenses was not given to us. And due to that fact, we could not get the occupancy certificate. And since there was no occupancy certificate, we could not have delivered the.
So what action have you taken against the wall?
Against that, we preferred the GMDA, they issued a demolition order. Against the demolition order, the residents of Games Village, they came to the court. The court issued a stay order. We fought for about 1 year. After that, just on 30/11/2023, that order was vacated and their petition was dismissed. Now that wall has been dismantled, now the thorough passage is done. Now we are, within 10-15 days, we are getting the fire license. That is my instruction. and we'll be giving the occupancy certificate. So that is the
Lordship,
present
my
scenario.
dispute is not regarding the possession of flats, because for that, as my learned senior submitted, the other occupants have already moved RERA. My dispute is only for the delay that has occurred. I am entitled to compensation in terms of the section 18 of the RERA Act, as well as the condition of the agreement. So I just want the damages part to be adjudicated by the arbitrator. That's it. I'm not seeking compensation.
For that, what I'm submitting, Lordship, is that RERA, there is a act, there is an authority. There is an authority, RERA authority. Then there is an appellate authority. Against that authority, there is an order before this honorable High Court will be approaching. Now, if there is an arbitration proceeding and some amount is fixed up, there will be a difference of interest amount, difference of compensation. This is the aspect which I wanted.
As
Now,
long as the flats
if
are
you-
not
if-
handed over
if-
to us,
And the flat will be handed over. Now they are talking about the interest part. Now what will be the interest till
only
what?
the compensation or interest, compensation.
Compensation is under the RERA Act only they are seeking,
And
which
also
stays in the
also
authority
for the
altogether.
contractual terms, Lordship.
Section 7,
There is a
point number
contractual term
78.
in the agreement as well that we will be
Huh?
entitled to. There is a contractual term in the contract itself that in case there is a delay, we will be entitled to compensation. And since the
this,
delay has been occurred, they are not paying us any damages.
so this delay part and other things.
No, so what is your case? That he should not go for arbitration, but he should go under RERA?
So Lordship, that question as to whether in view of the arbitration clause, in view of the RERA provision, can arbitration be invoked or not, was recently answered by the Honorable Delhi High Court. Regarding length,
First,
Just a minute,
Yeah.
one at a time.
it's a long judgment, Lordship. Paragraph 78 bills.
Yes.
In view of the aforesaid discussions, we overruled the ratio in N. Radhakrishnan, inter alia, observing that the allegations of fraud cannot be made a subject matter of arbitration when they relate to civil dispute. This is a subject to the caveat that fraud which would vitiate and invalidate the arbitration clause in an aspect relating to non-arbitrability. We have also set aside the full bench decision of the Delhi High Court in HDFC Limited, which holds that the disputes which are to be adjudicated by DRT under the DRT Act are arbitrable. This is one aspect, which are to be adjudicated by DRT are arbitrable. That means they are not arbitrable. They going to the DRT Act, that is not arbitrable. The same I'm saying, since there is a RERA Act and points are, it has to be first looked at by the RERA authority, then there will be an appellate authority. So these are all given in the Act. Second point, landlord-tenant disputes governed by the Transfer of Property Act are arbitrable as they are not actions in rem, but pertains to subordinate rights in personam that arise from rights in rem. Such actions normally would not affect third-party rights or have agra omnes effect or require centralized adjudication. An award passed deciding landlord-tenants dispute can be executed and enforced like a decree of a civil court. Landlord-tenant disputes do not relate to inalienable and sovereign functions of the state. The provisions of the Transfer of Property Act do not expressly or by necessary implication bar arbitration. The Transfer of Property Act, like other acts, has public purpose, that is to regulate landlord-tenant relationship, and the arbitrator will be bound by the provisions, including the provisions which inure and protect the tenants. In view of the opposite, we overrule the ratio laid down in Himangini Enterprise and hold that a landlord-tenant disputes are arbitrable as transfer does not forbid or foreclose the arbitration. However, landlord-tenant dispute covered and governed by rent control legislation would not be arbitrable when specific court or forum has been given exclusive jurisdiction to apply and decide special rights and obligations. Lordship. So this is my. So when there is a.
But is there any rent control legislation involved here?
This is the I'm trying to bring a parametric kind of a thing where
Where is the connection?
this is a RERA Act. RERA Act provides for compensation as well as interest.
When there is what? When you don't provide the flats in time?
Yes. Okay. This is that is the point which
Show me the act.
Section 18.
Not, this thing, that item 24, we have changed the order, huh? You know that, no? Anupam is taken it. I don't have a copy, it appears.
I have a soft copy.
Section 18, Lordship.
Yes.
If the promoter fails to complete or is unable to give possession of an apartment, plot, or a building in accordance with the terms of the agreement for sale, or as the case may be duly completed by the date specific therein, or due to discontinuance of his business as a developer on the account of suspension or revocation of the registration under this act or for any other reason, he shall be liable on demand to the allottees in case the allottee wishes to withdraw from the project without prejudice to any other remedy available to return the amount received by him in respect of the apartment, plot, building, as the case may be with respect, as the case may be with interest at such rate as may be prescribed in this behalf, including compensation in the manner as provided by the act. Interest as well as compensation have been provided that where an allottee does not intend to withdraw from the project, he shall be paid by the promoter interest for every month of delay till handing over of the possession at such rates as may be prescribed. The promoter shall compensate the allottees in case of any loss caused to him due to defective title of land on which the project is being developed or has been developed in a manner as provided under this act, and the claim for compensation under this subsection shall not be barred by limitation provided under any law for the time being in force. If the promoter fails to discharge any other obligation imposed on him under this act or the rules or regulations made thereunder, or in accordance with the terms and conditions of the agreement to sale, he shall be liable to pay compensation to the allottees in the manner provided by this act. So if any other terms and conditions are also provided here.
Where is the arbitration clause out here?
Lordship, it's in page number 59
59.
of my arbitration petition. Yes, sir.
Lordship, may peruse
Lordship,
the legal
the-
notice
Lordship,
once
the
more. as-
question that they are raising, the main objection as to whether in view of the RERA Act and arbitration invoked, Lordship, that has been answered very recently. Lordship, I've just placed a judgment for Lordship by the Honorable Delhi High Court.
but that's a Supreme Court judgment.
Lordship, but it has discussed the Supreme Court judgment
That
as
could
well.
be,
And I'll come to some other appeals judgment as well.
So
Lordship,
that-
kindly peruse.
How much time will you take?
Lordship, it takes it's a long judgment. Lordship, there are also Supreme Court judgments as well.
A lot of, can we put it for some other day because there are a lot of matters.
Lordship, they kindly fix
That-
it next
that
week because
aspect
Lordship,
which
for the last 3 occasions, we have been seeking time.
no, I have not sought time today.
And not.
So I
Because I don't think, I think it'll take some time.
yes, Lord.
Yes, Lord.
Let me fix my hearing date.
We have fixed a lot of matters.
Lordship, I'll quickly wrap it up, just this, I'll satisfy Lordship just in 2 paragraphs, Lordship, in the.
Because here again, I will not have to discuss if I'm placing reliance on Vidya Dolia, the other judgments which they have overruled. That aspects has to be also looked in, which I have to read.
They only has
This is,
been
I'm just
considered-
giving an overview of the.
Okay, we, Delhi High Court, which judgment?
Lordship, Priyanka Taksud and others versus Sunwal Residency Private Limited. Lordship, SCC 2022 SCC online 4717. Lordship, I'll not waste much of your time. Lordship, may kindly come straightly to para 32.
Yes,
Possibly disposing.
let us see. Let us see.
Because this judgment would be again, that's a Delhi High Court judgment.
I'll come to that, Lordship. Then judges.
No, the problem is, yeah, you see, now the manner in which you are going about things is they are referring to various other judgments.
Yes, Lordship.
So we will have to backtrack
Yes, Lordship.
and
That's the
then
point.
go into those other judgments
Yes,
also.
Lordship.
Lordship, the problem is that we.
There is one thing, no doubt, okay, there's an arbitration clause there. Arbitration clause can look into the issue, but the judgment that he has produced basically states that when RERA can look into it, then those cases are non-arbitrable.
Lordship, but again for that.
This again,
16 is there.
it is created in under the Supreme Court judgment,
Lordship,
which
there is
is
a question is
NTPC.
whether the
Again, I'll,
dispute is arbitrable or not. So the dispute, when is arbitrable or not, is writing them or writing personal. That is a simple question that needs to be answered. Even this judgment, Lordship, that isn't answered. Lordship, can I have a look at the judgment? Lordship, para 32.
Yes.
Delhi High Court, para 32. May I read your Lordship? From the foregoing, there is no doubt in the mind of this court that giving a purposive interpretation to section 79, 88 and 89 of the RERA Act, there is no bar under the RERA Act from application of concurrent remedy under the Arbitration and Conciliation Act, and thus there is no clash between the provisions of the RERA Act and the Arbitration and Conciliation Act, as the remedies available under the former are in addition and not in the anticipation of the remedies available under the Arbitration and Conciliation Act. Lordship, may kindly come to para 40.
No, I'm just a minute. First of all, this is not a landlord tenant dispute.
no dispute, no dispute.
Okay, so that part of the issue is.
That is no
Okay.
dispute.
Now, out here, there is nothing relating to fraud. There's nothing relating to fraud. Then
Lordship, in fact, the same judgment.
My contention is, Lordship.
no, another thing is that your judgment appears to show that disputes which are to be decided by DRT, they are not arbitrable.
Under section 16(2).
It does not talk about disputes which can be decided by arbitration also and by the DRT also. It basically, I mean, subject to correction, it appears to show that which are exclusively tribal by DRT, they are not arbitrable.
Lordship, to that we may submit, Lordship. Now, what are the disputes to be dispute that has to be adjudicated by DRT? That will be in the Act. So, the same way, what are the disputes will be adjudicated by RERA? That is given in section 18. This is where I am trying to draw. It's
that-
in the Act. It is not
Lordship,
That's section 18 again.
Lordship,
DRT will not.
I think it'll take some time.
Lordship.
I can understand where you are heading. Only problem is it'll take some time. I don't think we'll finish in within the.
The withdraw Dolia judgment itself is a long.
Lordship, but Vidya Dolia is being kind of misinterpreted in a way.
You see, the problem is that you both know the law. I am going to be, now I have got to be led by you. Either you take me up the right garden path or you take me on the wrong garden path till I find my way. I have to follow you both. So I'm the blind man and you are the one with the open eyes. So I'll have to go either this way or that way. So I have to be, I'm not, I've got to read a little more than you all. We'll adjourn the matter.
Lordship, may kindly fix a date.
When do you want? But when are we free? Before 15th or Wednesday? 22. 22?
Lordship, can we have a little bit?
22nd, February.
Lordship, can we have it in the next week or maybe the after week after?
We have fixed lot of
After
matters.
after 14, Lordship.
15th also we have fixed. I remember we have fixed a lot of matters.
Even if it is listed, if it does not come,
Fine,
it'll
Lordship,
it'll be the same thing.
22nd we'll do, Lordship.
If it is listed and it reaches around 3:30, it'll be the same story again. Again, it has to be-
No, but then, you see, if we fix, then we'll.
And that's what,
We'll try to
let
fix.
it be a date where,
22nd will be very welcome.
It's a hearing date.
no,
It's
it's
a
not a
hearing
hearing date. 20, oh, sorry,
Thursday, it's a
24.
hearing.
Thursday.
Oblige, Lordship.
And the party leaves the matter on.
Briefly, I'll let.
They'll see.
Lordship, may kindly
We
have
have we don't have a date prior to that, no? No. 20. 20. Okay, 20.
Lordship. Lordship, may kindly have it in the higher up the list. Because it's going to take some time.
No, hearing date, I think we'll somehow try to manage.
Oblige, Lordship.
You see, all the cases are important here. Everyone is
Very
worried about their tender, and it's all about money.
Very well, Lordship.
That's why all the good lawyers are coming here.
Oblige, Lordship.
And we are the ones racking our brains.
That is Lordship. In this case, petitioner is agreed with the order of the district collector directing to shift our IMFL shop.
They have been issued a notice
Yes.
to
No,
shift.
I was not issued a notice.
They've given an order to shift her license shop from one place to
License-
another.
Yes.
Okay.
Now, she was initially issued license in the year 2014. Thereafter, as per the Supreme Court order that it should be 220 meters away from this national highway, it was shifted in the year 2017.
But that will not apply to municipal
Yes,
areas.
it's not like a municipal area.
It is outside municipality.
Outside.
So it was shifted in the year 2017, and at that time there was an inquiry was done, conducted. I have annexed the report also, Lordship, says it is away from the 220 meter.
Then
2017.
So-
Now thereafter in 2022, this on-shop license was converted to off-shop,
on to off.
on to off.
What is on? What is the difference between on and off?
On is, they cannot
On is a bar,
bar.
off is a wine shop.
Okay.
So in 22, again inquiry is conducted.
So
Because-
the conditions remain the same.
Conditions remain the same. In 22 also, I've annexed the sketch map, which shows it is away from 220 meter and there is no religious place within 150 meter.
How is it? How is that 220 meter like this? Going like this?
Yes, it is like a road.
No, is it like this? Like within this room, you make it 220
No,
meters,
front
you
gate.
go like this, then you go
No,
one
it should be
feet, then
from
come
front
like
gate,
this. Is it
front
like
gate.
this? Oh, as a crow flies, how is it?
Front gate, Lordship, front gate road,
Straight lines.
straight line, straight on a road, how road goes.
No, say supposing 220 meters. Does it go right? Then after 1 feet it goes left, and after 1 feet goes so
The way road goes, Lordship.
Okay.
The way road.
the way the road goes.
Now, recently, this is 11 August 2023, this order was issued saying that space 33 is the
Page?
33
Yes.
is the imperial order. It says, Lordship, may I please read it?
Yes.
Seen the public complaint petition and the enquiry report submitted by the Inspector of Excise, Hailakandi dated 13/12/2022, which states that within a range of 100 meters of Mrs. Marine IMFL offshore located at such and such area, there are 2 Kalimandis and 1 mosque which violates Rule 289(1) and 2 of Assam Excise Rule 2016. Moreover, as per report of the executive engineer PWD Rural Division, Hailakandi, the IML office is located at a distance of 198 meters from the outskirts of National Highway, which violates the Honorable Supreme Court's verdict on distance criteria. So therefore, it has been directed to shift. Now, this alleged report is in conflict with the earlier two reports. I was not issued any notice to for any hearing was done. Nothing. At
When
that
is the
time,
earlier report?
as page 25 is the first report 2017. Paragraph 4 orders may be lodged. I personally inspected the location and verified documents. Thereafter sentence starts, there exists no religious.
Yes, what to do then?
There exists no religious. There is no religious
Also, okay, so this report is in your favor.
in my favor.
Now, what is to be done? What is the solution?
Solution is this import order has to be set aside because it's otherwise also it is bad. Because
So should there be a fresh verification? Or what?
There can be fresh verification.
there can be if they intends, but
So,
my prayer would be there may not be any order from this honorable court for fresh verification. If they are in free to liberty at liberty to done it, but whenever they take any decision to fresh verification, I may be hurt. Notice may be issued.
you take part in the verification also.
Yes.
You be a part of the verification team.
Yes.
Very well.
But
Fresh
why is it that first you have allowed and now you have taken a different stand?
That's
But
the thing.
two occasions it was allowed. 22 also.
And the petitioner saying he was on show cause and he wasn't show
Huh?
cause. He was on show cause regarding this second verification
Yes.
report, your lordship.
So 17 is in his favor, 2017.
Yes.
And where is
22
the
also.
first one?
First one is 17, Lordship.
Second
in
one
the
is?
present side. And second one is page 32. I annex this sketch map report.
Okay.
I did not get, but sketch map.
Sketch map made by whom?
It's by the,
Assistant engineer.
No, they are not interested party.
no, they
I
are
mean,
not.
this is not the excise. There is some friend of yours must be a childhood friend
No,
or
it
some
was-
engineer.
No, Lordship. It was at the inquiry was made
By whom?
by the this excise office, and sketch map was always prepared by PWD.
Acha, sketch map is always prepared by
Yes,
PWD.
this verification, this measurement, etc. It's by
Okay. So this sketch map at page 32 is against you.
no, it's my paper.
It's in your favor.
It's my paper.
But there's nothing to show that it was made on the behest of the excise person.
It relates to Lordship, it has date may be taken 8/8/2022. It's related to page 22 to 27. There is my off license. When it was converted from
On
on
to
to
off.
off. Right to that it was done.
Yes. What is this?
19.
198.
It is wrong. There is a 220. It is already there from the edge of the, this is from the outskirt. What does mean outskirt? It should be edge of the national highway.
Maybe you have not given money.
Let it go for fresh verification, lordship. Fresh verification will be better.
Or we set aside this and say that without notice.
Set aside this order.
They are at
Will
liberty
fresh
to-
verification.
Yeah, you do whatever.
Yes.
But in the event that
Otherwise, lordship, as per that particular order reflects that lordship. It's lordship. Within 198 meters.
correct, Mr. Council.
Lordship.
But then what about your earlier order of page 25? Is this a wrong order? Have you taken any action against that official? who has passed?
25 lordship, it's a official of the excise department. They have.
Correct, correct,
It was done.
correct.
Excise.
So this is also excise branch.
On the
Page
basis of,
33 is also excise branch.
on the basis of this report, it has been transferred to shifted to
You
the
see,
present
you
side.
cannot say your earlier order was wrong.
I am not saying that, lordship. Otherwise,
Then-
it's a disputed question, lordship. So, lordship, in that particular order, it says that it is within the 198 meters.
No, you see, one thing is that when you have given him permission 7 years back or 6 years back,
Lordship, it's a report by the inspector of excise. Otherwise, lordship, the distance was made by the PWD Rural Division, lordship.
so
It was by the PWD Rural Division, lordship. The report was as per the imping order, lordship. Order says that, Lordship.
So the
What about-
report at page 32 is not in your favor, it is in his favor.
No, page 33 says that, Lordship. May kindly perish for a moment, Lordship.
Mr. Counsel, you are arguing or he's arguing? Who is the counsel? You are for whom?
I am for the persons who have issued the imping order, Lordship.
You're for the excise.
No, I am for the deputy commissioner.
You're for the deputy commissioner. Now deputy commissioner excise branch.
Lordship.
You're for the excise branch or not?
Excise branch, but otherwise deputy commissioner we are representing. Lordship.
Okay, you are representing, but this is by the excise branch of the deputy commissioner. Now, tell me one thing.
Lordship.
When the government earlier says that this is a blue pencil, blue and red pencil,
Lordship.
now it is correct or not?
It's correct, Lord. It cannot be.
Now,
Lordship.
supposing the same pencil, after 10 years, this is no, now this is a blue and yellow pencil. Is it correct? Which one is correct?
It cannot be. My argument is not at that, not in that particular line, Lordship. I have said that, Lordship, the particular inspection report was given by the excise department, Lordship. Now the imping order is passed on the basis of the, Lordship, the report submitted by the executing the PWD well, Lordship. Who can, Lordship, measure the distance, Lordship? It's not.
So
for the
you
excise-
couldn't measure the distance.
Lordship.
You cannot measure the
No,
distance.
no,
Excise
it-
cannot. DC cannot.
I cannot say
The
that. Lordship.
inquiry has to be made by the excise department that
Come
takes help of
Let
the.
us not insult each other's intelligence. Anyway, right, heard Mr. Hmm?
SD Purkar.
SD Purkar, learned counsel for the petitioner. Also heard Mr. R.R. Gogoi, learned counsel for the
Respond number 1, 2, 4, and 6.
1, 2, 4, and 6. And Mr. K. Gogoi, learned counsel for the respondent number 5. 5. Yes, Mr. K. Gogoi, here for
Is for 3.
3. Who is for 5?
PWD.
And Mr. B. Gogoi appear for point number 7. The grievance of the petitioner is with the direction passed by the office of the respondent number passed by the office of the respondent number 3. In the order dated 11/8/2023, whereby the petitioner has been asked to relocate, shift the MS Marine IMFL offshore from Kalinagar Point -3, Roman 3, District Hailakandi, to a site which conforms to the excise rules and norms within 90 days. Full stop. Next paragraph. The petitioner's counsel subject that the petitioner had been running an IMFL onshore since
At the present site since 2014.
since 2014. And in the year 2017, the petitioner applied for shifting her IMFL onshore to a new location in the premises of Sri Rathindra De and Sri Jatindra De of village Kalinagar, part 3, PO Kalinagar, district Hailakandi, covered by DAR number 139 of Pata number 12. The new site was inspected and verified by the Inspector of Excise Hailakandi, who submitted his report on 28/8/2017, stating that
paragraph 4 and 5.
The proposed site was located at more than 220 meters away from the outer edge of the national highway and state highway. Full stop. Further, there was no IMFL shop within 3 kilometers.
There exists no religious and educational institution. The previous paragraph, Lordship, last sentence.
Further, there existed no religious and educational institution or hospital or nursing home within a distance of 150 meters from the proposed site, as envisaged in Rule 289 bracket 2 of the Assam Excise Rule 2016. The petitioner's IMFL shop was thus relocated to the new site, and the IMFL on shop was made into an IMFL off shop with the permission of the authorities. Full stop. Next paragraph. The petitioner has now been issued the impugned order dated 11/8/2023, asking her to shift her premises, her IMFL off shop on the ground that the report dated 13/12/22 submitted by the Inspector of Excise Hailakandi states that the petitioner's IMFL on shop is within a range of 100 meters from 2 Kali Mandirs and 1 mosque, which violates Rule 289 bracket 1 and bracket 2 of the Assam Excise Rules 2016. Moreover, as per report of the Executive Engineer PWD Rural Roads Division Hailakandi, the IMFL off shop is located at a distance of 198 meters from the outskirts of the national highway. Next paragraph. The petitions council submits that the impugned order dated 11/8/2023 should be set aside as no notice was issued to the petitioner prior to issuance of the impugned order, and neither was the petitioner made a part of any
This is the inquiry.
inquiry/verification team, which showed that the petitioner's IMFL off shop was in violation of the Assam Excise Rule 2016. Yes, what is your submission?
Okay, fresh verification may be done, Lordship. Fresh verification.
The counsels for the respondents submit that in view of the submission made by the counsel for the petitioner, a fresh verification may be held by the authorities concerned. Next panel. On considering the fact that the earlier report made by the Inspector of Excise Hailakandi on 28/8/2017 had stated that the petitioner's IMFL off shop location was in consonance with Rule 289 of the Assam Excise Rule 2016. It is not understood as to how the same shop could now be in violation of the same rules. In any event, no opportunity of hearing has been provided to the petitioner prior to the issue of the impugned order dated 11/8/2023, which is in violation of the principles of natural justice. Full stop. In that way, the matter, this court is of the view that the impugned order dated 11/8/2023 is not sustainable in law. The same is accordingly set aside. Full stop. In the event the state respondents are of the view that a fresh verification should take place, they should ensure that the petitioner is made a part of the verification team. The petition is accordingly disposed.
Highly obliged.
Where is the admission?
My lord, the liability statement page 23, my lord. Last page, my lord.
Yes, what is to be done?
Deputy Commissioner is the appropriate party. He can answer this.
Huh?
Deputy Commissioner is the appropriate. It's the main party. Lordship.
Main party.
Lordship.
Who is to verify the bills?
Lordship, Deputy Commissioner.
Now out here the
Water Resource is only the implementing party. Lordship. We are only the implementing agents.
who pays the bills?
Come to question. No, no. SDRF. SDRF. Deputy Commissioner.
Is Deputy Commissioner party here?
Yes, yes.
Who's the council? Yes, Mr. Gogoi.
Question may dispose of directly after verification Lordship. Otherwise, I have not received instruction. We have written letter on 7/12 Lordship, 22.
No, I want to know liability statement, okay. So 9, okay, right. This has to be paid by whom?
But Deputy Commissioner will pay. They will verify the bill and we will pay them.
Then why did you verify it? If they were supposed to verify, why did you verify it?
Lordship, page 22 Lordship, they have done Lordship.
That is what,
Page 22, they have done.
now he's putting the blame on you, that's why.
No, no, SDRF bills are to be paid from the Deputy Commissioner's account, Lordship, not from our account. We are only the implementing agency.
Verification part, they have done Lordship.
Completion report we have given, Lordship, that work has been completed because we used to verify, supervise the work. That is why we have given that report, Lordship.
Okay,
Lordship may direct on the basis of that report, they will verify and Lordship.
correct.
And submit report before the Deputy Commissioner.
No, they have already made verification.
Yes, that's
Now,
right,
D-
my lord.
now,
MNC
DC,
is
now
there.
DC will make a further verification.
Lordship.
Heard Mr.
R.
R. Sharma, learned counsel for the petition. Also heard Mr. K. Gogoi for
6. Lordship, I am for 6.
6 and Mr. for
1 to 5.
1 to 5. The petitioner has claimed release of contractual dues amounting to rupees
938,110.
9,38,110 for works done by him with the Water Resource Department, pertaining to the work of, invert commas, immediate measure to restore the damages, including road communication of Nagar Ali of River Desang near Borpathar and SDRF for 2017-18 bracket sub-estimate. That is in the last order, it is there, huh? Inverted commas close. The petitioner's counsel submits that though the work was completed in the year 2019 and the accounts officer and executive engineer Shiv Sagar, the Water Resource Division have made a no, and as the have made a liability statement showing that the petitioner is have made a liability statement showing that the petitioner is to receive 9,38,110 after completion of the work, comma. No payment has been made to the petitioner till date. Mr. R. M. Das, learned counsel for the water for respondents number 1 to 5, submits that the work completion report has been given by the executive engineer, Sibsagar WR division. And that the liability statement of the petitioner shows that he is to be paid 9,38,110. Mr. K. Gogoi, learned counsel for the respondent number 6, submits that. No, before that, you right? Mr. R. N. Das also submits that the payment for the contract work has to be paid by the respondent number 6. Next paragraph. Mr. K. Gogoi, learned counsel for the respondent number 6, submits that as the payment for the contract work has to be paid by the respondent number 6, the respondent number 6 will have to have a verification done on the petitioner's bills separately. Next paragraph. In view of the submissions made by the counsel for the parties and keeping in view the completion report and liability statement made by the executive engineer, Sibsagar Water Resource Division, comma. This court directs the respondent number 6 to verify the claim of the petitioner regarding completion of his contract work. So, if the verification shows that some contractual amounts are due to the petitioner for the contract work, the same should be paid to the petitioner by the respondent number 6, by the respondents, The entire the verification and the payment of the admitted amount should be made within a period of
3 months.
3 months from the date of receipt of a copy of this order.
Before 31st, my lord, because the.
Okay, within 2 months from the date of receipt of a copy of this order.
Hello.
Number 6, Lord.
Lordship, direct respondents authority because of the.
Yeah, respondent number 6, because we don't know. Someday it might be.
It might be there also.
SDRF payment are to be made from the deputy commissioner's office, Lord.
Lordship may indicate respondents authority, if we are liable, we will pay lordship.
Just in case. It's. Yeah.
Item 32 and 34 is similar.
Similar,
But whether 33 is wrongly being clubbed. So the
Okay.
petitioner is saying.
32 and 34 are similar.
32 and 34.
So 33 has to be taken out.
Yes.
33, you are in 33 also.
For 30 of the petition, my lord, 32 and 34 is similar, my lord, and 33 is also, it is this other part which I have already,
It is a different case.
different, my
Different
lord.
case.
So it has to be taken out,
Yes.
Yes.
So it will be taken up, but not clubbed together.
not clubbed together. Okay.
But in
My lord,
32 and 34, my lord, I prefer some further time to file a affidavit. Here, as per my latest instruction, my lord, the technical financial bid has been opened. The L1 bidder has been already recommended. Work order will be issued.
Then,
And on the last occasion in.
then it will become infructuous by the time we hear the matter.
Exactly, my lord.
No, no.
That's why that bill,
So-
my
Lordship,
my
you see
lord.
the order dated
financial-
22/12/2023. Last in this-
Yeah.
Yes, item 32. Interim was rejected. And it was dated.
Oh,
whatever-
rejected?
Yes, it has
But
been
the
rejected.
subject to the outcome of the
That
requisition
will
is
remain,
still here, my lord.
That will-
And my lord, there is a certain
outrightly
thing,
rejected on the very first day.
there is a certain things, my lord, the
Ah.
financial bid, the evaluation of the financial bid is yet to be signed, my lord. That's why I'm not praying for the regarding any type of interim order as of now, my lord. But regarding,
Therefore,
Yeah,
the
interim-
other assignment-
Your
I have
prayer
to-
for interim order already been
at that
rejected.
moment, my lord, my interim order was rejected. That's why I'm not coming for that point, my lord. But regarding the financial bid evaluation state, what they have to sign is not yet signed as of now, my lord.
That's a different issue.
Define it. And the third, it's a second, my lord, I have a request. So regarding, I want to amend some portion of that petition that may be allowed to
Up to him,
my
You have
lord,
to file an application.
application. Okay, and additional, if it I supposed to, I have to file, my lord. In additional for regarding some new facts, my lord. in
Ah,
this case.
that you can file. Abhi.
That's why, my lord, kindly
You
give me
see,
2 weeks time, my
instead
lord.
of that, if you're going to amend the writ petition in any event.
Yeah.
If you're going to amend the writ petition, you amend the writ petition.
Yeah.
Incorporating your additional facts also.
My lord,
Make it in the application,
my lord.
you put in what additional facts you want to put in.
Then, my lord, kindly allow me to for 2 weeks time for that month, fix a date, my lord. For that time, I can also file my affidavit for regarding the item number 32 and 34, my lord.
Ah, that's okay.
Okay.
But,
Then I come to the, my lord, on the 33.
just a minute. But by the, I think this entire thing is going to become infructuous. Anyway, right, heard the petitioner in person who submits that he would like to file an application for amending the writ petition. Mr. B. Gogoi appears for the state. In view of the submission made by the petitioner's counsel, this is the matter. After 2 weeks,
My lord.
Fix that, survey, dear, my lord.
give a date. Nineteen.
I'll develop, my lord.
That's for 32 and 34.
32.
33, what do you want?
33, my lord, there is a contextual matter for regarding the joint verification has already been done, my lord. Which has already been. I
Joint
have already
verification, what do you mean?
But
You-
regarding some
you have-
executed-
You've done the contract work.
No, my lord, what has happened is, my lord, he was found to be L1 in this particular tender, my lord, and letter of acceptance was issued. But
Okay.
there was a condition that he will have to submit additional bank, performance security.
Okay.
That he did not submit. Instead of that, he approached the honorable court challenging that particular, my lord, demand of the authorities. And that was dismissed by the learned single judge. It went to the division bench also upheld it. Thereafter, my lord, it was finally cancelled by the authorities.
Because he did not submit the.
Because he did not submit.
Performance
And,
guarantee.
and for that, my lord, it was retendered. Now, my lord, it has been allotted to a third party. He has already come, almost, my lord, 50-60%.
It is already been in the matter of
But now
record, my
the
lord.
petitioner claims that, my lord, moment that letter of acceptance was issued, he started a particular construction of a particular portion.
Due to
of
some
the work.
pressure by the
He is
department, my
claiming
lord.
that part. Whereas, my lord, there
And-
was no agreement signed, there was no
It
letter
is
to
the
proceed
formation
from the
contract
authorities.
was never been done, but there is a certain judgment of this honorable court, my lord, where is the LOA has been signed, measurement has been done, and the honorable court has directed the petitioner, respondent, to give the certain measurement of the payment and set aside the work order of some other contractors and allot the works to the petitioner. There is a certain judgment, I can produce the judgment of the same, my
No,
lord.
Mr. Counsel, let us be very clear of the fact.
Huh.
In 33,
My lord,
you were L1.
my lord.
You were what was the performance guarantee?
I'm just saying.
No,
few
Mr.
lines of-
Counsel,
My lord,
you see, sometimes you have got to hear us also.
my lord, my
Though your voice might be better,
lord.
but you have got to hear us also.
Sorry, my lord.
Because we have got to be clear in our facts also.
My lord.
Why I'm repeating it,
My lord.
so that I want to be sure that I am correct in the facts
My
of
lord.
the case. Now, there was a performance in the NIT, you were found to be L1.
My lord.
You were given the letter of acceptance.
Okay.
Correct? And you were asked to pay additional performance guarantee
Yes.
beyond what was
Unbilled
reflected in the NIT. Now, because you didn't pay it, they cancelled the letter of acceptance.
My lord.
Now, correct?
After he failed, my lord, before this honorable court. Thereafter, we have cancelled it.
Huh?
He approached the honorable court challenging this letter of acceptance.
Acha, challenging the letter of
Yeah, that was
acceptance.
upheld by the honorable
So
court.
that's this letter, so then this court dismissed it.
Yeah, dismissed.
My lord.
Then when was it cancelled? The,
Subsequent to that, my lord, when the writ appeal also was not entertained.
Then it was
dismissed.
cancelled.
It was cancelled by the authorities. because
okay, it was
of-
cancelled.
Yes.
My lord, LOA was for regarding the challenging of the, not for the regarding additional performance, arbitrary not of regarding the seeking of additional performance. That's why I'm challenging, my lord.
Hmm?
And honorable court has dismissed the plea for
Yes.
regarding not,
Release the file, no?
my lord, for regarding not
33.
challenging a particular clause, my lord. But after that,
33.
what happened, my lord? My rate was 17.86% below at the schedule of rates, my lord. And the work rate,
17 point something is 17 schedule of rates,
my lord,
provide that 10% will be contractor profit. So you are going below that also.
exactly, my lord. That's why the additional.
Anyway, that is not the issue now. Let us see.
My lord, I just wanted to say, which I don't want to disclose in the open of the honorable court. The same contract, even the same contract has been given by the authorities to some blue hat contractors by some political influence, my lord, at the rate of 10% of the estimated value of contract, above the schedule of contract, and the wastage of 5 crores has been
10% is allowed
10%
as per
above of the
CPW, as per
schedule of the contract, my
CPWD
lord.
manner it's allowed, I think.
Exactly, my lord.
Then,
That's why that arbitrariness which is still pending in this in front of in this honorable court, my lord. The petition number 6006, which I don't want to club this matter. This is a separate subject matter, my lord. In this subject matter, my lord, the joint measurement which I did at the instance of the and the emergent nature of the work and due to pressure of the respondents, I did that work. And the joint verification as per the honorable court has been done, my lord, on 14/12/2023. As per his letter is also there, my lord.
but you did the work, despite the no contract agreement being signed.
Exactly, my lord. LOI has been issued and the instance of the, there are certain
He in
certain
fact defined
documents,
PIL, my lord.
What is the amount of work?
near about 22 crores something,
Yes.
and I have
22 crores, you did
I
it
have
without
executed only
a contract
1.98
agreement.
crores, my lord. 1.98, I can produce the record of
According
the
to him, he has already constructed before, my lord, the dispute arose.
dispute errors.
And
That's
even
why-
before signing the, my lord, contract, he started the work.
And they have admitted it also, my lord. I can produce the records of the same, which is duly acknowledged by the honorable court. This is already
joint
part of the record,
verification
my lord.
done, my lord.
I think you
pursuant
should go to civil court.
to- Exactly, my lord.
No, my lord.
That is-
Actually, if the civil court, the contractor will complete the work and my matter would be infractions, my lord,
Mr. Counsel,
my lord.
you are right to do a particular work. Will only come when there is an agreement between the parties. You cannot do something on your own without any agreement.
My lord, that's why the certain judgment is there, my lord. Please have a look at that.
Please show me, give me the judgment.
I'm just reading the 11th portion of the judgment, my lord.
No copy for you. You have to
My lord,
listen by ear.
this matter is also pending before the division bench. Yeah, but-
My
But
lord,
the
please
issue was
come to
different,
page number 51.
That issue-
Ah, yeah,
Please come to page number 51, my lord.
51, okay.
And line number is 6, my lord. My lord, I have only highlighted the points.
Yes,
Shall I read, my lord?
yes, please.
At this court finds it relevant to take note of the specific query made to the learned counsel of the PWRT as to whether it is possible to award a contract to the petitioner on the basis of his bid. So submitted for the package in question, taking into account that in respect to package number AS 2198, almost, it is very important, my lord, 60 to 70% work have been completed. In respect to the other packages, some percentage of works have been completed. The learned Eastern Council for the PWRT submitted that a bids in respect to the packages in question are submitted item wise, and as such, that is his submission, my lord. As such, the work which has already been completed can be segregated and fresh work order can be issued after making the measurement. He submitted that the same principle would apply if the work is retendered. That is the submission by PWD. My lord, please after that, come to the para number, page number 53. From the bottom to line number 8, my lord. I've already highlighted, my lord. Shall I read, my lord?
Yes, yes.
Taking into consideration that the petitioner Muhammad Ziaur Pasha, which were technically responsive and the lowest, this court find no reasons why upon measurement of the work so completed in pursuant to the letter of acceptance dated 25/2/2021, issued which have been set aside herein above, the remaining work cannot be awarded to the petitioner by applying clause number 26.3 of the standard bidding document. The same thing has been happened with me, my lord. Consequently, this court therefore directs the PWD to make measurement
of the work done in pursuant to the letter of acceptance. That the same case, my lord, the formation of the contract was not done. In a letter of acceptance dated 25/2/2021. Thereupon, that is a relevant portion of the order, my lord. Thereupon, upon award of the contracts pertaining to remaining work in aspect number so and so package number in for the petitioner Jiaur Pasa, liberty is given to the respondent PW to take such action as advises in clause 26.3 of the standard bidding document. And as of now, my lord, that all the work order which has already been done, already been issued to defined parties, has all are set aside and allotted to this the petitioner, that is Jiaur Pasa. And he has already in the job, my lord, and completed the works also. It is further made clear that it is a relevant portion of the same page, my lord. It is further made clear that in the eventually the petitioner Mr. Jiaur Pasa is not agreeable in terms with the exercise carried out under clause 26.3 of the ITB, as well as the measurement of the work carried out by the respondent PW. The respondent would be at liberty to phrase tender for the remaining portion of the work in respect of packages. In that regard, the petitioner shall be entitled to the full refund of his unnecessary debt. It's a bad question, my lord. After then, my lord, the page number 59 and pair number 4 is important, my lord. 4, 5, and 6, my lord. Where is the, my lord, I just wanted to tell you, my lord, where the same judgment has been applied and has been given by this honorable court, my lord. The petitioner, where the PWD has submitted, there is no problem for taking the segregate of the work. In my cases, why does discrimination has been happened, my lord?
Mr. Counsel, these are different cases, these are different issues. Out here, the petitioner was the lowest, but the work had been allotted to respondent number 5.
Right.
They had already completed a portion of the contract work. Now, the issue was what to do with the remaining portion of the work. In your case,
My lord.
though you were given letter of acceptance, that has been cancelled.
My lord.
So you are not given any contract work with that.
Yes,
You are on a different footing.
no, my lord. I am just playing with my lord. For regarding the measurement of the executed work, that is my
Where
case,
is the
my lord.
question? Why should you work? When they have not asked you to work, why did you work?
That is a pressure of the department, my lord.
What pressure of
There is
that
certain-
is your pressure of, that is because you want the money.
No, no, my lord.
don't want
Without
the
the
money,
formation
then-
of the contract, without the signing of the agreement, it cannot be uploaded in the OMAS system and money cannot be
Correct.
released, my
So
lord.
where is this? Where is your signature in the agreement?
That is not done in the case of the Jiaur Pasa also, my
That
lord.
is why, that's why, when there is no agreement, when there is no document in your favor to do the contract work, why did you do it for free?
I can understand, my lord. That is, I have done the mistake, but it doesn't mean that I should not get that my legitimate right, my lord.
No legitimate right.
I have whatever I have already executed.
That will be
They
an
have
illegitimate right.
I have just showing you the records, my lord. They have
No legitimate right.
admitted the measurement also, my lord, in presence of the executive,
Who,
my lord.
who
The
admitted?
executive of the PWD, my lord, under this division.
You take money from him then. He's not, you take money from him. You tell him, you gave me this measurement, you give me money, tell him.
This is the
You
measurement.
go,
my lord.
you go attach his car and whatever, his salary, you take. How can he bind the government?
I can understand, my lord, but then
Pursuant to the
but
order
regarding the
passed in
deduction of
particular
the,
petition,
Huh?
this verification was made pursuant to direction of the honorable court in this particular case. It's not an admitted one. There was a direction and my lord, bypassing the chief engineer, the executive engineer, my lord, along with the petitioner.
They went
he-
at it.
Yes, in fact, I
no,
was
no,
at
they-
the time the
they-
matter was
no,
called up.
no, my
Yes,
lord.
copy
There
was
is
handed over.
He
order.
did all this work.
Yeah.
No, I
they-
can't say, my lord, that instruction is still awaited from the executive engineer. He has
On the
never,
I
Why
just
does
wanted to
any
add one more thing, my lord, for regarding the
He is
pretext of
holding
the pretext of the instruction, my learned friend has already been past five months, my lord. And their contact is remaining only for.
I wish we had contractors like you in our state. We would have free roads everywhere.
But anyway, this is my only submission, my lord. Till the matter is heard, the contractor will complete the contract and my payment will be is nowhere, my lord. And if you tell me, my lord, then where should I guess? Where shall I go, my lord? Where should I go to and assess, my lord? If what the works has been completed, I have completed.
No
the
one
work
asked you
and
to do the work in the first place.
The contract executive engineer, my lord, executive
point
engineer
here?
is of chief engineer, and some political pressure is also there, which I don't want to disclose in this open court, my lord.
Unless you disclose in this open court, this court cannot help you.
My lord, actually some political pressure is there. There's what has been allotted to such a personal assistant of a very renowned politician's personal assistant's names. I can produce the copy of the same, which has already been the matter of record in 6006 of 2023 petition, my lord. This is still,
Unfortunately, Mr. Council, we cannot go into those. Those are not even, they're not even, those are not even part of your pleadings.
no, that's why I don't want to disclose, my lord. But regarding, my lord, the verification has been done, joint measurement was done at the order, by the order of the honorable court, my lord.
Where is the order of this court?
I can put it.
Is there? 11, 12, I think. Eleven, 12.
Page 410, 4th October. Is it? 8, 12.
And regarding on the last order, my lord, regarding the post, this order has already been mentioned. That regarding whatever I have already done in the measurement,
Sorry,
they have
11,
already agreed, my lord.
11, 12.
11, 12.
Yes.
They have already agreed, my lord. And this is a part of the order. But contractor, whatever the contractor has already taken the amount, he has not done the work, my lord. That is, I have done the work, my lord. I have executed the work and he has taken the payment, my lord.
Is this pavement work or only earthwork?
This road construction work.
Otherwise, it's
Only
artwork.
Only earthwork. That means only
I have
earthwork.
done the.
This does not show that there is pavement work.
No, my
You have
lord.
only put, I think, water-bound macadam, that's all.
The body of the measurement sheet is there, my lord. There is a WBM. I have done the second.
WPM is water-bound macadam, that's all.
What happened become them? If the artworks and pavement works is already complete. The signage wise measurement also there.
Where is the pavement work? There is no pavement work.
Upon side, the body of the.
But the photograph doesn't say that, so.
Photographs, we have done the only to really take the evidence for it. We have concluded the measurement on the order of the honorable court. That's why we have taken this photograph of the some portion of the works, my lord. Not for the entire portion of the works, my lord.
But there should be something showing that you have done, they put that Alcatraz. It's not there.
And I'm not doing that between us concrete work, my lord. I have done the WPM and artwork, which is duly admitted by them, my lord. And in the
How can we allow you your prayer?
my lord, otherwise,
How come this has been done? I don't know.
And
My
Para
lord-
6, we have filed the affidavit, we have already disputed it.
Okay, you have disputed this.
Yes, by respondent number two, chief engineer.
no, my lord. On the last order, on 22nd 12, he has submitted.
But how much, what is the length of your work you have done?
There is certain portion of the works
What is the length?
near about, you can say, my lord, 4 to 5 kilometers. 4 to 5 kilometers of the entire length of the work. There is some sketches of the work.
4 to 5 kilometers.
Kilometers. That is WBM first layer and the second layer has been completed. GSB has been completed. And my lord, whatever my learned friend has submitted, now he is,
And did the PWD write it in the measurement book, in the MB book? In the MB book, is it recorded?
you can treat it this as
No,
like
that
it
was
my
on
lord.
the basis of the court order. No,
Uh-huh.
I'm talking about normally. Was
No,
there any?
no, my lord.
No.
Because the formation was contract was not done.
Then
That's why they have not done the MB
if
book.
MB book has not been applied, has not been acted upon, has not been used, where is your claim? Where is your right?
In the Jiaur Prasad case, my lord, same thing was happened, my lord. Same case has been happened. And whatever my learned friend has submitted, that is the dispute question. On the last date of submission, he has made clear. It is the last page of the order. He cleared that whatever the patches of the work has been completed on my part,
he has to take the instruction of the department. On the pretext of the instruction, my lord,
You
5
you
months
see,
has already been done, my lord.
you
What
go
will him
and
do?
talk, you talk to them privately. Like you've got those powerful friends, politicians. You talk to them secretly, and do it through that channel.
My lord, in
This
outside
channel
of the
cannot-
court, my learned friend is not willing to talk with me. How could I ask, my lord? This is the main thing, my lord. I want to settle it, but regarding it has been denied. That's why I approached the appropriate court. honorable court, my lord.
You're not telling everything to the court, so how can that's why you have to go through your own channel. This channel won't work.
My lord, if for common man, if there's certain things which I cannot disclose, my lord. I have been
No,
denied.
for
my
a
lord.
person who does 4-5 kilometers of work, he is not a very common man. That also without any agreement, nothing.
1.98 crores, my lord.
Yeah, 1.9 crore free, just like that.
1.98 crores, I have executed my.
And in broad daylight,
As per
not
the
chupke
bill
chupke or
submitted-
something like that.
as per the bill submitted in the petition number, I have already annexed the bill, my lord, because they have denied it. Copies were even page number 80, my lord, of the writ petition, which I have already annexed, my lord. Where I will go, my lord, because neither they were not giving the works to me. In some other works also, my lord, I have been denied to get the works to the tune of 460 crores, which has always been a matter of record, my lord, due to certain arbitrariness of the circular. That's why I am not telling you, my lord. But where I have done the executed works, my lord, that should I get, my lord.
Who told you to do the works?
I don't, my lord.
Who told you to do the work?
There is a concern executive as well as the concern.
Now,
authority, my
now
lord.
supposing there are 7 contractors and for a project, and before signing any agreement with the either of the 7 contractors, those 7 contractors start doing the work, then what to do?
Here I'm just at my one thing, my lord. Like yesterday, Honorable Chief Minister has inaugurated the flyover in Cycle Factory, my lord. That is 376 crores. The tender agreement has not yet been assigned, my lord. On the
I don't know that. I don't know.
on the verbal mutual understanding, we did the work, my lord. We have to do the work with a conscious and with a mutual understanding with the department, my lord. So many not less than 5,000 crores or more than that amount has been as of now running, my lord, without the issuance of the formal work order. my lord.
Okay, I think I've heard you. Okay. Now let me hear the other side.
Madam.
Okay. Now just show me one by one all the documents.
Madam.
We'll dispose of this matter once and for all.
Page 25 is the my lord, letter of acceptance.
Just a minute. Page 25.
Letter of acceptance.
No, show me the NIT.
That NIT at page 21.
Page 21, NIT.
Lot 7. It is dated 21/5/2023.
21/5/22 then.
And these are page 22 is the various packages.
22 is the various, and then he got which one?
Yes, well, this package number 260. My lord, number serial number 2.
Okay.
Page 22, serial number 2, Morigaon.
Okay.
Package number AS 1726.
So what is the performance guarantee payable here?
That lordship will find at page 25.
Page 25.
Second para.
Page 25, second para.
You are hereby requested to furnish performance security for an amount of rupees 45 lakhs only and additional performance security of 2 crores 12 lakhs 29,000 for quoting 17.86% below the estimated construction work as per ITB.
So they are scared that he might not be able to perform.
So there is a clause already we can demand it.
Okay. So there's a clause for, where is the clause? Just show me that.
That is not part of the petition, but it has been mentioned in the judgment matter. I didn't want that.
Okay, anyway, leave it aside. Then next.
Now, my lord, thereafter, my
No,
lord,
page 25 is the letter of acceptance.
yes. Page 25, letter of acceptance.
6-8.
6-8.
Then
Now, my lord, challenging this particular letter of acceptance, the petitioner approached his honorable court by WPC number, my lord, 5301 of 2022.
5294.
5301.
Page 27 is 5294.
Page 34. There is a series, my lord. 4 cases were there. He was L1 in 4 items.
Oh,
He
okay.
challenged all.
But this matter is with regard
Yes,
to.
my lord. 5301 2022. Lords will find that at page 34 is the part of the judgment. Lords will see the package number herein. It is AS 17260, which is related to the present case. Page 34. The application number is there.
Correct.
So additional performance guarantees some my lord 2 crores 12 lakhs 59 is mentioned. So challenging this my lord the petitioner my lord.
Then where is the, so where is the relevant portion?
Yes, my lord. Lords will find that at page my lord 43.
43.
Yes.
Where does it say that additional performance guarantee can be asked for?
Yes, madam. That Lords will have to see from the RFP. No, that is not part of the.
No, it is here at page 13, page 37.
37.
Para 13.
13 is mentioned, but that.
Clause 26(3).
Yes.
Empowers the authority to demand for additional performance security. Then next, DB.
Yes. Sir. At page 49.
Rate appeal number.
Appeal number, my lord.
86 of 2023 is page number 49, my lord.
86 of 2023. It is page 51. 56. WA 86 of 2023. Page 51. This number is there.
Yes.
4 is the appeals by the last
Yes,
one.
so 86.
Yes, 56.
Okay, then.
Then finally, my lord, page 58.
Okay, dismissed. Then.
It was affirmed.
Then,
my lord, the petitioner again approaches honorable court.
For what?
He submitted a representation that, my lord, there are certain bills pending, my lord, which is to be paid to him. So that should be adjusted to that particular, my lord, pending bills. That additional security. We have rejected it by a speaking order. Thereafter, we have gone for a fresh tender.
Okay,
He again
okay.
approached.
No, so page 59
Yes.
is WPC. Which one is it?
1057, my lord. 1057, 2023, my lord.
1057.
Yes, my lord.
1057 of 2023. That the pending bills
Yes,
should be adjusted against the.
Yes, sir.
Pending bill as well as some forest royalty amount is
And
also there, my lord.
forest royalty amount.
Forest royalty amount, which can be, I have also requested them, my lord, but they have denied. But in other contractors, they have agreed, my lord,
Forest royalty amount
as well as the some receivable amount. Which
should be adjusted.
shall be adjusted in regard to the additional performance of this particular project, my lord,
Against additional performance guarantee,
as the additional
Yes.
performance security, my lord.
security.
Then
what is the court say?
Page 71.
It's 70.
It is WPC minus 1725 of 2023.
I just, my lord, in WPC 1725, my lord, you can find out that.
So writ petitions closed as not pressed.
Yes.
No,
Page
my lord.
71.
Huh?
Page 71.
I'm just
Out of
clarifying,
4
my
in
lord.
petition, 3 he said that I am not pressing.
Ah.
So those were.
Court works toward there, my
So
lord.
the case that we have,
This remains in WP, it was considered in WPC 1725 of 20.
he said 1057.
There is
No,
a
that
one
is
for regarding the
That's
adjustment of
different,
the
that's a different thing.
My lord,
Just a minute, please do not confuse.
Page
Sure.
71, Lord, you may see, my lord,
1725 is the one that is involved
related
in
to
this
this particular
package.
package.
So out there
For
again,
confirmation, page 73, Lordship may kindly see the second para, last third line of the judgment.
page
page
73,
73.
yes.
The third para, last third line, package number is 17 to 60. It's very clear.
Yes.
So here, my lord, finally, honorable court said the reconsideration directed to be made may be done expeditiously and preferably within a period of 10 days from today. It is further directed that till such decision is arrived at and communicated, no steps should be taken in the process of retendering of the job in question. Then lordship will find at page 75.
No, just a minute. Where is the cancellation of his letter of acceptance?
That lordship will find at page 75. The speaking order has been finally issued.
No, page 73 says what?
Here,
Actually, that was rejected. His offer was rejected.
offer was rejected, and my lord, we have passed a speaking order in this regard.
Page 75.
75. This is a speaking order. Lordship will see the date 10/4/2023. And serial number 3 reference is the value WPC 1725 of 23, as well as other orders.
Huh?
The order passed in 1725 has been taken into consideration while passing this particular speaking order. Serial number 3.
So what does it say then?
Lordship will find at page 76. Order, in view of the above findings, the department is not in a position to accept PS, that is the performance security, and additional PS from the bidder, Rana Construction, that is the petitioner. At this moment, and the department is not in a position to award the work of package number so and so to the firm. So we finally cancelled it.
But there is no specific sentence to the effect that the LAC has been.
So we said we are
Cancel.
not in a position, considering the court's order, we have passed this order. Automatically, my package number has been mentioned.
My lord, please allow me to say two things, my lord. In this speaking order, my lord.
Just a minute. Yes, then.
Now, my lord, page 77, the speaking order has been put to challenge in WPC 2146 of 2023. At page 78, lordship will see in the second line, the order date is there, 10/4/2023. There is a speaking order. And this is pending, my lord.
This is pending.
This is pending. So now, my lord, this tender work of this particular package is over, my lord, it has been allotted to a third party. He is now presently continuing with the work. So that particular portion that the petitioner claims that he has executed.
No, so he's challenging the speaking order.
No.
Correct.
My lord.
Now, and this writ petition is what?
No, he wants the balance, payment of the balance part of the work that he has completed. Without the,
So has he been given any money by you all?
no,
No.
lordship will see page 18, the prayer.
Page 18.
Page 18. A writ in the nature of mandamus shall not be issued directing the respondent number 2 and 3 to make payment against the bill submitted by the petitioner on 18/7/23 against the work carried out so far in so and so. Package number is 260, it is there. So this is a claim made in this particular. The speaking order is under is pending. The new work that we have allotted, he preferred a BIL mallet. That also, the honorable court said that court will impose penalty. Heavy cost that was withdrawn.
That has been withdrawn now.
So that,
this
so
submission
that,
will not
so the
suffice.
challenge to the speaking order and this case will have to be tagged.
Otherwise, lordship warrant can be.
Otherwise, if we dispose of this matter without disposing that, then it can cause a problem.
Then both may come together and the property is considered.
Yes, what were you trying to say?
My lord, I'm just submitting just my last submission, my lord. Please come to page number, just for a moment, my lord.
Yes, I've given you enough
71,
time.
my lord.
Huh?
71. That you have, actually, my lord, that there are earlier 4 works was in question, my lord. Where I have already requested the department to adjust of all my receivable amount to those that has been denied by the department. For that reason, I have filed I am asking about only 1 works, which has been clearly written in the judgment, my lord. Please come to page number 73, my lord, for a moment. Pair number 6, my lord. This has already been recorded in the judgment, my lord. That I have already been completed, my lord, 10% of the executed works. In peculiar circumstances and an exceptional case, the court has directed authority in question, namely Stephen Public Works Department, to reconsider the offer made by the petitioner regarding his willingness to pay the entire amount of the additional security deposit for the work in
That is
question.
absolutely at the discretion of the employer, the PWD.
I'm coming to
Because the court has already passed the judgment to that effect. Now we cannot revisit the order passed by this court unless there is a application for review.
Right.
Or you go to the Supreme Court, that's all, nothing else.
But
Now,
regarding
Mr. Counsel, it's a waste of time. What I'll do is I'll pass the order. I'll tag it with the other case.
Yes.
So that at least I'll put it in order,
My lord.
so that we won't have to waste so much time again. Heard the petitioner in person, who is the director of the petitioner company. Full stop. Mr. B. Gogoi appears for the PWD, while Ms. R. Devi, CGC, appears for the respondents number 4 and 5. Okay, right. The petitioner's grievance is that despite having completed 10% of the work in terms of the NIT dated 21/5/22 issued by the Chief Engineer PWD Border Roads, Assam, the petitioner has not been paid his pending bills amounting to rupees 1,98,11,912. The facts of the case, as can be culled out from the pleadings herein, is that the petitioner had taken part in the short NIT dated 21/5/22 pertaining to package number AS 17-26-0. For constructing road length of 22.65 km in Moregaon district, the road name being T05-Dimaruguri Kamarpur Road. That is at page 22, serial number 2. Stop. Next. The petitioner, being the lowest bidder for the said contract work, he was offered a letter of acceptance dated 6/8/22 by the CEPWD. Full stop. However, he was requested to furnish performance security for an amount of rupees 445,98,000 and additional performance security of rupees 2,12,29,000 for quoting 17.86% below the estimated construction cost. Next para. The petitioner being aggrieved by having been requested to furnish additional performance security of rupees 2,12,29,000 file WPC number 5301/22 challenging the said condition for submission of additional performance security. This court dismissed WPC 5301/2022. While order dated 7/2/2023. Full stop. Being aggrieved, the petitioner filed an appeal which was registered as WA 86 of 2026. The same was also dismissed by the division bench of this court, while order dated
20th of March.
20/03/2023. Full stop. The next paragraph. The petitioner, in the meantime, in the absence of any contract agreement, in the absence of any contract agreement signed between the parties, file WPC number 1725/2023. Saying that his pending bills for constructing 10% of the roads in pertaining to package number
In 17260, my lord.
AS 17260. Should be adjusted against the additional performance security that had been requested from him by the authorities. Full stop. This court disposed of WPC 1725/2023 by order dated 27/3/23 by directing the respondents to reconsider the case of the petitioner. Correct? To reconsider the case of the petitioner.
Yes, yes.
For adjusting
Yes.
the work done by him, the 10% work done, for adjusting the bills for the 10% work done by him.
No, my lord. Pending for other works, not my lord, this particular portion of the work.
Okay,
For other works, there are some pending bill.
okay,
So that should be
for
adjusted, not
adjusting, petitioner in respect of other contract.
Yes. And the petition number is also wrongly mentioned, my lord. That is 1057, my lord.
That's what he says, 1057. You are saying 1725.
1725, lordship, it is mentioned, my lord, for package number, page 170, or page 73. It is 1725.
1057 for regarding the adjustment of the.
No, the writ petition is 1725.
It is 1725, so reconsider, my lord. It's already there.
1725.
And regarding the adjustment of the securities, my lord, like whatever you were saying, that is, my lord, in regard to the petition number 1057, my lord.
1057.
1057, my lord.
How does it matter? It's for some other contract work. It's not with regard to.
No, that is in regard to this page, this particular package, my lord.
1057 is
Yes, my lord.
pertaining to this package.
The particular for this package, my lord. 1057 for regarding, I have filed.
But 1057 is not with regard to NIT 21/5/22.
No, that is in regard to this NIT, my lord. That's why I'm just clarifying, my lord.
No, lordship may kindly see page 70, for a moment, yes, I will clarify that part.
Yes,
Page 68, for a moment, man.
page 68, yes.
Yes, lordship will see, my lord, the main lead case is 1052.
Yes.
1057 is at page 69.
105,
7.
yes,
69 link case, and
Yes.
lordship will see the order 27/3/23. In view of the order passed in WPC 172523, filed in the same, filed by the same petitioner, so and so the.
He would not
Yes,
touch this.
so it was closed.
Those are closed.
1725, it was directed to be reconsidered.
Ah,
1725.
In 1725 with regard to this package. Correct. So whatever I said. Please do not confuse. Mr. Naidu.
Okay, my lord.
Again, I back to square one. My hair had enough hair will all burned. I mean, turned curly by now. Anyway, what was it? As per other works, for payment of the additional performance security pertaining to package number AS 17260. Next para. Next para, subsequent to consequent to the order dated 27/3/23 passed in WPC 1725/2023, the CEPWD Border Roads issued speaking order dated 10/4/2023, stating that the petitioner was not entitled to start physical execution of the work without receiving any notice to proceed with the work. Goes down. It accordingly ordered that the department was not in a position to accept the performance security and additional performance security from the petitioner, and that the department was not in a position to award the works under package number AS 17260 to the petition. Full stop. Next para. बाद में. Now, what is this other writ petition 2146?
Well, regarding the speaking order that has been passed, it has been put to the
To challenge, okay, that was rejected.
2146.
Asha, next para. The petitioner being aggrieved with the speaking order dated 10/4/2023 passed by the CEPWD Border Roads, the petitioner put to challenge the speaking order in WPC 2146/2023, which is still pending before this court. Full stop. Next, in the present writ petition, the petitioner has prayed for payment of the pending bills he has submitted to the PWD with respect of 10% of the roads. 10% of the road he has alleged to have constructed in relation to package number, that package number AS 17260. Despite no contract agreement being signed between the petitioner and the respondents, and no work order being issued to him. Full stop. Next para. On considering the fact that the challenge to the speaking order is still pending before this court in WPC 2146/2023, this court is of the view that both the petitions would have to be decided together. First of accordingly, tag this matter along with WPC 2146/2023 on which date? When? Next week?
Yes.
We have time. Did you say, when, give a date, when nearby, when?
19, my lord. On 19, the other matter has been fixed on 19.
No, with you, one set is enough for once. 12, 12, 12, 12, okay, 12, 12. I think we've got anyway, 12, 12. Registry to detach this case, the WPC 4982 of 2023 from WPC 756723 and 756823.
Slight correction, my lord. So far as the, my lord, claim for adjustment is concerned, that was in, my lord, WP 1057. There he said that he will not press. This, my lord, WPC 1725, there he said that for this package number 4, that is 260, he is now going to pay entire, my lord.
I know, that's what he said.
Yes.
From the other bills that he is going to get from other contracts.
No. But that part, that prayer, my lord, he has abandoned, my lord, said that I will not press the writ petition. The 1725 is writ petition, in the meantime, he filed. He stated that I am going to pay the entire amount.
Okay, from where he doesn't say.
Yes, sir. That part also
Okay.
kindly.
Okay, from where he doesn't say,
Yes.
not from the other contracts. So that we will clarify later.
Yes, Lord,
You
we
will-
find it at page 72.
Anyway, we'll do it, because there's so many
Yes,
issues. At least now there's a sequence.
yes, now it is.
There's sequence. Now we'll take it up next.
I'm obliged.
Highly obliged, my lord. My lord, in this case, I think my friend needs some time. But only thing, my lord, the last part of the order, earlier order, would your lordship be pleased to see, my lord?
Huh.
The pendency shall not be a bar for.
Yes, but
My lord, this is annexure 15 and 15A. Only that part only we should. There are two bills, my lord, 15 and 15A.
anyway, what to do? No time. What do you want?
Unless the final accounting is ongoing, madam, we need some time. 3
When?
weeks time. 3 weeks time, madam.
Final accounting with regard to what?
With regard to page 89, madam, bottom of page 89. Where it says, madam, the certain amount the petitioner alleges to be admitted.
Admitted amount.
Or the fine, it will be subject to whatever receivables the APDCLs have to get from the petitioner, madam. So that accounting is ongoing.
Okay, right, Mr.
Each or 3, madam.
B. Chaudhary and Standing Council APDCL submits that the accounting process is on. And the amount payable to the petitioner as commission would be made known within
3 weeks.
3 weeks.
Commission, etc., my lord.
Commission, etc.
My lord, pendency shall not be bar on the respondent.
That is already there.
No, 15A is missing. Two bills are there, 15 and 15A.
Okay. List the matter after 3 weeks. Pendency shall not be a bar for accepting the claim of the petitioner, which has been said to have been tendered by documents annexed as annexure 15 and 15A to the writ petition.
Deeply obliged. Thank you.
Yes, madam.
Lordship, notice has been served as per earlier order.
Did you participate in the new tender?
Lordship, kindly fix the next date. Let the argument come.
There's a new tender issue, correct? Did
Yes,
they participate?
Lordship, I participated, yes.
Oh, you participated in the new tender?
Yes, no, not in a new tender, but in the earlier tender, which
The new tender, they are getting.
some stay.
Huh?
No. No, let the argument.
There is
also
no
come.
stay,
Let the
madam. There
argument
is no stay. The issue was that you were allowed to participate in the subsequent tender. Have you participated?
Lordship, kindly fix the next date.
That is your case. Yes, what is to be done?
Participated, there is no case. I have.
Okay, right. What is your name?
A. Hussain.
Miss A. Hussain, appearing on behalf of, your Wakalatnama is there.
Yes, Your Lordship.
Miss A. Hussain, learned counsel for the petitioner, shall obtain instructions as to whether the petitioner has participated in the NIT dated 30/12/23. This is the matter after 2 weeks. 1 week
Any date.
or 2 weeks.
51 to 53.
That, I think that,
Yes.
experience loss, whether the distributor, yes, your distributors, are they having any
Yes, in fact, for 6591, which is the last writ petition, Your Lordship.
Yes.
Yes. The authorized distributor of the petitioner therein, MD Biopol, has participated and they're technically qualified as well, Your Lordship. I have instructions from the client.
Lordship, that's they are in the technical evaluation.
Huh?
Yeah, technical evaluation.
Technical evaluation.
Correct. So can you understand the irony of it? The manufacturer is not allowed to participate because he doesn't have that certificate. But his distributor is allowed to participate
No,
because of the
No,
experience certificate.
Lordship, MD Biopol is the manufacturer, Lordship.
MD Biopol. So what happens, Your Lordship, in this in tender, there are three classes of bidders were classified.
Huh.
One was a manufacturer, the other is a distributor,
Huh.
and then there are importers.
Huh.
So the manufacturer's prime work is to only manufacture the product,
Correct.
and thereafter it is not.
He gives it to his
It is not in
distributor.
the court of the manufacturer to ensure as to whether it goes to a private entity or a government entity. There was no clause which required a government sale undertaking or any sale undertaking prior to when the NIT was issued. Thereafter, by way of a corrigendum, the requirement of a government sale certificate was put in place. That incorporation was based on the standard bidding document, which did not have a clause for government certificate, but merely a supply certificate. We have supply certificate that is needed. But the fact of the matter remains that the government, the requirement of having a government sale undertaking a certificate, that word government, Your Lordship, that we do not possess. And our rationale is the fact that we, being manufacturers, we sell it to retailers and distributors who eventually.
So what is your name? The manufacturer.
I'm in three writ petitions, Your Lordship. 6588 and 6589 is for Prabhat Fertilizers, and 6591 is for MD Biopol.
So MD Biopol is a manufacturer?
Yes, it's a manufacturer.
Then-
MD Biopol is a
So
manufacturer.
MD Biopol has that certificate.
No, MD
doesn't-
Biopol's dealer
Dealer has a
has
certificate.
participated separately as well,
Okay.
and
That's
they
what-
have
that's
also
what I'm
been technically
saying.
qualified. Yes,
So MD Biopol might not have that certificate. His dealer, his distributor has got a
Yes.
certificate.
that is based on our.
Lordship, in the NIT, it has been stated that experience in similar nature within the particular 5 years period.
Correct.
Lordship,
So it's like this. If my agent has got the experience certificate, why is the principal, how can the principal be barred?
Lordship, both cannot participate.
Why not?
No, they're not the same entities. What has happened is they are authorized dealers. So MD Biopol, the petitioner in a writ petition, the third writ petition, is a separate entity, and they have been dealing through Tech Business, who is a separate entity altogether, who is also participated as a dealer, not as a manufacturer, and they've made the cut. And in fact, if Your Lordship sees the
No,
instructions.
that's what I'm saying.
Yes, yes.
So the Biocol is a
He's
manufacturer.
a manufacturer. So he is a
His distributor, his dealer
yes,
can participate because he has got that experience
yes,
certificate.
yes. And then
Only thing is that the manufacturer doesn't have that,
Yes,
that certificate.
because my first
So, but
line of
then,
production
when
goes
the,
by-
when the,
He
when
wants
the,
to participate on his own, the
Correct.
petitioner.
so what is
And
wrong?
Lordship, that experience is it's a essential condition, and that was based on the pre-bid meeting suggestion and everything in terms of the NIT Lordship.
But
Where the
but
petitioner never participated.
Huh?
In the pre-bid meeting.
that is-
you have not called him.
No, it's all have been called in, but he never participated.
How can he participate when he's not allowed to participate?
No, Lordship, pre-bid meeting, Lordship, one can participate after after the interim order, they have submitted their bid, and subsequently, Lordship, the pre-bid meeting was held.
after filing of the writ petition, when that corrigendum was incorporated, there was a pre-bid meeting held prior to that corrigendum, and that aspect of inclusion of government certificate was not addressed. And that is not our case. Our case is that you have created three separate exclusive class of bidders. Me being a manufacturer, my primary first level of response goes to a dealer or a distributor. Whether it's a government entity or not, that distribution is taken care of by another entity which operates at an intermediate level. That is my entire submission. I am a manufacturer, and what you have done is that by incorporation of the entire clause, you have completely ousted me. Now you have
Yes, there's no time now.
there's no time.
Lordship, may take it up on Monday because urgency is there.
There's a stay order, no?
Yes.
Stay order there.
There's no-
Lordship, but subsequently modified, allowing only the items against which the petitioners have.
Correct,
filed a
correct,
writ.
correct,
That has
correct.
been,
subsequently modified.
So interim order as modified will continue.
Lordship may take it up on Monday, urgency is there, Lordship. No, because the sowing season will end, Lordship.
Huh? Okay, Monday. Okay, I got. Okay, right. On the prayer, the parties leaves the matter on Monday. In the modified interim order shall continue till the next day. The interim order as modified shall continue till the next day.
Lordship will,
Huh?
will make a mention for upgradation, if Lordship.
That's the only issue that.
That's a small issue,
Yes,
basically.
that is.
Only you just give me some citations if you have. I don't think you'll have, but if you have.
I have Lordship, side.
Do you have?
Yes, bottling few.
But don't, how much?
3 case laws, Your Lordship.
My
Your
God.
Lordship is aware of those case laws, Your Lordship. Refers to those matters.
No, it shouldn't be too thick.
Ancillary and essential
Oh,
conditions of
those,
the contract here, those.
Gigi Fernandez
Yes,
and all.
Yes, yes, so demarcated between that, whether it's essential for a manufacturer or not, that will be our submission.
Okay, okay. Let it come to me. In the chamber. Let it come to. Actually, you give it to me. That's give it to me. Monday.
Monday, I'm grateful.
Why is it so? It's so urgent. Monday.
It's not urgent for me, it's urgent for my.
Urgent in the sense because the, for the, crops for which these, items are required, it can be sold only from mid-February till March. Lordship,
Oh.
thereafter, it will.
Okay.
be
Okay.
The
not
order
possible.
protects me, but.
And the, Lordship, the central fund will also, go back.
Lapse.
Yeah, that's Lordship. That's the issue.
But basically, is the
So-
lapsing of the fund, not the. No one's really worried about the season. Yeah. Okay. Where is this? Prabhat Patel technical?
In this
Yes.
matter, government was required to submit certain documents. On the last order dated 29/1. So far the interim order is concerned. So, let the probably here is a case where lordships may have to consider certain other aspects involved. There's no time, lordship may fix another date so that let them also come. Well, other friend is also other side not there.
Okay, when do we do some, where?
Malad, lordship may fix a date, Malad.
All right, Mr. KK Manta appears for the petitioner. No one appears for the respondents. Leaves the matter. Give a date. After 10 days or so.
That take not to. But a little later, Malad.
Okay, give a date.
Little later. 23. Interim order shall continue.
Huh?
Interim order shall continue.
Interim order continue
All right.
till the next date. Item? 54. Okay, okay. Okay. Yes,
In this case, my lord, our Fairfax places are suspended, my lord.
for,
Since my lord,
9/10/23.
yes, my lord.
Yes,
Lordship, I have received instruction about Lordship's direction, Lordship. My lord, paragraph 2 and 3, Lordship.
yes. Okay, so the,
So lordship may take with this with petition lordship because same cause of action lordship.
what time with which case?
Lordship on lordship, WPC lordship 6053 lordship.
This is with regard to what?
My
Same-
lord, that is in regard to, my lord, the
See-
propriety of the Caesar.
Caesar is
challenging it,
lordship,
my lord.
Caesar is in
It is
respect
done
of,
in violation of the, my lord, the law.
Caesar is lordship in respect of misappropriation lordship. See,
You have to satisfy my lord.
lordship. SAS and Caesar is the same cause of action lordship. In that particular case, honorable court directed us to restrain to take any further action. So everything is complete lordship.
Oh,
Everything is complete lordship. Even inquiry is completed as per lordship's directions, everything we have completed, but we have to pass the final order. Either
but,
we have,
but because of that order,
because
you,
of that, either we have to revoke it or cancel it lordship.
My lord, in this case, in this petition, my lord.
Otherwise, suspension is also lordship, suspension and so forth is the same lordship. And same date suspension is issued.
so basically,
My lord,
the thing is that your license is going to be cancelled.
my lord, in this case, my lord, what I challenge the propriety of the inquiry proceeding in
Correct.
this case. my
No. Out here, what you have challenged is whether a suspension can go beyond 90 days.
My lord, beyond that, the issue in this writ petition, my lord, what is happened, I just in a brief, my lord, I am just narrating your lordship. In this case, my lord, after suspension, show cause notice was issued, I have replied the securities because whatever the action they taken based on a complaint made by some of the consumer before a local MLA. Local MLA forwarded to the deputy commissioner, my lord. That is the basis of initiation of all this proceeding against me. So when the show cause notice was issued, my lord, a preliminary inquiry was conducted. Then a report was submitted. On the basis of that, my suspension order was issued, lordship. Then when the issued a notice to me to reply against the show cause notice, my lord, I prayed for, my lord, the submission of the copy of this complaint.
What we'll do is we will take this case with them.
Lordship, lordship,
We'll
lordship.
take this case.
That will do lordship.
Okay, right. Mr. King over has produced a letter dated 25/1/2024 issued by the SDO bracket civil Lakhipur, which is to the effect that as per the investigation carried out by the executive magistrate, there has been a recommendation for cancellation of the petitioner's license. However, full stop, however, comma, in view of the order passed in WPC 6053/2023, where this court has directed that no coercive action should be taken against the petitioner, comma, the state respondents are unable to pass any definite orders. Full stop. Accordingly, take this matter
Lordship.
along with WPC 6053/2023 after a week.
Lordship.
Let me be.
Lordship, lordship.
Or after whatever it is, but I could get to your lordship. I know, I love you.
Those
Solve the matters. I know, my lord.
so many matters, we
Yes,
don't have time to,
I understand.
if we are going to adjourn, that's a different thing. Let it come, it'll come. Or what?
Otherwise,
Okay, give a date.
or after 17, whatever it is, convenient. That is why I leave it to my lord. I know, but it is so many matters. Oh, yes, lordship. Definitely. Obliged.
In this matter, I need some time, Lordship, because as I have been informed by the wife of the petitioners that they have received some letters from the ATDC regarding deposit of some document for clearance of an amount of around 3,30,000 for that. Lordship. I need 1 week time for
For leave encashment or what?
EPF payment,
EPF?
Lordship.
Okay, right.
Lordship.
On the prayer made by Mr. R.M. Das, Learned Counsel for the petition. Leave this matter after 6 weeks.
Lordship. Lordship.
But it has to come to an end, in this
Lordship,
case.
it will. Lordship. Next day, your Lordship. If-
6 weeks or 4 weeks?
Lordship, 4 weeks.
4 weeks, 4 weeks, 4 weeks.
But I'm appearing for the sole respondent, my lord. On the last occasion also petitioner is absent. Petitioner was absent. The last occasion they were also.
No one appears for the petition on call. No one appears for the petition on call. It is seen that on the last date, 18/10/23, no one appeared for the review petition also. Pusta. As such, it appears that the review petitioner is not interested in pursuing this matter. The petition is accordingly dismissed for non-prosecution. But then they seem to have a case.
Yes. But they are not appearing, my lord. That's why the difficulty.
No, but then one thing, why can't we decide it on the basis of what is there?
That lordship can do, my lord. If lordship
Huh?
says no.
No, because they have a case, I think.
But their case is that, my lord, the council has not admitted the amount.
No. You cannot get beyond 7 lakhs.
No, my lord, there are resolutions by the board. They only want to say that since their financial capacity is not that, they can pay the amount.
Okay.
Only that is.
Okay, carry on. Next,
Well, lordship is dismissed, my lord.
dismissed.
Obliged.
But if they ask for restoration, it's going to be restored.
Obliged.
May it please the lordship, it relates to the non-payment of the contractual bills. It's an admitted amount.
Where? Admitted?
Yes, your lordship.
Huh?
Yeah, Mr. NJ Khatunia was there, my lords, for some personal difficulty, he had left, lordship. Regarding the payment, lordship, the amount is admitted, they have sent for the judicial department for some views, my lords.
What views? If it is an admitted amount, what remains?
Lordship, for financial sanction, lordship.
Oh, that's very good.
So,
Your lordship, finance has already given a concurrence. That was a statement made by the finance department. I don't understand why they are delaying with the matters. This is a 2013 case. The madrasa was closed down, then it was merged with secondary. The director has admitted that the payment is supposed to be made.
Where is the admission?
I'll just come to that, your lordship. If your lordship comes to the page 93 of the petition. That's the affidavit which was filed by them. This is a contempt petition, otherwise, your lordship.
I said this is a contempt.
Yes, your lordship.
Oh.
That was an admitted amount and the honorable court passed a judgment directing them to comply the things within 2
Then
months.
let us another day, because then maybe we'll call them or something, do something. Okay. Right, due to paucity of time, list the matter.
Next week, your lordship, if possible.
List the matter after the week. Next week will be too heavy.
Deeply.
Too heavy, I don't know.
Your lordship, a direction may be issued that by then, let them take.
Contempt is a contempt. I cannot issue any direction in a contempt.
Right.
The only direction I can issue is appear before the court. Go to jail.
Deeply obliged.
May I please, your lordship. Lordship, as per petitioner instruction, kindly withdraw the petition.
You want to withdraw?
Yes, sir.
What is your name, madam?
Miss S. Das on behalf of R. Goswami.
Miss L. Das.
S. Das.
S. Das.
Yes.
Appearing on behalf of
R. Goswami.
Mr. R. Goswami, learned counsel for the petitioner. Submits that she may be allowed to withdraw the writ petition. Mr. K. Gogoi appears for
All the respondents.
all the respondents. The prayer of the petitioner's counsel is allowed. Writ petition is dismissed as withdrawn. No one appears for the petitioner on call. This is the matter after 2 weeks. What do you think about this case?
Hello, so far as the petitioner's challenge, hello, the whole market cannot be washed for the set.
He's not a person who has submit. He's not a tenderer.
No one.
His only case is that the market is encroaching upon his space, his land.
Yes, my lord.
So that is a different issue.
Yes, my lord.
That is a issue with regard to land dispute.
Yes, sir.
But it's nothing to do with settlement of the market. Right. No one appears for the petitioner. So Mr.
U Sharma on behalf of N Bora,
Mr. U Sharma appears on behalf of Mr. N Bora.
MS N Bora,
MS N Bora, Learned Counsel for the
PNRD department.
PNRD department. Full stop. The grievance of the petitioner is that the Uguri Daily Bazaar, OUGURI, Daily Bazaar, is encroaching upon the petitioner's land. It is not the case of the petitioner that the petitioner is a tender for settlement of the market. Full stop. As the dispute pertains to a civil dispute regarding land, the petitioner would have to explain as to whether this court can, whether the petitioner would have to approach the civil court. List the matter when, let's give a date nearby. Right? Okay. Relation.
45.
My lord, here the service is awaited with regard to respondent number 3, my lord. My lord, what happened was that in this matter, my lord, notice was issued on 12th of January, my lord. Here the case of the petitioner, he is the lessee of the Assam Tea Corporation Limited, in which the state government has decided to disburse the tea gardens as a package to different lessees for a period of 30 years. My lord, after taking over the possession, my lord, with regard to item number 45 and 46, my lord, both items, 45, it came to our knowledge that out of the in 45, my lord, what happened was that out of the total land, my lord, 178 bighas of land are encroached by some other persons, and inside the market, around 50% are encroachers, my lord. So what happened was that though we were granted physical possession, we cannot go inside the market. They are encroachers and
It's inside the market.
they inside the tea garden, my lord.
Tea garden,
Tea garden. And around 50% of the land is encroachers, and they are workers of the company, my lord.
They are workers of the
the company. So if we
workers of the
ATCL, of the Deepling Tea State, ATCL is the Assam Tea Corporation Limited.
Okay.
Assam, they have given on lease, my lord. What happened was that we have filed various representations. At least we have filed 5 representations. They were not replying to any of our representations. Out of no options left, we approached this honorable court. We filed a writ petition on 9th. It came before this honorable law 12 January. It was fixed to today, my lord. What happened was that yesterday at around 3 p.m. through mail we got a SOCOS from ATCL to with a SOCOS notice for determination or termination of lease deed. They are not appearing before this honorable court. Since they have a separate set of counsels, but government is to appear for that generally, they are aware of the fact. So this court issued notice, and as the matter was serious, it was fixed at a short time, it was fixed today. Yesterday at 3 p.m., mail was sent to us with a 7 days time with a subject to SOCOS notice for termination of lease grant in respect of Deepling and Rajabari, and we were asked to reply within 7 days. So, my lord, what was that? We have been filing applications to them since 11/9/2023. And the last application was filed till 2nd of January. No communication, no options left. We appeared before this honorable court. So, my lord, they are not appearing, they are not even, no eviction has been done. We cannot go inside the land. Similar dispute with regard to the 46 item. In 46 item, what is that? Out of the total, there are around 2,000 something bighas of land. Out of only 749 bighas were granted to us. We are not even allotted permission to enter to the other bighas of land. And interestingly, of late, we came to know the land are not mutated in their name. The question here arises another thing, how ATCL can grant permission, how can they give a lease to a land in which they don't have even their names also, my lord. So, my lord, here one prayer is that, my lord, we have received this SOCOS yesterday at around 3, and the petitioner resides at Sipsagar. Today morning, though he has come, my lord. So, may I pray that this matter may be taken up on Monday, because we have time till Wednesday. On Monday, we will file an IA
with regard, I am bringing on record this document, my lord.
or additional affidavit.
And my lord, it is my lord, because there will be prayer for stay, so I will be.
Because what is your main, what is your main prayer in the?
Prayer was, my lord, this issue was not on record, or that.
So
main
what,
prayer with
so
regard to
you see,
record.
what we can do is,
Hmm.
you find additional, put it on record,
My lord,
and we dispose of the entire it, saying that your representation should be heard,
yes, my lord,
and that you should give a reply to this also,
yes, my lord,
and everything should be decided,
yes.
and no coercive action should be taken till a final decision is taken.
My lord, if once I can produce this document, it is on record. My lord, if my lord is going in that pattern, my lord can.
I thought maybe that way we'll dispose of the entire thing.
Yes, my lord. And if my lord wants to keep this on record and by oral submission, so my lord, I can give it. Because if my lord is going to dispose of it.
I can take it like this also.
Yes, my lord, general, because it can be kept in the record of the court. In the matter. My lord.
Go. Defaulted but because of those things.
My lord, we have been continuously filing representations after entry. My lord, what is more interesting in item 46, my lord? Total land is 2789 bighas given on lease, my lord, as per the RFP, and only handed possession 759 bighas, my lord. These issues came later on now to avoid this bigger issue, my lord. They have yesterday at around, my lord, may see the date. One there. Yesterday, today the matter is weak. Yesterday they have served us at around 3 through mail, and they have given us only time of 7 days, my lord. Because finally
When did you enter into the land?
Yes, my lord. Yes, because. With regard to item number 45, I was handed letter of handover position 28 March 2023, and my first representation, it started from my lord 11/9/2023.
After how many months? After 6
No,
months?
my lord, lease deed was done on 5/5/2023.
Still after 4 months.
After form, because my lord, we were talking orally, we were in this 30 years lease, my lord. We do not want any disturbance on that fact. We were out of no options, my lord. We have started representations. And thereafter, what they did was, now they want to avoid these issues and everything. And the bigger issue is that they are going to be in problem if it goes in civil way. They don't have the land in their names. Mutations are in process. How can they give lease to a land in which they don't have even their names also, my lord? But we don't want to go on this way. We want the tea gardens. We want to work for the development. The only issue is the representations to be considered. At least an opportunity.
So this letter is with regard to both 45 and
Yes,
46.
my lord, 45 and 46.
The problem is notice was issued
On 12th of January, my lord, and fixing it because.
not even a month,
Yes, and it was fixed today.
but because of this. Thing.
Because they were, yes, my lord, my lord, it was considering the grievance of the issue and the graveyard, it was fixed today.
You file additional affidavit,
My lord, I can.
or you file a application with state,
My lord,
then they will come, I think.
I think so. That I can.
That's better, I think.
Yes, my lord, but my lord has to fix it on Monday because Wednesday, the 7 days will be over. I have no option. They have given it.
Okay, right. Let this, the prayer of the petitioner here is that the petitioner's representation, the petition representations should be decided by the respondent. As the lands that have been given to them under 30-year lease is largely inaccessible. Correct?
Yes, my.
Due to encroachment. Leave the matter on Monday. So both the orders, huh?
My lord. Oblige, my lord.
My lord, I have entered appearance today on behalf of the private respondent number 4, my lord.
Yeah.
I need 10 days time to file affidavit, my lord.
My lord, today was fixed for consideration of the interim order, my lord. The issue is that, my lord, the bid of the petitioner has been improperly rejected and improperly his bid has been accepted, my lord. So on the on last occasion, I prayed for a status quo, so that this honorable court was pleased to observe that, my lord, after serving of notice on the private respondent by way of justice service, the prayer will be considered, my lord. So, my lord, I pray for a status quo order, my lord, because, my lord, the rate of the petitioner has quoted much higher.
Status quo meaning what?
Already I have given, my lord, 26 lakhs bid money I have already given.
Given, but it has not started, my lord.
Already it has been started. If your lordship kindly takes the last order, if your lordship kindly turns to the last order, it is clearly reflected, my lord. The second page, second paragraph, this clearly stated the issue regarding non-submission of undertaking in the prescribed format and also the format under Annexure E has also been raised. It is also submitted that in the meantime on 17/1/2024, the LOA has been issued in favor of the respondent number 4 and the respondent has also deposited the bid value of about 26 lakhs approximately. And thereafter, if your lordship kindly turns to the next last paragraph, it clearly says, the second line, it is however made clear that any action taken would be at the risk and cost of the concerned party.
And prior to that paragraph, there is
Everything is clear.
another aspect is there, my
And
lord.
my lord, my instruction is the allegations as well as the grounds which are taken in this writ petition are incorrect, baseless, and completely misconceived, my lord. So I want to place it on record and lordship can dispose it off finally.
One more aspect is there, my lord. Prior to that paragraph, there is observation by this honorable court that there is one more aspect in this matter with regard to the emergence of a situation of only one bidder. Because, my lord, there were 3 bidders in the technical bid. In the technical bid stage, 2 bidders have been rejected and only 1 remained for the price bid, my lord. So in an auction bid, my lord, when there is a single bidder, that should be go for a fresh tender. On the last occasion, the departmental council was asked to produce the records regarding that also, my lord. Otherwise, also in my petition, also, my lord, I have an
Who is the departmental council?
excise department, my lord.
Who is the council?
The learned
Mr. P.N. Goswami, my lord. And otherwise, also, my lord, that
Anyway, so since he has come now,
yes, my lord.
he has come now, let him file his affidavit.
Let him file, my lord, but
Let him
at
file.
this stage, my lord, status quo as regards. My lord, what I am submitting, if he is saying that he has started, then he will be running.
No,
And
no.
Anyways, it is at my risk and my cost.
When will you file the affidavit?
Within 10 days, my lord. 10
No,
days.
no, 10 days too much.
Yes, my lord.
Within a week. You file it, we'll list it next Friday.
Yes, my lord.
Today is my lord.
Today is Friday.
Today's
We have got tomorrow and the after to.
already.
9 days. And my lord, till then, status.
No. Why
If he
status quo?
has started running, then he
No,
will
no.
continue running, my lord.
There is absolutely no
My
problem.
lord,
This court has not given that.
my lord,
No, nothing has been given.
my lord, it has been stated in last paragraph, my lord. The efforts
And
and
why
prayer would be
status quo, my lord?
considered on
Because
the
without
retardable
records-
date, my lord. Last prayer, my lord.
Your
My lord, last but second paragraph is that 3 for a learned counsel for the petitioner prays for an interim order. Then, my lord, last paragraph, the aforesaid prayer would be considered on the returnable date. So today is fixed
and
for
the next
consideration
paragraph,
of
the records of the decision-making process are also directed to be produced on the next day.
We will list it next Thursday, hearing date. Right. Mr.
A.K. Barwa.
A.K. Barwa.
I am appearing on behalf of the private respondent number
Appears
4.
for the respondent number 4. No one appears. Before that, you write Mr. D.P. Bora appears for the petitioner. No one appears for the excise department. Mr. So appears for the respondent number 4. He is granted. The respondent number 4 shall file their affidavit in a position on or before 8. On or before 8/2/2024. List the matter on it.
Public.
On which date, the excise council shall produce the reports.
Public.
And my lord, this observation that my lord, interim will be considered on that date. On the.
Your lordship will find
If the affidavit of the respondent number 4 is not filed on the said date, And in the event of the excise not producing the records, comma, on the said date, the interim order, the prayer for interim order can be considered on that.
Obliged.
Deeply obliged.
There's some more.
Made to the lordship. My lord, on the last occasion, this court, my lord, on preliminary hearing of the petitioners, my lord, was pleased to issue notice and have also, my lord, directed us to serve ASTI on the private respondent and respondent number 4, my lord, on the ground that, my lord, issue involves some urgency, my lord. So it relates to a tender work which involves, my lord, fixing, my lord, commissioning and installing of, my lord, floodlights in Indo-Bangladesh border.
Now, what is to be done?
Today, my lord, we have taken the ASTI service, my lord, and the respondents have received, and I have filed an affidavit to the effect. Perhaps, my lord, they have entered appearance, my lord, please your lordship, because this tender and everything else was done at Delhi, and jurisdiction was at Delhi. It is specifically mentioned in the NIT allows as a GCC, General Condition for Contract. But I am astonished why this case has been filed at Guwahati, because this entire contract has to be executed at the Mizoram, into Bangladesh border. Then, there is a ABC laminate and other swastik gases. Court has specifically, the Supreme Court said that so far as jurisdiction is concerned, once it is ousted by an agreement, they cannot come to other court. Here also in Guwahati,
Yes, why, what?
my lord, on the last occasion, the point of jurisdiction was issued and we have addressed this point and court was.
You address it now again. You
Yes,
address
and
it
the
now.
notice was issued, my lord.
You address it now.
My lord, notice was issued on.
Maybe I'm saying, I'm dismissing it.
My lord.
You go to the concern, you
My
go to
lord,
Delhi.
the point of jurisdiction lies, my lord, in the fact that, my lord, we have concurrent jurisdiction, this honorable court has. The defendant, that the respondent upon whom the tender is going to be allotted, that is the private respondent number 8, has a local office, he is a local person.
No.
My lord, a cause of action has partially taken part.
How do you know it's going to be given to him?
Yes, ma'am, he's the L1 bidder.
So what?
Yes, my lord.
So what? It doesn't mean that L1 will have to be given.
On the point, my lord, that we have basically assailed the technical qualifications of the two L1 and L2. We have approached this court and as the final work orders have not been issued till date, my lord. No, issued. It is issued. No, are we at?
What order has been issued?
Issued. So let them come by way of an affidavit. File an affidavit. Yes, my lord. Let them come by way of and let them raise this point of maintainability will address, my lord. On next week, we'll file it. My lord. Let them raise this point of maintainability. So far as jurisdiction is concerned, yes, my lord, and the other development. Yes, my lord. We can address.
Okay, Mr. Mr.
A. Thakur.
A. Thakur appears for the
respondent number 1 to 6.
1 to 6. He submits that affidavit will be filed within
2 weeks.
Within 2 weeks. Anybody else appearing? Mr. Patwari appears for fund number 8. Who's for 7?
7, they have not entered appearance. 7, my lord, on the last occasion, my lord, notice was not issued on the light of the fact that, my lord, 8 was the L1 bidder, my lord. So court was pleased to issue.
Stop, right. As per office note dated 30/01/2024. No steps have been taken by the petitioner for service of notice. On the respondent's number. On the respondents. And no steps have been taken by registered post with AD. As well as by usual process.
That we have taken
By the
yesterday, my lord.
petitioner. In terms of the order dated 25/1/2023. Oh, but yes, 1 to 6, 8 are here.
Yes, my lord.
No need.
No, we have already.
But 7. The notice has not been issued to 7.
My 7 on the count, my lord, that he was L2 bidder. So court in the order itself observed that L8 would be important. So first, let the notice to be ended.
And you file the affidavit. Is it necessary? Release the matter after 2 weeks.
Now, may I humbly submit, my lord? We have some urgency, my lord, as my lord has senior
No hurry, Mr. Council, no hurry. No hurry.
because my lord, since work order, as he has submitted that has been issued, my lord. Can it be, can I pray for a date, my lord?
No hurry.